Good morning, everyone, and thank you all for attending this year's Energy Law Symposium. My name is Charlotte Smalley. I am the Symposium editor for our Energy Law Journal here at Texas Tech School of Law. And then Marcus Bramer, who you also see walking around, was Law Review's Symposium editor. And so we have put a lot of work into putting this together for y'all, and we're really excited that you are all here. I want to also give a special thanks to our sponsors, Sims Land Service, for helping us be able to put on this symposium. We could not have done it without their help. Okay. Here is the CLE information. This is the QR code. I believe there's also a QR code sitting at the check-in table that y'all can scan as well. If you are seeking New Mexico CLE, you can email either myself or Marcus, and we will provide you with that certificate of completion so that way you can get that submitted to get your New Mexico credits as well. So to start us off, we have Professor Keffer. He is the advisor for the Energy Law Journal, as well as the Energy Law program in general here at Texas Tech. He graduated from UT in 1984, started in general litigation practice at the Dallas law firm of Weil, Hamilton, Koch, and Knox. He then began specializing in oil field pollution cases, representing various energy companies and various landowners. He joined Texas Tech in 2014. He is the Janet Scavilli and David Copeland Endowed Professor of Energy Law and the director of all of our energy law programs. So I will turn it over him to welcome all of you here.
Well, welcome to our 4th annual Energy Law Symposium that's jointly put on by our two journals, the Texas Tech Law Review and the Journal of the Energy Law Practitioner. And welcome to Texas Tech Law School. Texas Tech Law School is the home of the advocacy program that's ranked #1 in the nation. Texas Tech football is now ranked #7 in the nation, and flour tortillas, I think, are in permanent timeout. So the other thing that is notable about our law school is that we have a very successful energy law program. In fact, I would say that our energy law program offers more to law students than any other law school in the country. You know, the United States is #1 in producing crude oil in the world, #1 in producing natural gas. Texas is the #1 state in the country in production of crude oil and in the production of natural gas, also #1 in wind energy and also #1 in utility scale solar energy. And the Permian Basin in Texas is the reason why the United States is #1 in crude oil and natural gas production, because the Permian Basin is home to about 40% of the nation's crude oil supply. Texas Tech Law School is the law school in closest proximity to the Permian Basin. So it only makes sense that we would have not only an energy law program, but I have focused my efforts since I got here in 2014 in making it the very best in the country. So let me tell you a little bit about the program. The brochure that you saw at the check-in table is the brochure for the Energy Law program. Looks like that. Tells you everything you want to know about what we do here. Those of you who are students, pick one up and find out about what all you can do in the program here at the law school. Those of you who are practitioners, pick up a brochure because it might be interesting to you, but it might be interesting to folks that you know who are looking to apply to the law school and to find out where the best place to go would be for the Energy Law program. To sort of illustrate just how comprehensive the program is, got up here on the next 2 slides, 12 energy law courses we've added to the curriculum since I started in 2014. When I got here, we probably had a couple of courses, oil and gas law, maybe one on natural resources. But since 2014, we have been steadily adding to the course catalog so that now we have 12 courses that are part of the Energy Law program. Oil and Gas Law 1, an advanced course, Oil and Gas Law 2, Oil and Gas Lease Negotiation, Wind and Solar Law, Texas Mineral Titles, a course that is really not taught anywhere anymore, and it's such an important skill set for those of you who run title or litigate cases that arise from people who didn't know how to run title properly. You know how important it is. And Texas Land Titles. We also offer a course in energy law, just kind of a general survey course, one that's specific to energy transactions, energy tax, electricity law, where students learn how to say PUC and ERCOT and what the grid is and how all that comes together. Eminent domain in Texas, and we just added this fall a nuclear energy law course, which apparently is going to be a thing that everyone's going to need to know about in the future. We also have programs that are part of the overall offering here at the law school, just like this symposium today, but we have a couple of different guest speaker series. One is called the Energy Law Lecture Series, which occurs on Mondays in this linear auditorium, where we bring in 3 guest speakers each semester. It's open to the law school generally, but it's also open to main campus. It's open to the public. And so we have people attending from all those different categories. Those of you who aren't physically in Lubbock or aren't able to be at a program on a given day, we offer the Zoom option so that you can remote in and watch that way. It's free of charge. And it also provides 1 hour of CLE credit, Texas, New Mexico, and continuing education credit for landmen with AAPL. The second series is a little more informal. It's called the Nuts and Bolts series. It's on selected Fridays in a room up on the second floor, where we also bring in 3 guest speakers each semester. But the objective in that program is to bring in speakers who do something in the energy law space, and it exposes students to folks who are in that area so that they can get a sense of what kinds of job opportunities might await them after graduation. Like I said, it's more informal. It's attended usually by law students with a particular interest in energy law. Again, people outside the law school can participate and watch by Zoom. There's no CLE credit for that series, but it is always very enlightening. And then, of course, we have programs like today's symposium, generally October. I think one year it ended up being the 1st of November, but it's usually sometime in the mid to late October timeframe. And hopefully you'll have a favorable experience today, and we'll put it on your calendar in future years to not only attend, but also to invite other people to join you. Again, you can attend in person, you can attend by Zoom. We have folks here in the auditorium today, but we have a pretty sizable Zoom audience across the state and in New Mexico. So Zoom is, a pretty popular way to get CLE anymore, especially when you can have 7 hours worth of it, and including 1 hour of ethics like we have today. Just to give you an idea on the lecture series this fall, we had Jim Wright, chairman of the Railroad Commission. We had Charles Weller, who is with the CO2 Coalition, dealing with the current endangerment finding debate that's going on in Washington. And there's one more left this fall that I would encourage you and invite you to attend if you can, either in person or by Zoom, with Shane Walker, who's the director of the Texas Produced Water Consortium, which is actually headquartered here at Texas Tech. It was created by the Texas legislature. It's a program that is designed to accelerate research and development on how to get produced water in a more usable state for beneficial application at an economic price. And so obviously, with kind of an endless source of produced water, it would solve a whole lot of problems if we could figure out how to put that water to use. When you attend the lecture series, like I said, you get 1 hour CLE credit. On the Nuts and Bolts series, give you an idea who has been here this fall. Todd Spake, Tech Law alum, who is in charge of the energy practice at the Kelly Hart law firm in Fort Worth. Anna Griska, another Tech Law alum who's in-house with Woodside Energy in Houston. And then we have one more Nuts and Bolts event on November 7th with Charlie Sarton, who is with Gray Reed in Dallas. And again, no CLE credit for those, but they really are interesting and always bring a lot of information to the students, but to everyone who watches. Field trips. Another feature of the program here is that we get students out of the classroom and into the field. So we have a wind and solar field trip that we do in conjunction with Professor Wetzel's wind and solar law course in the fall, and go down to Sweetwater and get out in the field and look at those things. I take my students in the oil and gas law 1 class every fall and every spring down to Midland. We just did that last week, where we go down and listen to guest speakers about living and working in Midland. We go to the Petroleum Museum, and then we end up going out in the field, typically with Fasken, because they're always drilling a new well, and we can go out there and put hard hats on and tour the rig floor, and students' eyes, get wide because now they're seeing firsthand what they're learning about in the classroom. We have another field trip in the spring in conjunction with Professor Wetzel's mineral titles course. where we go down to Colorado City and Sweetwater, go to Abstract Plant, go to the 2 courthouses, see how they maintain their books for title. And then I do another trip, usually towards the end of the fall and spring semesters, on a Saturday morning, where I take my students out to North Lubbock to look at production operations that are handled by Texland, a company that's based in Fort Worth. Most people come to Texas Tech. Most people live in Lubbock don't know that we have oil and gas production in North Lubbock, and we've had it there for decades. So it's a very convenient way to take students out in the field and show them what production operations look like. I said that one of the co-sponsors of this symposium is the Journal of the Energy Law Practitioner. If you go to that website, ttujelp.org, you will find just an abundance of helpful information. Not only will you find the back issues and the current issue of the journal for free, but you'll also find the list of all the energy law lecture series speakers we've brought to the law school since it started in 2014. That's over 60. They're all accessible. You can click on and watch those videos. You can get your 1-hour CLE by watching those videos, and it covers a whole lot of people and a whole lot of topics. And so it's a great way to have access to that sort of information. It also has a tab for really kind of an endless list of links to other energy websites. So you can go to the JELP website and find out a whole lot about energy just by going to that one source. You might have noticed on the tables outside the doors here that we've got some issues of the journal. We've got the current issue, several copies. We have copies of back issues. So I'd encourage you to just pick up one or two and just take them with you so you can have hard copies to make reference to. But all of this is free, so take advantage of the information that the journal provides. That's a copy of the front page of, I guess, the current journal, current issue. And then finally, you might see in the loop that plays between speakers and before we started this morning, we started last year to offer my oil and gas law 1 and 2 courses outside the law school. So for people that are interested in oil and gas law, but they're not law students at the law school, because I kept on getting calls from people wanting to know how they could take my course or learn the subject matter, but of course they didn't want to pay tuition to go to 3 years of law school. So I finally figured out a way to navigate all that and get these courses packaged in such a way that I can offer them through the continuing education department on main campus. So you can learn it yourself. You can have your associates at your firm who didn't take oil and gas law learn it. This way you can, people who are managers of mineral portfolios and want to know the law, this is a great way for them to learn it as well. I've already had 40 plus students go through it since last summer, since we launched it. So I think it responds to a market need out there. And so I'd encourage you to be aware of it and ask me questions if you want to know more about it. So finally, if you want to keep up with what we're doing at the law school and the energy law program, then all you have to do is send your contact information to me. Just email me at william.keffer@ttu.edu. I'll add you to my distribution list. You'll find out and keep up with what we're doing here and take advantage of the programs when and if your schedules permit. So there's a lot going on here. I hope you'll spread the word that Texas Tech is the energy law school and encourage students who are interested in going to law school to come here. Encourage other prospective employers to come here to interview for that kind of student, because we are putting out folks who are ready to hit the ground running when they graduate. I want you to also remember that this is a student-sponsored, a student-organized symposium today. A lot of students have put in a lot of hours to make all this come together. So when you see them down front or sort of doing their thing throughout the day, stop them and thank them for putting on such a great symposium and for putting in all the hard work, as this is on top of all the things they have to do just to keep up with their coursework. I hope you guys have a great conference. I appreciate you being here. You guys who are on Zoom, thanks for joining us today. And I'll be here all day if you have questions. So have a good conference.
Thank you, Professor Keffer. Our first speakers today are Brian Faribault and John Lovell. Both are partners at Lovell, Isern, and Faribault in Amarillo, Texas, where they specialize in a wide range of practice areas, including personal injury, immigration, and of course, oil and gas issues. specifically exploration and production disputes. Mr. Faribault graduated from Denman School of Law at Southern Methodist University in 2011. That same year, he was admitted to the Texas Bar and began practicing law at Lovell, Isern, and Faribault. He is board certified by the Texas Board of Legal Specializations in Oil, Gas, and Mineral Law and was featured on the Texas Super Lawyers Rising Stars list for energy and natural resources from 2017 to 2021. John Lovell graduated from Baylor University Law School in 1984. He joined Lovell, Isern, and Faribault in 1997 and is now managing partner at the firm. Mr. Lovell is a successful trial attorney in both state and federal courts. In his litigation work, he handles a wide array of litigation for businesses and individuals on both the plaintiff and defense side. This includes cattle transactions and oil and gas disputes. His work has led him to be board certified in the civil trial law by Texas Board of Legal Specialization, a distinction less than 7% of licensed Texas attorneys hold. They will be discussing surface estates and remedies in Texas. Please welcome Brian Faribault and John Lovell. This is the clicker for yourselves.
Okay, that's for Andrew. Yes, I'm on.
Okay. Can everybody hear us through the auxiliary mics? All right, great. I'm Brian Faribault. This is John Lovell. We are very honored to be able to speak with everybody here today. I will, without being prompted, plug Professor Keffer's program and the tech law program just with my own experience. I went to SMU. I got to take energy law under John Lowe. I think I took all 4 classes that SMU provided when I was there at law school. It wasn't enough. And so I decided to get an MBA in energy finance to get more energy-related education, which has served me well. But your school is doing a lot for you if you go to this law school. And I can tell you, if I was making a choice now, I would probably choose here. But that being said, I am where I am, and I'm happy to talk.
And I'm there with him.
Yeah, there you go. And I'm happy to talk about surface rights, surface law, and surface remedies in Texas. And we're going to start by going over the contours of the surface estate in Texas. I think that's important. We lead the nation in many respects to determining surface rights as it relates to energy production. For a long period of time, surface rights, as far as I view it, and in my opinion, were really focused on just mineral production, oil and gas production. Those things have changed rapidly in the last few decades and really in the last 10 years. And you have now rapid involvement of law and the application of an existing law to new means of using the surface. And this can be seen in case law about pore space, salt dome caverns, just the use of the ground surface for development of other energy sources like solar and wind. And you get more conflicts now, and that makes this area of law more, I think, complex and more interesting and more important, especially for places like where we are in West Texas, where land is vast and the use of that land has multiple opportunities for energy development. I don't know if any of y'all are familiar with the Energy Information Association website. It's a federal government website. Has a GIS map. If you do landowner or surface representation, you should get familiar with all maps that are available to you. That one is particularly useful because it shows you lots of information about the use of land for energy development across the United States. You turn on filters to see where the sun shines the most. West Texas has lots of that. I think New Mexico beats us out. It has some of the prime solar landscape in the U.S., but we're a second to just New Mexico. And We then have all that wind development that has been put in the pipeline and otherwise developed previously. We are number one in the U.S. in that. I think we will remain that way. When I talk to surface owner clients, I tell them when they complain about, well, we don't have oil and gas development or we don't have this or that, I say, you just wait a few more years and somebody is going to make some productive use for energy development of your land out here. There literally is no place out here that I can think of that cannot be converted to energy production if it goes dry and can't be used for agriculture or farming. And I don't know what, I mean.
I agree. Yeah.
So we're going to also then get into, and I call that kind of contours and foundation. We're going to talk about the accommodation doctrine, just as a heads up. John and I, we're trial lawyers and we practice in the trenches. The accommodation doctrine is the last thing I want to use. I don't really want to use it because it's a gap filler to protect people that don't otherwise have rights. That it's just, you have surface, you don't have a contract, and you've got to find some way to keep what you have. And that's a last resort. If we can do anything else, we do it. We, a couple years ago, tried a case, it's probably been about 5 years ago now, we tried a case that I think led to a couple of the pattern jury charge instructions that didn't exist before that case on an issue we talked about at the end of our presentation, which is Natural Resources Code compliance and provisions in the statutes that give you a cause of action. I think that's one of the most attractive ways to go protect surface rights. And then we also are in the middle of that going to talk about trespass.
I'll add briefly that one of the things that you're going to experience in the field, particularly with the older operators, is they think that as the dominant estate, that means they can tell the surface owner to go to hell. And that's basically their attitude, that they don't have to recognize any surface rights. And dominant means we get to do whatever we want without paying for it. And so the law is developing, where that's not the case. And the Natural Resources Code has been very important. The accommodation doctrine is a very important backup point. But for many of the operators out there, they just can't believe that they have to recognize that the surface owner has any rights.
Yeah, and historically, and I think that goes back to what I was saying, historically, that's been the case because you really only had a conflict between surface and mineral producer. And now that we have different uses of the surface that may be tied to or related to mineral production, but that the Supreme Court of Texas has clearly said is a surface estate right, and you have other conflicts with other energy production, the surface owner is getting a stronger hand to say these rights are important and should be protected, not only recognized, but protected. And a lot of this all boils down to, we have a state that values productive, economically beneficial use of land. We don't want land left in a state where it is not economically productive. And that is the policy that underlies a lot of what the courts do for all users of the surface. So, but to start, we've got to figure out
What surface?
Yeah, what is surface? And we've gone through a lot of case law recently that helps us further define that. Now, there's old case law that says stuff like gravel, sand, and materials would be surface estate and not minerals. Though, as you can imagine, some of those materials, which can be composed of minerals, would be something valuable to mineral production. So there have been fights in the past over who owns these materials. And the case law, which is old on this point, has been very clear that these materials are part of the surface estate. Now, any of that could be changed by contract, but when you're talking about sand, including frac sand, stuff like that, it's going to be mined at the surface. It's just taking part of the surface. That's a surface estate, not a mineral estate. That the question related to that is, what is a mineral? And that originally, and I think that's the next slide, was surface destruction test. So if you had to consume the surface to produce it, then we would call that surface estate. The Texas Supreme Court changed that law and just went to what do we plainly mean or understand by a mineral, a more scientific approach. But what I wanted to do, pointing this slide out, is if you look at the old surface destruction test, you'll start to see what is really just underlying accommodation or anything that is related to how do we protect the surface. So where a deed conveyed or reserved minerals generally did not convey or reserve any substance, the extraction of which by any reasonable means would consume or deplete the surface. So if you're going to destroy it, destroy that use, then, or that right, then that's against the policy of the state of Texas. The courts are going to turn against that. Previously, that's how they determined what a mineral was. They changed that, and now it's substances with ordinary and within the ordinary and natural meaning of the word, whether that their presence or value is known at the time of severance. So it doesn't matter if you're going to destroy the surface. If we think it's a mineral, and it's part of the mineral estate. That is forward-looking from 1984. So if you have old deeds or old conveyances, then you may still have to look back at what was a mineral way back when. But for everything in the current times, when you're getting into a contract, that's what a mineral is going to be. Pore space, probably if you've looked at any of the case law in this, you're familiar with cases in the last 10 to 15 years that deal with this. And I'm sorry about the pixelated pictures on some of these. I was doing this out in the field on damage inspections in the middle of Roberts County, Texas, which is the second least populous county in the state of Texas. And I did the best I could from a truck to get some of these pictures together. Is the pore space part of the surface? And so this is the area where the minerals are going through. It's usually what's being expanded with proppant when fracking occurs. And questions have arisen, what is that? Who owns that? And the case law has come out very clearly that the matrix, the actual structure that the hydrocarbons and minerals are located in is the surface estate. Mineral estate is just the minerals between those pores or within the pores. And so we have a mineral estate that exists within the bounds of the surface estate below the dirt, but also as we get further down into the pores, that structure is surface. And that matters more and more because that pore space is where new opportunities are starting to exist. Pore space has been used for tertiary or secondary and tertiary recovery of hydrocarbons in the past and currently, but we're also going to start to see with carbon sequestration attempts to use pore space to store carbon to help with our atmosphere and other uses at the surface and to get rid of pollutants. That's going to be economically valuable in the future. And so we start to see fights over that right now. Now we see it in different contexts, but everybody's following it because they need to know who owns what when they start making deals on whether or not we can put carbon in the ground over here to store it. And the lightning oil case where that got fleshed out the most recently was a mineral owner fight between two mineral estates. I don't know if you're familiar with it, but it was the context of that lightning oil case is you had a mineral owner that had minerals under a nature preserve where you couldn't produce from the surface, and then the adjacent mineral owner who could produce from the surface. Mineral owner one that's under the preserve got rights from surface owner on the adjacent property and put a program up to drill numerous wells. I think it was maybe up to 50 on the edge of the adjacent property, adjacent mineral owner said, hey, you're going to drill wells through our mineral estate when you go into your property. You're going to produce some of our minerals as you drill those wells. That's a trespass. That space is our space, and you can't do that. And the Texas Supreme Court came down in lightning and said, it is the surface owner's matrix, the minerals that get produced as you extract, or as you drill, not extract, but just drill through to put productive string in to extract from the adjacent property is not enough to outweigh the rights of that adjacent property to drill through that little area. And unless you exclude a right, unless you totally end it. So again, we're going to look at what's the most economically productive means of using the surface in these estates. If you don't preclude its use, if you don't end the right, then we're going to look the other way. We're going to say it's okay. And that's what they did in lightning. They said it's not enough to just produce little, small amounts of minerals when you drill through the mineral formation to get to a neighboring property. It has to be more. You have to prove that this totally ended some right you had. This is a newer case, non-migratory mineral mining extraction, so salt domes. You go in, you produce salt out, somebody has a salt lease, they produce the salt. What's that? Who owns that? Again, the ruling, this is from this year. It's mineral is one thing, the space that holds the mineral is another. We'll keep going. Groundwater is the same. I don't want to run out of time, so I'll talk forever. Groundwater under a local.
It's an occupational hazard,
yeah,
actually.
Under a local set or a local case, the Coyote Ranch versus City of Lubbock case that came out over a decade ago, I think, or about a decade ago. It set out that groundwater was a separate estate, severable. It's part of the surface estate. It can be severed and created into its own estate, just like oil and gas. And in Texas, we're going to follow oil and gas law as developed for the rights of this subsurface groundwater extraction. And there, this relates to accommodation. The surface owner, they issued deeds during the drought of record in the 1950s, and they felt a civic duty to go in and say, okay, here in Lubbock, here's some water. We want to be a neighbor, and we want to do good things. And so it didn't really matter until 60 years later when there was another drought, and Lubbock said, we're going to come in and put in a well field, essentially take up your entire ranch surface. Ranch said, hey, no way, that's no good. We can't do that because now we can't do what we do. And they had to fight over whether accommodation even applies. And it mattered whether this was part of the surface and whether it was severable, and then whether it would follow oil and gas law. And the Supreme Court said it is its own estate. It was part of the surface. It's severed. It follows oil and gas. Accommodation can apply. Produced water. And so we talk about groundwater. Groundwater is underground. It's in formation. It's the surface. Produced water, you would think something similar. It's in the ground. It's in that pore space. It's in formation. Shouldn't that also be surface? The answer is no. That is not the surface estate because historically it's been considered waste byproduct of oil and gas. That is now under Texas law, very recent law this year, established as part of the mineral estate. This matters as well because, again, we're looking at what's future use and future value. And produced water, as Professor Keffer said, we're looking at ways to put it on the surface for farming, for irrigation. They're also looking at ways to extract valuable minerals from it, which could be even more valuable than just applying it for agricultural use. They have lithium in produced water from East Texas, Arkansas, Louisiana. They recently started a series of just leasing activity just to get that water. It's just brackish water. They're going to bring it to the surface. They think they can extract something valuable from it. There, because it's not a byproduct and it's a direct product, I would say the law would probably be different. It's probably surface. But here, where it's coming right from oil production, once it's captured by the operator, it's a part of the mineral estate ownership, and they're going to get to keep that value. Wind and solar are the same. We're all just talking about how we use the surface. And I use this Lego example because I think it's the best one. When we're the surface owner representative, like John and I, we're the green board, and we're trying to figure out who gets to do what below and above us and connect what. And if you're not careful, your whole green board gets covered up and you don't have any green left to do anything with. And that could be a big problem if your whole life depends on productive use of that green board, which is ranchers, farmers, people for who that really matters. The surface, and I think this is just at the underlying heart of all of this, the surface is really what provides value to all these energy production uses and these valuable uses. If you don't have the dirt to connect to or to go through or to pull from, you're not going to be able to accomplish what you're trying to do. And because that provides value, everybody's rights, including mineral owners and groundwater owners and everybody's solar and wind right owners, they all have a say in how we use it. And the state protects that say and that right, but not to the exclusion or preclusion of the other. So everybody has to play fair in the sandbox. But if you're the first one into the sandbox and build your castle first, you may have some protected rights that are superior to someone else's. So we're going to jump into that. Accommodation doctrine. The Merriman case stated this most recently, most clearly. That doctrine, which is a protection of the surface right, is based on an existing surface use without an alternative, and where the mineral producer or the other user of the surface, if it's a groundwater user, has a reasonable customary alternative available to them. This is the burden of the surface owner to prove all three. They have to show we have a use that's going to be precluded and we have no viable alternative option. And then that once those two things are established, you have a next step, that is whoever is trying to use the surface to produce, the mineral or groundwater producer or solar or wind, has some viable alternative use. In that Merriman case, and we'll get into that we'll just say it's to balance the rights of the parties, and it recognizes mineral dominance over the Soviet surface estate. But again, we're looking to protect economic use of property, especially existing established economic use. The doctrine really first got its start in Getty Oil versus Jones, and that was an irrigation pivot versus well pump case. That makes it's a local West Texas case. Easy to see. You have a pivot that's out that costs lots of money. People put a lot of money into those pivots. I don't know if you've ever looked to see how much those things cost, but they are expensive. Here in the 70s, it was a $100,000 investment. I can tell you it is probably much more now. John represents a lot of people with pivot issues, and when you dump that kind of money in, you're usually getting financing from a bank. You're putting all of that in to get water out of the ground, to be able to produce over a long-term period and make money with agriculture. Well, when you put up an oil, like a pump jack that's taller than the pivot, how does that pivot work? Well, it slides across the surface and turns, and it's going to hit that pump jack and stop and break if it doesn't get stopped, and that's a problem. And here it precluded the use. That was the evidence that was put on by Jones against Getty Oil to say, we cannot use our pivot that already exists, and we don't have another way to productively irrigate the surface. And so there's the first two elements. And then they went into the third element, second step. Producer had an alternative. They could dig a ditch, put concrete in, make a cellar, lower that pump jack. It doesn't have to be just at the surface. The oil's not just right below the surface, it's way down. And you could do a hydraulic pump that's a lower profile. The court, as you may know, sided with Jones. They applied the accommodation doctrine. They said, oil company, you've got to use alternative means because they're customary and available. And to prove customary, and this is also important, they showed that other operators on the same land were using cellars and hydraulic pumps. And so all of this is, what are the actual facts? It's not just theory. It's not what's possible. It's what's actually happening on the ground. We have a pivot that's productive, and we have alternatives for the oil company that are productive. And in those situations, the court has said, we are going to provide an accommodation and protect the surface owner. If the surface owner had negotiated a contract, they could have gotten out of this gap filler, and they could have maybe said, you're not going to put a tall pump jack in. We actually negotiate pump jack clauses in leases on irrigated land that require low profile if you're going to try to put it up in the middle. Otherwise, you put it up on the corners. And so you can negotiate for that, but in the absence of an ability to negotiate, this is the path you have to take. Merriman versus XTO was cattle pens versus a gas well. As the information shows, the landowner lost on that one. The economic toll to the landowner was $5,000, and that was just to move the pins around so that they didn't have to have a gas well blocking a gate or two that was causing a problem for how they work cattle. That was not enough. Here, you have to have something very costly or expensive or more economically burdensome or a problem to the productive economic value than just $5,000. Coyote Lake Ranch, here, that was, you had, and this is not a great representation, but I needed a grid work of mowing because that's what Lubbock was accused of doing, was they just mowed a grid across this sand landscape and were planning to put in all these wells. It was going to end productive use for cattle. That got kicked back. Accommodation doctrine was established as applicable, but there were also issues with what the deeds said. They said you could use necessary and convenient uses of the land for the wells. Well, what's convenient may not be necessary, may be broader, and all of that had to go back to the court to be determined. But you had a contract dispute, and somebody had to prove accommodation. I believe that settled without further appellate practice, and so they got direction from the court, and they fixed whatever the problem was. Harrison versus Rosetta, we had a landowner that said they wanted to apply accommodation to say an oil company has to buy water from us. Court didn't go for that. That's not an accommodation because that doesn't prevent or preclude anybody's use. You have to have something where it's the use ends, not just that somebody has an option that they chose not to take. Here they said no substantial interference. Beer tax, this one I think is one of the more interesting ones. There was an argument about hunting and power lines in South Texas interfering with helicopter hunting. I don't know. Has anybody ever gone helicopter hunting before? Okay. You fly pretty low when you do that. If you put up electric lines, that could be a hazard if you're in a helicopter going fast after game. John, more of the hunter than me, he was surprised that this case came out the way it did, but the court in South Texas said because there is a reasonable alternative of natural gas or buried electric lines, which buried electric lines are expensive. And I don't know if you know the economics of that, but most of the time the power companies say they won't do it because it's too economically expensive.
So do the operators.
Yeah,
They say, no, we're not putting them underground. It costs too much.
Costs too much. I can tell you currently for a property on which I'm on a board of, that's 1,000 acres. Excel is putting in buried lines for 75% of the electric lines on that property that serve about 80 structures, and that's going to cost over $2 million just to bury the lines. And that's just ditching in 1,000 acre area and putting in new lines. It's very expensive. There, though, it was preclusion because it was unsafe and reasonable alternative. The evidence was there and that supported a jury finding of accommodation.
And the lawyers that picked that jury did really good.
Yeah. Lyle versus Midway Solar development over most of the property. Here, the determining fact was that there was no mineral development. And so, again, you have to have preclusion of a right. You can't have some advisory opinion or some future theoretical use that is being interfered with. The surface went ahead with solar. Mineral owner said, wait a second, now I'm not going to be able to do what I want to do. And the court said, but you don't even have plans. Like there's nothing underway. That's just theoretical. It's not enough. We're not going to apply accommodation or otherwise preclude the solar panels use or the use by solar panels. But as we said, and I'll let John kind of take over from here on this part, we tend to go for trespass or waste whenever we can because it is more effective and it's not a gap filler. It's more direct. And as trial attorneys for surface owners, we like the more direct route than the please save us route. We have this right, they're interfering, or they're damaging and causing waste in violation of Natural Resources Code.
Go ahead.
We'll skip this. There.
Yeah, well, here we go. This is one of our cases, Henry versus Smith. And we had an old operator down near Wichita Falls that thought this was the way to operate a lease. This is one of those old operators that thought that being the dominant state meant you could tell the surface owner to go to hell with extreme prejudice. And so they used the property for their junk, for spare parts, for other leases, trash dump. They absolutely wouldn't go into compliance with the National Electric Code. They wouldn't follow the Natural Resources Code requirement. Basically, their argument is, well, that statute only applies to new stuff, and that's not the way we do it around here. And so we're going to do it the way around here because the way we've always done it around here. And so we had to sue them in a multi-year lawsuit. Finally, I think it was 2 weeks before the trial, they finally got some linemen out there to try to get compliance with the National Electric Code. We had a great incident there. Their electrical facilities were so bad, they actually electrocuted one of our client's cows. And Brian, yeah, you're going to jump to the, yeah. This was the cow, and of course she was found nose up to one of their electrical outlets here. And of course the position of the operator was, well, that surely she died from that thunderstorm that was in another part of the county 2 days before. Surely she had a heart attack. Well, it must have been a stroke, or it could have been global warming or sunspots. So during the testimony of the operator, Larry, we got Larry to admit, yeah, that he found her. That cow was electrocuted. And so I asked Larry, well, Larry, how'd you know she was electrocuted? And he said, well, when I found her, she's still smoking. So we solved that problem. Larry ended the Martians and sunspot theory that the operator had. But that was an example where the local railroad commission district would just completely ignore electrical problems. They didn't really care what the statute said. Their attitude was, well, they don't fund us. We're not electricians. The statute doesn't say we have to make sure they comply, so they didn't. And there were other potentially fatal electrical problems there. That wasn't the only spot that was electrified, and it was a miracle that no people were electrocuted.
They had an uninsulated live electric line
That could be touched.
Yeah, it was like, or you could run into it if you're tall.
If you were a tall guy, you might get electrocuted by walking into an uninsulated hot wire. It was that bad. I will say, lately, the Pampa office of the Railroad Commission, District 10, if you can believe this, and you need to take notes, okay, they're actually starting to enforce the law in District 10. Now, I'd be surprised if they were doing that in the Eastland District, okay, because the Eastland District judges, in my experience, are all former Midland oil and gas lawyers, but that's just my belief. But we're actually very hopeful, that things are getting improved. And, Brian and I do a lot of, and we have now a lot of the fire cases from the Smokehouse Creek fire, the Windy Deuce fire, and up in our area where we're working on now. And 90% of the fires are caused by one of two things. It's caused by electric utilities of one flavor or another not maintaining their equipment properly, or it's caused by oil and gas operators that don't maintain their equipment properly and don't comply with the law. The Windy Deuce fire, it was so tragic. You had Polaris Operating Company in Chapter 11 bankruptcy down in Houston, and they actually had hot wires running through trees. Now, I don't know how many trees there are growing on well sites in the Texas Panhandle, probably 3 or 4. Okay, but on this lease, they actually were running hot wires through the trees. And guess what happens when the wind blows with hot wires through trees? They arc, they start a fire. The Windy Deuce fire then went over and burned out much of the little town of Fritch. And there was maybe 400 homes burned, kind of low-income homes. People were burned out. 400 people or 400 homes burned because they didn't want to spend the money to keep their electric facilities in compliance with the law. They just didn't want to do it. And up to that point in time, nobody made them do it. The Smokehouse Creek fire was the result of an old pole that should have been replaced 10 years before, where the utilities just simply said, well, let's just leave it there and not maintain it or replace it till it fails. So they waited until it failed, and then it burned 1.1 million acres, killed 2 people. Anyway, it's been a real tragedy. We're also worried, this last summer was quite wet, quite a bit of summer rain, and there's a lot of fuel. So this coming February, March, April, keep your eyes open, because we're likely to get burned out again one more time. And there's a lot of litigation going on, and we expect it to go on until somebody, the Railroad Commission, perhaps, actually starts enforcing Natural Resources Code requirement to comply with the National Electric Code.
Yeah, and that comes through, and I'll go through this series of slides, and John can add in on all this, but that comes through this law that's in the Natural Resources Code that prohibits waste. In Texas, waste is prohibited. Usually that's in the context of mineral waste. Like, we don't want production to be spilled on the surface or just leaked out into the surface, or methane leaked into the atmosphere.
This statute is probably the most effective claim that a surface owner has, because waste is defined not just not economically using oil and gas resources, but creation of unnecessary fire hazards is included.
You don't have to have a fire. It's just the hazard of a fire. John talked about this. These are just pictures. These are pictures from, I think, California. These are pictures from our client's land in the Texas Panhandle after fires. Those fires are actually even before Smokehouse. Here you have what John's talking about, which is Natural Resources Code 91.019, which says that operators have to construct, operate, maintain electric power lines serving wells in accordance with the National Electric Code. This legislation came directly from 2006 wildfires in the Panhandle. It came, there's a guy, Joe Leathers, that was he's still I think a foreman.
He recently retired.
Foreman on the sixes, Dixon Creek, and then he was actually a foreman in Guthrie too for the 4.6s. He works for Taylor Sheridan right now. He went and testified before the Energy Committee in Austin about how we didn't have these things, these fires in the Panhandle, until energy and electric lines started coming in. And it changed the landscape. And now we all react to it. And we think about what the weather is and when the next fire is going to start. You have to comply with the code. It's built in multiple places. You can sue for damages under the statutes as a party who owns an interest in property that may be damaged by another. This is so effective because you don't even have to be the landowner on which the violation is occurring. You can be the neighbor. If you're a neighbor who has the effect of an unnecessary fire hazard on the other side of the fence line, you can sue to get that brought up to code. If you have that risk, it may be worth it. If you were in the area of where the Windy Deuce fire originated, had you said something, then you maybe would have prevented a massive loss that was uninsured or underinsured. They only had $2 million total by bankruptcy order of insurance. There are over $150 million in uncovered losses. $2 million to cover it. Everybody's getting less than a penny on the dollar, and most people are just foregoing a claim. You spend a little bit of money hiring a lawyer to go protect your rights under a statute that the legislature said we want to give to landowners to help them protect themselves, then you may avoid that loss that's uninsured.
And the landowner needs to be hiring electricians to go out and do inspections for him so that you can give the operators a written report ahead of time telling them where their dangers are, so that that report can be admitted into evidence on the gross negligence claim when they start the fire because they refuse to follow your warnings.
Yep. And we have a expert that's actually out of Lubbock, who is Doc Turner.
Yeah.
Who is he's done this before. He's been doing it for us since the 2006 fires, and he'll go out and look at electric lines and mark. He's a lineman for a co-op, and he'll mark everything that's non-compliant and send you pictures and a report, and you can use that to go get the companies to go clean it up. It's much less expensive than the losses you incur if you allow it to go forward.
Yeah, we're about out of time.
Yeah, I think we are out of time. So we have more slides. We skipped over a lot. There's just too much to cover. But as it goes in Texas, you have protections that are gap fillers like accommodation, and you have statutory and common law protections that give you remedies. The main consideration is your loss or your right going to be precluded? And the state and the courts are going to try to protect everybody's right to be economically beneficially using the land. And if they can give everybody a win, they will. But if there's somebody that's there first, they're usually going to get to go with what they have unless there's no alternative.
Okay, thank you.
Hey,
Okay, our next speaker is Drew Cloutier. He graduated from the University of Texas in 1987. He is now a partner at Hinkle Shanner in Roswell, New Mexico, one of the largest and most established law firms in New Mexico. He is licensed to practice in New Mexico and Texas. Drew specializes in representing upstream oil and gas clients in complex litigation and administrative proceedings. Drew maintains a statewide litigation practice representing clients in a wide array of oil and gas, land, and other commercial disputes. Drew is also an AV-rated Martindale-Hubbell, and he has also been named as the Southwest Super Lawyer every year since 2007. In 2023 and 2024, Law Dragon named him as one of the top 500 energy lawyers in the United States. Today, Drew will be talking about surface dates and remedies in New Mexico. Please help me in welcoming him.
Thank you, Charlotte. My standard line when somebody tries my last name is "I've been called worse." So if we could get my PowerPoint up, please. Oh, okay. Clicking. Here. All right. Okay. All right. Thanks. All right. Bienvenidos Nuevo Mexico. One of our territorial governors, former all calculations based on experience. The comes up a lot. Our state question, red or green. I want to touch on a couple of areas which are pertinent. First of all, before John and Brian gave their talk, never would have occurred to me from the DC to New Mexico practitioners talk about waterfall. New Mexico Falls doctrine of purification is water was up on the day New Mexico became a state in the United States. It belongs to the state of New Mexico. It does not belong to the water permit. If the water was being associated prior to state it's used in that volume for that type of purpose. You own a cotton farm, you want to you can use your water rights, you want to follow the fracking operation, no standing. Okay. Is that better? The other thing that I'll mention, and you'll see this in the theme, is New Mexico. In the time I've been practicing there, the past 35 years, has gone from law policy being the case law being directed at telling people how to conform their conduct to protecting moved to the civil right to jury trials and a real reverence for the finder of fact. A cynical person might say that's because a bunch of trial lawyers started going on the appellate courts about 35 years ago in New Mexico, but New Mexico does not have this thing called case law that you guys study on most things. We have a lot of types of surface ownership in New Mexico. Three are relevant for the Permian Basin, and I'm going to touch on wind energy, solar stuff as well. But fee surface, state surface, which is managed by the New Mexico State Land Office, which is governed by the Commissioner of Public Lands, and federal surface, usually managed by the Bureau of Land Management. For other forms of energy and non-oil and gas producing areas, you've got tribal lands. We have 23 federally recognized tribes in New Mexico. They have various degrees of autonomy. Bureau of Indian Affairs and the tribal rules govern. Spanish and Mexican land grants. Basic answer there is don't bother with trying energy development. The people there won't let you. And then Forest Service lands, which is like BLM lands, except subject to stricter regulation. So let's see, am I too far away? Ah. All right. Okay, there we go. All right. Pertinent historical New Mexico laws. So first of all, you've got the Treaty of Guadalupe Hidalgo. Interesting treaty, but what's pertinent for us is that all land in the state of New Mexico became federal property except Spanish and Mexican land grants and some land grants in towns, or some property rights in towns like Santa Fe. Those lands are concentrated along the Rio Grande River and in the Sangre de Cristo Mountains, which is where you find Santa Fe, Taos, the northern mountains. Everything else belonged to the United States. And then the United States recognized, of course, its various reservations. I went to look for a picture for Treaty of Guadalupe Hidalgo, like Nicholas Trist, the U.S. negotiator or something like that. And I was surprised to find out that there is in Mexico an annual art competition about art on the Treaty of Guadalupe Hidalgo. And as you can see from Raul Severin's painting The Dreamcatcher, there's still some strong emotions in Mexico about the Treaty of Guadalupe Hidalgo. So in any event, thought that was interesting. We have a number of federal statutes affecting title to land. First of all is the Arizona-New Mexico Enabling Act, which formed the states of Arizona and New Mexico. They granted townships 2, 16, 32, and 36 to the state of New Mexico to be used for benevolent purposes, 19 different funds. Because of the land grants, reservations for Indian tribes, military facilities, other federal uses. There were in lieu or indemnity lands granted to the state of New Mexico that the state of New Mexico had a great deal of choice in selecting. The state geologist, although oil and gas was not discovered in commercial quantities in New Mexico, looked around and said, you know, all this flat goat pasture in Lee County looks really like a lot of land out in West Texas where they're already producing lands. Let's grab a bunch of that. Politicians thought it would be very funny for the New Mexico Military Institute based in Roswell to get all that goat pasture because it was worthless, ugly land. And so the New Mexico Military Institute in Roswell, which has about 2% of the land under the land grants, has about 16% of our permanent fund because of all the oil and gas revenues there. So, but there are different beneficiaries. The beneficiaries have no say over this land. It's all the state land office. Then we have various federal homestead acts that granted, under which people could come populate the state and get a grant of 40 to 160 acres. Depending on the act, the feds either kept the minerals or granted the minerals to the landowner, except for coal. the feds were always reserving coal, but oil and gas and other stuff. Some of them include sand, gravel, and caliche. Some do not. So it just depends. Last, we have the Northwest Ordinance of 1787, only relevant because you folks in Texas are used to all your surveys that may or may not perfectly meet up. We have very regular surveys like every other state except Hawaii and the original 13. Let me talk about some legal terms that may not be familiar or less familiar, but are pertinent to surface issues in New Mexico. First of all, we have split estates. That's where the surface and the minerals are owned in different legal concepts. Minerals are severable from the surface, so you can have fee mineral owners of where there's fee surface and the ownership be different, just like in Texas. But you have situations like I just described with the Homestead Act where there is federal minerals and fee surface, and the state with its lands, the land commissioner has the discretion to sell off in a public way, surface only, and patent the surface where the land commissioner thinks the land's only good for certain things like grazing purposes and doesn't have, in his or now her judgment, the commercial value otherwise. So you can have state minerals and fee surface as well. Pooling. I'm not going to step on Jackie McLean's talk this afternoon, but in New Mexico, we do not have allocation wells. Pooling can be voluntary or forced, and you're combining parts or all of 2 or more oil and gas leases to form a lawful proration unit. Horizontal spacing units are now the big norm, and in formations that are designated gas formations, you have to do it in 160-acre blocks. Oil formations, you're forming your spacing it with 40-acre blocks, but you can go as long, we're getting 3 and 3.5 mile laterals now, and so your spacing unit can be as big as the technology will allow you to drill. Pooling only applies to private owners, whether it's voluntary or forced. The federal or state government are not subject to it. I'll talk about that in a second. And our Oil Conservation Division has a compulsory pooling proceeding that an operator can initiate for recalcitrant or reluctant or just non-responsive owners of minerals or leasehold rights to force them into the proration unit under certain circumstances. And then there is what the operators love over there is there's usually a non-consent penalty of total of 300%. You recover all your costs plus 200% before the compulsory pooled owner who doesn't elect to participate comes back in. So communitization, slightly different term. It basically means pooling with governmental consent. You've got state or federal minerals. Both governmental have communitization forms and approved communitization agreements. And you can be combined with compulsory pooling for the private owners. Nowadays, it wasn't always true, but nowadays it's very regular. If you've got a communitization, if there's federal minerals involved at all, it's FedCom. There's no federal minerals, but state minerals. The well will be a state-com well. Sorry, I got these two backwards, so I'll start at the bottom. But unitization involves putting together a number of leases for the combined or coordinated development of the oil and gas resources to allow maximum recovery. Statutory unitization can be primary recovery, that is an exploratory unit, or for secondary or tertiary recovery where there was not a unit before. So let's get to our rules and practice for surface usage, and I'll talk about some statutory modifications to this and damages a little bit later. As in Texas, the oil and gas leasehold is the dominant estate, and as Brian and John previewed for you, this can lead to problems, and New Mexico may be a cautionary tale to Texas because oil and gas operators don't like where this led us, but it's still true. So what does dominance entail? The mineral lessee is entitled to use as much of the surface as is reasonably necessary for its drilling and production operations. Then we have, it must be reasonable use and with due regard to the surface owner. And that statement from Amico versus Carter Farms is as far as New Mexico has recognized the accommodation doctrine, but I think that's it. Carter Farms, the case I just quoted to you, has been partially overruled. You're going to see a red flag in Westlaw, but the subsequent McNeil case in 2018 says the essence of Carter Farms remains the same. That is, those two rules I just talked to you. We're going to talk about Carter Farm damages later, but it's still viable and the mineral estate's still dominant. How do you apply those rules to our communitization and unitization? The entire unit, when you have a unit, is treated as a single lease. So if you want to put your central tank battery, which all 60 of your wells are going to flow on one lease, you can put it there on the surface and flow, and you don't have to pay the surface owner anything extra for that usage. You get to use the entire surface as a single lease, and so your reasonable use of the surface is for the development of the whole unit. You are not likely, and I certainly know this with federal lands, we know this with federal lands and state lands, but you're not likely to be able to use non-unitized portions of a lease for unit operations. So if a fee lease gets cut in half and half of the it covers a whole section and the west half of the section is in the unit and the east half is not, you've got an oil and gas lease for the whole section. The unit production may hold this lease in perpetuity. There may not be any development on the east half, but you can't use the east half for unit operations, even though the part of the lease is in the unit. Communitized acreage is largely the same thing, except communitization is just for a single proration unit. And we have a case that says you cannot use, so yay, we have a case in New Mexico. Seriously, in New Mexico, I get the Texas oil and gas publications. You guys get more oil and gas cases published every quarter than we do in a decade in New Mexico. So we don't have a lot of case law, and even less for the reason I just described at the beginning. We get jury trials. We don't get summary judgment in New Mexico. We get jury trials and the fact finder. So oil and gas companies don't like that uncertainty. But you can't use the non-communitized portion of an oil and gas lease to the benefit of the communitized portion. Kaiser involved, Amico trying to get across land that was subject to a single oil and gas lease to access its communitized acreage, and the court said, nope, can't do that. So, oops, sorry. Where am I going? How did I get so far ahead? I am going the wrong direction. There we go. Okay. As a UT grad, I had to get a couple of Longhorns in here, but let's talk about issues on governmental grazing leases where the feds or the state own the surface and it's subject to a grazing lease. We're going to talk about the theory of the law of state grazing leases. Use of on-lease surface is permitted to the extent reasonably necessary as in predominant estate. For the unit, the rules are the same that I just described. Presently, the land commissioners, I think, ignoring the law. And if you have a communitized portion of a state lease, but the well is not located on that the communitized portion of the state lease, she is requiring business leases for central tank batteries for that lease. She is requiring right-of-ways, the commercial right-of-ways for gathering lines and all that. I think that's contrary to law, but nobody's taking her to task for it. Maybe because when you fight the government like that and you win, the government usually finds other ways of getting back at you. So we have a mandatory form of state oil and gas lease in New Mexico. The Constitution requires state oil and gas leases to be on a form promulgated by the legislature. Ever since the first form was promulgated in 1931, it provides that the lessee is liable and agrees to pay for all damages to range, livestock, growing crops, and improvements. Courts generally accept that these are the exclusive remedies as to state lease surface. And the one thing we don't have a decision on, but I've argued with some effect, is that these provisions apply after the state, even if the state has patented the surface beforehand, these damage limitations apply to the fee surface that the state has granted, but we don't have an appellate decision. Let's talk about the reality of state grazing leases, however. I've told you what the law is, but what is it when you're on the ground? Commissioner of Public Lands is an elected statewide office. Ranchers vote, oil companies don't. So historically, the commissioner and her bureaucracy, the state land office, has turned a blind eye to grazing lessees extracting more compensation than they're legally entitled to from beyond the lease provisions from the oil companies. Most landowners follow the maxim, pigs get fat, hogs get slaughtered, and they are not greedy about it. But we are starting to see more ranchers get more assertive about it. And the current land commissioner, who is unfriendly to any use of state surface for resource development except renewable energies, is considering jumping in on some of these things. But we haven't seen that haven't seen that yet. Federal government requires all sorts of permitting. There's environmental or NEPA studies that are done on large areas of land prior to oil and gas leasing, and they're subject to these studies. Archaeological surveys are required before you do any surface disturbing activity. The federal government readily grants access over its surface to isolated federal minerals. And there's numerous regulations that are far too lengthy to get into today about how you conduct your surface operations, including things like all equipment has to be painted beige so it blends in with the landscape. So if you're using federal surface, you're going to need to consult with a federal oil and gas E&P expert. Federal grazing lessee and the operator. Again, damages are limited, crops, buildings, and other improvements. The BLM strictly enforces these limitations. If they find out a rancher is trying to extract one more dollar than for those things, or maybe killed livestock, they will cancel the grazing lease and put it up for auction to somebody else and won't give it back to that rancher. So ranchers do not try and extract any consideration for federal grazing lease land usage except for that which is permitted by law. Back in the day, there was a Lee County rancher named Johnny Etcheverry. This painting reminded me of him, and as hazing in our law firm, new associates would have to go out to get TROs because Mr. Etcheverry would get pissed off with a oil and gas company, lock his gates, and stand there with a gun at the gate and keep people off. So we'd have to run, go get a TRO, get the sheriff, get them on, and Mr. Etcheverry would cool down. We've got certain common law remedies that have been superseded as to oil and gas operations, I think largely, but probably not other forms of energy development or uses of the surface. So, first means of access at common law where you don't have your oil and gas lessee clearly did not have access, you're not right off of a public road or whatever, is easement by necessity, which you probably learned in property law, but the grantor conveys some portion of his estate and reserves another. Normally in this situation, conveys the surface, reserves some or all of the minerals, and it arises from the presumption that if you're going to reserve something and not convey it, you're going to reserve the right to beneficially access that which you reserved in order to develop it. However, it's common in New Mexico. It's a question of fact. You've got to go look in the facts and circumstances. So expecting summary judgment on your easement by necessity case is not a good expectation. The elements are unity of title. So that is the dominant and serving estate were owned by the same people at the same time. There was a severance of the dominant estate, and it's reasonably necessary. Now, one of the reasons I brought up the Treaty of Guadalupe Hidalgo is that as to federal minerals, remember, all the land in southeast New Mexico was owned by the federal government at one point. So I have successfully argued for stranded federal minerals, even when a ranch and fee land has existed for 100 years, that the federal government reserved access to those minerals. And again, we don't have case law on it because these things tend to get settled beforehand, but especially as to federal minerals, easement by necessity can be a strong argument. And I actually had a trial judge one time when I argued the Treaty of Guadalupe Hidalgo, look at the landowner's attorney and said, I'm going to go back and see if I can find some way to help you, but you might want to go out in the hall and settle with Mr. Cloutier. And we settled, and that was that. So the elements of a prescriptive easement is the adverse and open use by the claimant or the public. It's open, uninterrupted, and peaceable, and continues for a period of 10 years with the knowledge or imputed knowledge of the landowner, and it's got to be proven by clear and convincing evidence. We have some public easement cases in New Mexico where the courts say even hunters going over a road a couple times a year is enough open and obvious usage that can create a public easement by prescriptive easement. So, but you got to marshal your evidence, and you've got the clear and convincing standard to overcome. Surface Owners Protection Act in New Mexico, and this is ultimately one of the punchlines to where overuse of the dominant estate leads you. It was passed in 2007. It applies to all new entries or developments and surface disturbing activities in oil and gas operations occurring on or after July 1, 2007, except for the reclamation provisions, which apply to any well drilled before the effective date, but not plugged and abandoned prior to that date. It requires certain steps to access the surface, even when the mineral owner had a clear right of access that they granted to you with your oil and gas lease. The activities depend on whether it's a surface disturbing activity or an oil and gas operation. The statute says the non-surface disturbing activities are inspections, staking, surveys, measurements, and general evaluation of proposed routes and sites. I think the statute says includes, but the only case we have on it suggests that that list may be pretty nearly exclusive. Geophysical survey is an oil and gas operation. Whether it disturbs the surface or not, although the court indicated that picking up dust from the thumper trucks doing the geophysical probably was surface disturbing, but geophysical survey was being used by the operator to site their wells, to determine if they were going to drill wells and where they were going to site them, and seemed to fall within the non-surface disturbing activity list. But the court said, no, that's too far. That's an oil and gas operation. So for the inspections, surveys, et cetera, you've got to give the landowner 5 days written notice if you hand deliver it, 10 days by certified mail. And by the way, I think I've got a handout. Charlotte or John, do I have a handout that people can have? I've got a 2-page handout on Surface Owner Protection Act. Oh, somebody's waving it at me, so it's out there. So a lot of this stuff is covered in there. There's no required content of it, but fulsome and robust is my advice to clients when they're using this. There's no reason not to get Google Earth out and draw the route that you're going to do. Tell them what sort of vehicles are going to be out there, who they are, contact information for a question. The more information you give, the less likely a trial court judge is look askance at you if you have to go in for a TRO and enforce your rights. Larger, the oil and gas operations, 30 days advance notice, 5 more if you're certified mailing. You've got to have a robust description of the proposed oil and gas operations, enclose a copy of the SOPA statute, provide contact information for the operator's representative, and include a proposed surface use and compensation agreement. I'm not going to go through them all, but the statute mandates 12 topics that the surface use and compensation agreement has to cover, and they're activities that are generally important to ranchers and include indemnification obligations, and it can include anything else that the parties agree. So again, fulsome, robust is my motto. So my form, surface use and compensation agreement, includes, if we have to reseed, we will use blank type seed or the BLM approved and let the rancher fill in what sort of seed blend they want to see used. No hunting provisions are easy to include because you're not going to allow your folks to hunt anyways, but they add to the landowners' potential contentment and also make you look better when you're in court. So to get in, the operator can get in on the surface after the 30 or 35 days of notice expire if you've got an agreement with the surface owner, or if there's no agreement, you've got to post a bond at a New Mexico financial institution. It's $10,000 for a single well bond, $25,000 for a statewide bond. I've never seen one of these bonds called on by any that my clients have maintained, but I think there's an implied duty under the act to maintain it at that level. So if it's called upon, you need to refresh it. Surface damages and remedies in New Mexico. Now I'm going to go back here, and by the way, SOPA does apply to oil and gas operations. So solar, wind, even geothermal, which is a lot like oil and gas, of course, I don't think it applies. So a lot of your answers, I think I've already given away the punchline, are going to depend on the effective date of your act. So I want to go back to Amico versus Carter Farms because John and Brian alluded to this, but when you get too aggressive with asserting the dominant estate, it doesn't lead to good places ultimately for the oil company. So Amico drills the Carter Com #1. This is an older well, so we don't have whether it's state or federal com on fee surface. They use 4.53 acres for their pad and have 3 unlined pits, a reserve pit, a spillover pit, and a burn pit. This is the fact that really makes the decision and the fact that Amoco took it up kind of egregious. There's surface water is found 2 feet below the surface of the reserve pit. So they build it up with caliche, but in a reserve pit, as I'm sure Professor Keffer has taught those with oil and gas experience, you're putting produced water in it. The heavy metals and chlorides are going to start settling to the bottom. These are unlined pits. Eventually, in our country, when it rains, if this stuff is left on the surface, it starts to leach down. Grassroots in New Mexico ranch land and probably out here in West Texas goes deep as 4 or 5 feet. So 2 feet of surface water under there, rain is going to get down there and start leaching stuff into the subsurface. So what do we have at the end? Amoco wants to just level the reserve pit and bury the waste in other pits, and Carter Farms refuses to allow them to do that, and Carter Farms sues for the cost of reclamation. Now, of course, here's why Amoco must have fought this so hard, because Carter Farms advances a nuisance theory for the cost of restoring the site, almost $14,000. You see why an oil company would fight that all the way to the Supreme. I mean, again, this is the problem with flexing your muscle on the dominant estate too much. It's $14,000 they're fighting over. The jury finds on special questions that the land as pasture is worth $500, but awards on the nuisance theory. The trial judge vacates and says, nope, you're capped at the value of the land, $500. Our Court of Appeals reinstates the jury verdict, and then it goes to our Supreme Court. We follow Texas and most other courts and say there is no duty implied to restore the surface. There's either got to be a contract with the landowner to restore it, or the oil company doesn't have to do it. And then this kind of convoluted damages scheme depends whether the damage is permanent or temporary. That created a lot of dispute. If it's permanent, it's the difference between the fair market value of the land prior to the injury and the fair market after. If it's totally unusable for a period of time, it's the rental value of the land for the same period. And if it's temporary, it's either the cost of restoration, as long as it doesn't exceed the value of the land. So after Carter Farms' decision, those of us practicing in New Mexico had to advise our clients, your damages are capped at the value of the land. So I fought and won some trials where, oil's being left on the surface because the land's worth $75 an acre as grazing pasture. And my client, either because they butted heads with the landowner so many times or just out of spite, wanted to fight it. So here starts to be the lesson and the erosion of Carter Farms, and this theme that I talked to you about New Mexico becoming much more and more enshrine the virtues of civil jury trials and let the jury be finders of fact versus trial judges telling us how to conform our conduct. So McNeil involved a 1951 unlined pit that was closed in 1992. And under the Carter Farms doctrine, they said, hey, this was unreasonable use of the surface because the closure was done contrary to industry standards and resulted in contamination. So you did not act as a reasonable and prudent ordinary operator. You closed it in an unreasonable way, and that's how they were trying to get around Carter Farms. The court said the cost of repair, unlike under Carter Farms, was admissible because it has a tendency to make the testimony of the expert on market value of the injury more or less probable and bears on the diminution in value. It retired the permanent temporary distinction in Carter Farms that we talked about, which involved lots of litigation over a dichotomy that was often hard to figure out where the line was drawn. And then SOPA, I think, for oil and gas operations, put the nail in the coffin on Carter Farms on remedies. One last thing about McNeil, though. McNeil did say you could look at the value of the entire property before and after. So you had a $31,000 acre ranch. And so even though the area where the pit was probably wasn't worth all that much money, McNeil allowed the court to look at a before and after value of the entire ranch because of this surface contamination. So now we have a statutory duty under SOPA to reclaim the surface, and that means to substantially restore the surface affected by the oil and gas operations to the condition prior or as otherwise agreed in writing by the operator and surface owner. And this reclaim definition creates a lot of leverage for a landowner on reclamation activities because you can't dig out old spills to 4 feet and put down a clay liner and call it good. Maybe you can, but you've got to get to a jury to find that that was substantially reclaiming. You've got to get the landowner to agree to that. To avoid the uncertainty of litigation over that. That may be substantial reclamation, but you're only going to find it out on a case-by-case basis. And if I win one case that goes to the Court of Appeals and says that in New Mexico, all that is a signpost to the trial judge that I can win that again, but I've got to go back to trial again with my second client to do it. So substantial leverage. And as I mentioned before, the duty to reclaim applies to wells that were not P&A'd prior to July 1, 2007, its effective date. So if you've got a client that has a pre-July 1, 2007 well, pre-SOPA common law probably applies to monetary damages, but it's after the cost of reclamation because you still got the duty to reclaim. So what is the before and after value of the entire property? Under SOPA, all operations got to be reclaimed. Are we about done or? Okay, good. Okay, sorry. I'm not watching the time. Under SOPA, the operator is strictly liable for loss of agricultural, let's do it here. So here's what SOPA says. You've got to compensate for oil and gas operations and its strict liability for loss of agricultural production and income, lost land value. There we go. Lost use and access to the surface. We need a new battery in this. Lost value of improvements. And importantly, the payments contemplated by this section only cover land affected by the oil and gas operations. So I contend, we don't have case law, I contend that McNeil's overruled under SOPA and you can't look at the whole value of the ranch, how it's affected. You're only compensating for the land loss. So here's the trade-offs. The landowner gets notice prior to entry. You can't just barge on. You've got reclamation duties. You're forcing the operators to at least offer compensation, and the operator's strictly liable for damages. You don't have to prove unreasonable usage. What the operator's getting is guaranteed access. The whole prescriptive easement, all that stuff that I talked about, that's still applicable to other forms of energy development, but not oil and gas. You've got the ability to create certainty as to damages, which in a state like New Mexico and its reverence for the finder of fact is valuable. And you probably have the elimination of the before and after of the whole property. So I think that's it. And I appreciate everybody listening. Thank you for the two journals for putting this on and inviting me, and Professor Keffer too. And I think we're done. So I'll be hanging around if anybody wants to talk about this for the coffee break. So thanks, Deb. Thanks for Michael's appreciation. All right, we're going to take our morning break. We'll be back in about 10 minutes at 10:30. Thank you, guys. Thanks. Yeah, appreciate it. I was glad I was hurrying through that because I was like, they didn't leave me quite as much time as I know. Wanted to.
Thank you.
You're welcome, Charlotte. Yeah. Oh, yes, you do need that.
Thank you very much.
All yours.
All right, everyone. We are going to get started back here. Our next speaker is Jeff King. He is a partner at K&L Gates in Fort Worth, whereas he is a member of the Oil, Gas, and Resource Practice Group. He is an experienced litigator representing a variety of oil and gas producers in federal and state courts, including before bench and jury trials and arbitration panels. He has represented his clients in several states, including Texas, Colorado, Oklahoma, and has even gone before the Supreme Court in Texas, North Dakota, Oklahoma, and West Virginia. His work has led him to multiple awards, including being listed in the best lawyers in America every year since 2008. In addition to his litigation, Mr. King is a frequent speaker and author on various oil and gas topics, including a 2022 article, The Uniform Electronic Transaction Act, Risk of Binding Oil and Gas Industry Contracts, which he co-authored and was published in the Texas Tech University School of Law's Journal of the Energy Law Practitioner. Today, Mr. King will be talking about oil and gas royalties in Texas. Please welcome Mr. King.
There we go. Well, you all right? And we don't need a products liability case or slip and fall. All right. Well, hello everyone. My name is Jeff King, and I appreciate the very nice words that were said about me. And if you ever want to read, if you ever have trouble falling asleep, just go pull down one of my articles, knock you right on out, especially the one that she just talked about. Well, we're here today to talk about oil and gas royalties under Texas law. And what I want to, so we're going to talk about royalties to be paid on natural gas, crude oil, and if we have time, and I hope that we do, we can talk a little bit about the implied covenant to market. But primarily, we're going to talk about express covenant cases and express oil and gas leases, express royalty clauses. One of the things that I believe that everyone needs to understand and comprehend when you're analyzing royalty obligations is if you do not understand how the gas is actually sold or the oil is actually sold, you're already going to be in kind of that wonderland of how it is that we're supposed to pay for the production. So I wanted to start off a little bit unusually and talk about how is oil and gas actually sold in today's world. The days of where gas was sold for a fixed price at the well or for some or based upon an actual number, those days died a long time ago. And if you want to read about it, you know, there's multiple articles about why that occurred. It occurred primarily because of deregulation. And if you want to read something that I wrote on it, you can look at a 2011 article that I published at Texas Wesleyan Law School before it became Aggies. And once it became Aggies, I was out because I'm a Longhorn Raider, so you know we don't deal with them very well. But what you have to understand is that natural gas is sold by producers in multiple places. It can be sold at the well. It can be sold at the tailgate of a processing plant. And if you're a big producer and you have the ability and the capacity to do it, you can move that gas all the way down to market hubs. Sometimes, if the gas is not sold at the well, sometimes the sales point is multiple miles away. And if you are not at a processing plant, if it's not going to be sold at a processing plant and you have the ability to move it downstream, you might not even sell that gas for hundreds of miles. And why is that important? Because, as we'll discuss later, the point of sale where this production is actually sold is going to drive royalty obligations depending upon the terms of the oil and gas lease. All sales, I'm going to say that right now, all sales of natural gas are by a formula. It doesn't matter whether it's at the well. There's a formulaic price that is calculated and paid at the well. If you're moving that gas over here to the tailgate of a processing plant, there's another formulaic price that the parties will enter into, or a formula that creates the price that will be paid for that gas. If you are moving the gas all the way down to a market hub, say you're moving it over to East Texas and you're going to sell it at the Carthage hub, there will even be a formulaic price that is calculated there at that hub. Each location of sale will have a different formula depending upon the factors that are at play in the purchase of that gas. Now, oil used to be sold. Anybody ever heard of posted prices? Okay. Boy, I'm old. Oil used to be sold based on posted prices, and that's where oil buyers would say, literally, the way it was done is they would post on a fence post, I'll buy your oil for $10 a barrel. And then all the way up and through the 90s, oil companies would post their price as far as what they would pay for oil. Well, that all went away back in the late 1990s. And now, over the last really 10 or 15 years, even oil is sold based on a formulaic price, depending upon where that oil is sold. Now, this is going to be important as we get into the calculation of royalties, because the calculation of royalties is going to depend upon where the point of sale is and the price that's been obtained and what is and isn't a deduction. Whoops. Sorry about that. So what is a formula? As I just said, the market centers are basically far away from the sales points, where you have liquid pricing, where we have, shall we say, for crude oil, Midland, NYMEX Midland, or if you're in other parts of the world, NYMEX Cushing, Oklahoma. That's where the market centers are. And so these contracts will establish a value at the point of sale, utilizing market center data as a starting point for determining what somebody will pay depending upon where they're going to purchase it. No rational purchaser will base a price or will pay a price based on a market far removed from the place where they're acquiring the production. That doesn't make any sense. Why would I pay a price for Carthage, Texas index for gas in the Permian Basin? Because the value of that gas in the Permian Basin is going to be a lot less than it is at the Carthage hub. The same thing with oil. Why would I pay Cushing NYMEX, and Cushing is in Oklahoma, Cushing NYMEX for oil in the Permian Basin? You will not do that. So the purchasers calculate and create these formulas to create a purchase price that they will pay wherever it is that they're purchasing the product. Now, for those that say, oh, well, gosh, this seems like some trick that the oil and gas industry has picked up, it's the same way every other commodity is sold. I do a lot of work in Oklahoma, do a lot of royalty work there, do a lot of royalty work in Kansas, where the plaintiffs are generally farmers. They're wheat farmers, sorghum farmers, and things of that sort. And you always ask them, how is your commodity sold? What you grow? They go, well, I move it to a silo there in Thomas, Oklahoma, and I get Kansas City NYMEX with a location differential, a formula. The same thing goes with beef. The same thing goes with all commodities. So there's nothing unusual about determining a price based upon a formula. So what is a sale? Sometimes this issue comes up in connection with royalties and what should and shouldn't be paid. A sale is where we're going to have a change of title. A sale is where we're going to have an assumption of the risk of loss, and a sale and a calculation of the price to be paid at that location where title changes and the risk and the assumption of risk of loss is assumed. All right. We'll get into some of these royalty clauses. We're going to get into some others in much more detail. But this is a standard producer ADA dual royalty clause. It is by far the most common clause here in the state of Texas. You don't see this clause in other states with much regularity. But if you go across the state, whether it's in the Panhandle, in the Permian, East Texas, this is the typical clause that you're going to see. These are very old royalty clauses, and you've got leases that are producing a hell of a lot of oil and gas with a royalty obligation is what you see in front of you. So the royalty clause that we see most of the time is if the production, this is for gas, by the way, if the gas is sold off of the lease, royalties will be paid based on the market value at the well and at the well valuation. If the gas is sold on the lease, then it will be the amount realized from that sale. So we'll just go through this part really quickly because I want to get into some of the really hot or more common types of disputes that we've been seeing. Market value. Supreme Court has told us what a willing buyer will pay to a willing seller when neither party is under compulsion to buy or sell. I think I've written and said that a few times. That a comparable sale is one of like kind, quality, quantity, deliverability, and availability to marketing outlets. So the first way we're going to try and determine market value is to determine whether there are any comparable sales in the area. And if so, how do we determine what the prices were for those comparable sales? A little alert here. We used to be able to rely on comptroller records fairly regularly to determine the prices paid in an area. Because of severance tax regulations, because the things that operators can now deduct as, quote, marketing costs that are not typically marketing costs, those numbers have become a little more difficult to utilize because some companies have the ability to take additional capital deductions on their severance taxes that other companies are not, and that skews the numbers. And so that makes using the comptroller records a little bit more difficult. And, it can be done, but there are certain assumptions that are subject to cross-examination by good lawyers like these two guys over here, Brian Faribaugh, who I know. It makes it subject to cross-examination. It makes it a little more difficult to utilize. But comparable sales, well, we used to use comptroller records. We generally are going to have to find other alternative means of doing it. There are ways of doing it. Your experts can help you. What has become more and more common for determining market value is the use of the netback method. So I've sold the gas downstream off of the lease. I've sold it at a plant tailgate. The netback method is to take those sales proceeds and I can deduct post-production costs back to the well to determine what the market value was. The types of litigation that we get into there really deals with, well, was it really market value? Were the deductions too high? Could you have, were there better terms that could drive that price? And we get into those types of disputes. That's that in and of itself is probably a 1 hour presentation about really the viability of that argument, but that is the argument that is made, and that's where the dispute is. So the netback method, when we're in market value litigation, is typically about what's the value of the deductions or the costs that the producer was incurring in deducting. Proceeds. The second part of this is if we sell the gas on the lease, then the royalty is to be paid based upon the proceeds from that sale. Our Texas Supreme Court has finally come out in the last 4 or 5 years and actually told us what the hell proceeds means. And it's really very simple. It means the actual amount received. So if I sold the gas at the well, and I would submit to you, if I sold the gas at the well per my formula, and the formula will always include the buyer's costs in one form or another, and that generated $3 per MMBTU, I got to pay a royalty based on $3 per MMBTU. The royalty owner, under those circumstances, that's the proceeds from the sale. We're going to get into here in a moment in the use of these pricing formulas when I have a formulaic price at the well, what is and isn't a deduction. But for purposes of this discussion, the proceeds from the sale for an on-lease sale is exactly the amount of money that we got. Okay. The litigation that we've been dealing with really over the last, probably 20 to 25 years deals with the concept of what are the deduction of post-production costs. The first point and the first question that we should have to ask is, what is a deduction by the lessee of a post-production cost? That's the first question. Please note that I didn't say what is a post-production cost. We know what that is. That's going to be gathering, compression, processing, treating, transportation. Those are post-production costs. The question is what is a deduction by the lessee of a post-production cost? And the cases that we're going to be talking about address that very issue. If we have a deduction of, if there is a deduction of a post-production cost by the lessee in the payment of royalties, does the royalty owner bear its proportionate share? General rule, if we are at the well, the answer is absolutely yes. They bear their proportionate share of all post-production costs incurred by the lessee. The question becomes with other types of clauses is when the point of sale, when the royalty clause is not tied to the well, let's say it's tied to the point of sale, okay, which is becoming more and more common in Texas, is what post-production cost does the royalty owner bear and how do we get there? Of course, we're going to talk quite a bit about, we're going to talk a little bit about Heritage Resources versus Nations Bank. And if you've never read that case, it's a 1996 Texas Supreme Court case. The royalty was to be paid based on the market value. It was this dual royalty clause. Market value at the well. It said there will be no deduction from that value for gathering, processing, treating, so on and so forth. No deduction of post-production costs. The Texas Supreme Court said, well, market value at the well is the market value at the well. And by necessity, you have to deduct post-production costs to get that value. And then they implemented or discussed what we call the surplusage rule, which we'll talk about more later. Now, when we're trying to determine the amount of royalty to be paid, we're going to use the lease language, right? Lease language is a legal question. What the meaning of it is a legal question. I have been looking at oil and gas leases since 1995. I have yet to find an ambiguous one. I've heard it argued that they were ambiguous, but I've yet to find a court that found one that was ambiguous. Now, maybe they're out there, but I haven't seen it. In this state, unlike in other states, and I'm going to say that again, in this state, unlike in other states, we enforce the royalty clauses as written. Oklahoma, that's not true. But in Kansas, that's not necessarily true. But in this state, they are enforced as written. So the words matter. The two things that our Supreme Court has come around and finally started giving guidance about the things that are important to determine the amount of royalty to be paid. The first thing that they're going to look at with a royalty clause is where is the point of valuation. So in other words, where is the royalty to be valued? Is it at the well? Is it at the point of sale? In other words, where did the lessee actually sell the gas? Or is it based upon some other barometer that is objectively verifiable? I've seen royalty clauses that say, you shall pay me a royalty based upon the gas index applicable to the area. And we get into all types of litigation about, well, what does that mean? But at least that's the point of valuation. That's where the royalty is to be valued. The second thing that we're going to look at is once we know where it's to be valued, we're going to look at the method of valuation. Is it going to be market value? Is it at the well, at the point of sale? Is it going to be the proceeds received? Is it going to be gross proceeds? Is it going to be net proceeds? And I would suggest to you that as we go through this, the distinction between gross and net starts to become less and less depending upon where the gas was sold. So we're going to look for those two things every time we look at a royalty clause, understanding how the production was marketed. Any of the law students here going to clerk for federal judges or any judges? Okay. If you get an oil and gas case and it's a royalty case, start the opinion off with how the dadgum gas or oil was marketed. That would make things flow a lot simpler for all of us because those things dictate how royalties will be paid. Just a suggestion. You can tell your judge you heard a crazy speech. And then he'll say, who was it and when's he going to be in front of me? And we're going to address the surplusage rule that was first that was discussed in Heritage Resources versus Nations Bank. But before we get into this, I thought I'd give everyone some free legal research. Pulled this right out of a brief I'm writing right now. And here are the rules of contract construction that apply to royalty clauses. I won't go over them all, but none of them should be surprising. We're going to enforce it as written. Industry knowledge and industry custom is going to be inadmissible to interpret an unambiguous document. We're going to examine the entire document, consider every part of it with every other part. We're going to give the terms their plain and general meaning, and we're going to look at this from a utilitarian standpoint as to what is the business activity to be served. They're not going to rewrite leases. They're not going to add. They're not going to subtract. Like I said, they're going to enforce them as written. I'm sure you can have the PowerPoint, so here's some free research for you. I actually wrote that myself, so I did read the cases. So, all right, so how about that? That's okay. So one of the things I wanted to visit with you about, can you roll that forward, please? Is some of these cases that we've had out of the Texas Supreme Court that drive the discussion about how we calculate royalties. There we go. As I said earlier, the main thing that we have been dealing with in the last 20 some odd years has been the deduction of post-production costs. The Heritage Resources case I've already discussed. There you go. You're all right. The Heritage Resources case we've already discussed, but I wanted to address the Potts versus Chesapeake case and some of these other ones. In Potts, the royalty was to be paid based on the market value at the point of sale. It wasn't at the well, as per the terms of the lease. But the production was sold at the well. And so, in that particular lease, it said market value at the point of sale, and there'll be no deduction for the cost of gathering, compression, and so on and so forth. Well, Chesapeake was selling that gas to an affiliate at the well. That affiliate was moving that gas downstream, selling it at a market center, and deducting the post-production costs that the affiliate incurred in calculating the price to be paid to the operator. There was not an issue in the case about whether or not that was a sham transaction. And in fact, the parties stipulated that the transaction in and of itself was valid. The plaintiff was saying, look, you're deducting post-production costs. Therefore, you need to pay royalty on those post-production costs that you deducted. Trial court said, no, the point of sale was at the well. So it's market value at the point of sale. So we calculate and determine what the market value at the well was, since that was the point of sale. And the deductions that were part of the formula to create the price that was paid at the point of sale are not deductions. They are a means of calculating the price. They do not burden the royalty, and they are not borne by the royalty owner, because those were elements of the pricing formula, the formula I talked about earlier, used to calculate the price that is to be paid for the production. A contrary view or an alternative view of what, not view, excuse me, but a set of facts is the Bluestone versus Randall case. What was happening there, this case that came out of the Barnett Shale. Bluestone was producing the gas there in Johnson County, Texas. Bluestone maintained title, contracted with a company to gather the gas for them, move that gas through the gathering system, contracted with another company to process the gas for natural gas liquids and residue gas. Then Bluestone sold the gas out of the tailgate, sold the gas out of the tailgate of the plant, sold the NGLs out of the tailgate of the plant. Bluestone was then deducting the cost it incurred, because it's paying a fee for the processing, it's paying a fee for the gathering, started deducting the processing costs and the gathering costs. The royalty clause said gross value received by the lessee. So following our rule of where's the point of valuation, the point of valuation is where, and the Supreme Court said this, is where's the sales point? Because gross is determined based upon the amount of money you receive, where you sold that gas. And the value is going to be that value. What is that price? Now, there was a big blow up in that particular case about this was all in an addendum to the oil and gas lease, which controlled the addendum or the body of it. But once they made that in my opinion, very easy ruling that the addendum, where it says notwithstanding anything to the contrary, to me, that means that all this other stuff don't count, and we're going to use gross value. So once they made that distinction, the answer to the question became very, very simple. Gross value without deduction, because you're to pay gross value. Now, let's how do we reconcile that with, say, Potts, point of sale, and how we're going to reconcile that with another case we're going to talk about here, Shepherd. The point is that if Bluestone had been selling that gas in an arm's length transaction at the well, the purchaser would have to gather the gas. The purchaser would have to process the gas. And most of the time, the sales price, the formula, would include some type of index-based price for the residue and some type of index-based price, probably Mont Belvieu Opus, for the natural gas liquids. And then the formula kicks in to determine what the gross price would be paid to Bluestone. So at that point of sale, been at the well, you would have had a different result in that particular case. How do I know that? I know that because we get to Shepherd. Shepherd is a 2023 case, Devon Energy versus Shepherd. That oil and gas royalty clause was a bear, to be honest with you. It went a little bit further than some of these other ones did. In that particular clause, it was gross proceeds at the point of sale. Gross proceeds at the point of sale. Now, by the way, all of these leases had this anti-deduction language in it. We're going to get into why that is just, it's universally surplusage here in just a few moments so that we can make all this make sense of it. In Shepherd, the royalty clause was gross proceeds at the point of sale. Devon was taking that gas. It was this is Eagleford Wells. Devon was moving his crude oil downstream and selling that crude oil out of a central delivery point. The price for that crude oil was a price set there in Houston minus $18 a barrel. That was the price that that they were getting in an arm's length transaction. They were moving the gas from the wellhead through pursuant to a gas gathering, processing, and purchase agreement through the end of a tailgate of a plant, and then selling the gas at the tailgate of the plant. Had the royalty clause only said gross price, the Texas Supreme Court was very, very clear that if Devon paid royalty without deduction based on the price of the proceeds it received for that oil, which would have been the Houston price minus $18, and had they paid royalty based on the gross price they received at the tailgate of the plant, regardless of the no deduction language, and regardless of the other language in the case, they would have complied with the royalty clause because they made no deductions from those gross prices. But this particular clause had something more to it. It had what we call an add to clause. I have seen these in other leases. They are they're unique. They don't happen very often. But in this particular oil and gas lease, the royalty clause said, look, if you're selling production in an arm's length transaction to Keffer Midstream, and in that contract, Keffer Midstream has its costs associated with it. In other words, this formula that we've been talking about, where there's going to be an adjustment of the price based upon his cost. Under that oil and gas lease, the language was you have to add that back in the calculation of gross proceeds. We call it an add back clause or an add to clause. So Devon was paying on gross proceeds, but they were not adding back the $18 a barrel in the payment of royalty. When they sold the gas at the tailgate of the plant, again, a formulaic price that they were receiving, they were not adding back the elements of the formula in the payment of royalties. And the court said, look, first of all, what are gross proceeds? And this is important because this dovetails in with Randall and dovetails in with Potts. What are gross proceeds? Said the landowner, he said, but the leases also plainly require certain sums to be added to, quote, gross proceeds. The question is not whether an unaffiliated buyer's post-production costs, in other words, the elements in the formula, because I've got title transfer and the buyer's post-production costs are included in the formula. Question is not whether an unaffiliated buyer's post-production costs are gross proceeds under the leases or under the law. And here's the quote. Of course they are not. The gross proceeds in that situation was the actual amount of money that Devon received for both the oil and for both the gas. Then the court goes in and says, however, in this case, the express language in the lease required you to add those buyers' post-production costs for the calculation of royalties. I expect to see on every lease in the Permian Basin that gets signed the same dadgum language that we saw in Shepherd, because that is the way that all of that changes. That's the way that the formula, the way gross proceeds would be calculated and changed. An example, and I want to talk about Hawkins versus Capitan Energy. A little funny story about that particular case. I had the exact I had a case that was similar to Hawkins but not identical, wherein the plaintiff's lawyer in my case was the defense lawyer in the Capitan case. And I thought their briefing in that case was outstanding. And so did the judge, because they were agreeing with me in my case. But we won't get into that. But in Hawkins, it was gross proceeds, and there'll be no deduction for any post-production costs incurred by the lessee. So in that particular case, the gas was sold. There were a lot of things that were happening, but the gas ultimately was sold at the well. Hawkins came in and said, hey, you're deducting post-production costs, because it also said that there'll be no deduction of post-production costs directly or indirectly. And this is at least an indirect deduction of post-production costs. Federal judge out there, this is in the Pecos division, he said, no, wait a minute. What is a it's the same question that I started this speech off with. What is a deduction of post-production costs? And they said, now, these formulaic prices, they may reduce the amount of royalty paid, but it also reflects the fact that that's where the gas was sold. The gas wasn't sold downstream. The gas was sold there. And so a deduction is something that the seller of the gas actually incurs. I negotiated and I gathered the gas myself. I processed the gas myself, and I'm going to pay for those services. I cannot deduct that. But if I'm entering into a formulaic price at the wellhead, and those are costs by the purchaser, those are not deductions. They're post-production costs, but they're not deductions. Those are a means of determining the value of the price to be paid at the point of sale. So, I want to come back to this issue. I want to talk about I didn't put this on the PowerPoint, but I wanted to visit with you about surplusage. Texas Supreme Court in Heritage Resources, they said, look, the royalty was to be paid based on the market value at the well, and the language that says there'll be no deduction from the value of that for gathering, processing, so on and so forth, post-production costs or transportation. They said that was mere surplusage and therefore is unenforceable. The state of Texas, including yours truly at first, had absolutely no understanding of how in the hell what surplusage was. But once we start analyzing and utilizing the rules that the Texas Supreme Court have told us to use in determining how to calculate royalties, the surplusage rule becomes very, very clear. So when I have, let's say I'm required to pay royalty at the point of sale, and my point of sale is downstream, I cannot make deductions from that point of sale. Whatever the proceeds are, whatever the market value is, I cannot deduct any costs between the wellhead and the point of sale. Okay? And any language within the oil and gas lease that says there'll be no deductions is surplusage, because all it is doing is repeating what the law of this state is. It has not added anything to the interpretation of the royalty clause. And that's what the Heritage Resources case, the court was trying to say, is that the no deduction language there was just a recitation of the law. So when we see these no deduction clauses, except and unless we're in the Devon versus Shepherd world, when we see them, all they are doing is regurgitating what the law is. I've got a case right now where the royalty on gas is to be paid based on the first sale by an unaffiliated and unrelated party. In other words, the first arm's length sale. And so my client in that particular case has a relationship with its gas buyers, an affiliated company. That means quite clearly that they get a royalty based upon that affiliated company's arm's length sale. It also has no deduction language in it. But we already know that I got to pay based on the proceeds of my first arm's length sale, and there can be no deductions. So the language in the lease that there'll be no deductions is absolutely surplusage. By the same token, like I said, all gas, all NGLs, it becomes even more bigger with NGLs when we get into why. And now I don't want to get into the difference between Y-grade and purity products because it makes my head hurt, and I'm already putting you to sleep, and I don't have enough good jokes to wake you up. But it's all formulaic pricing. So whatever the proceeds were in my case and in these other cases, at the place of sale, especially if it's arm's length, that's what royalty shall be based on, and it automatically says there can be no deductions from that. So the deduction language is, as a matter of law, surplusage, unless and until you have a Devon versus Shepard. Now, to kind of, and by the way, you know, this isn't just things that I tell courts and plaintiffs' lawyers and things of that sort. These are things I tell my clients. I represent a lot of clients in Oklahoma and in other parts of the U.S. that have finally wisened up and invested in Texas oil and gas producing properties. And I tell them, congratulations, welcome to the big leagues. And they automatically, when they're coding their leases, they'll just say, well, Texas has a default rule that's at the well. That is incorrect. We do not have a default rule that is at the well. We have a default rule that says we will enforce the oil and gas lease as written. So if you have any clients that just say, well, shit, I'm just going, pardon my language, but you know, it kind of irritates me. I'm just going to put all my royalty value there at the well unless, whether it says at the well or not, they're making a grave mistake, and they're going to probably be visiting with somebody like Mr. Lovell or Mr. Faribault very, very soon. So the answer to it is understand how you market this production. Understand where the point of sale is. Understand how the price is determined. Then look at your royalty clause, and on your royalty clause, find out where the point of valuation is and the method of valuation. That's how you comply with royalty obligations in this state, at least on pricing. How are we doing? Okay. I want to visit a little bit about an issue that is coming up, becoming more and more prevalent, and that is on gas used off lease. Typical royalty clauses will say that for gas that is produced and used off lease, a royalty is owed on that. Generally, it's the market value of that gas. Now, gas is used quite frequently in the marketing of production. I mean, these compressors on these gathering systems, most of them, at least at this point in time, use natural gas as fuel. Processing plants, most of them, even though you're seeing more and more conversion to electricity, most of them use natural gas as fuel. Is a royalty owed on those volumes that are used off lease? Except in circumstances that I'm going to raise later, the answer is generically yes. Sometimes we don't see this as often as we used to, but sometimes gas will be used for production from other wells. They need gas lift compression, and there are certain problems with the well, so they'll move some gas over there to produce that well. So in those circumstances, a royalty should be paid. Now, the question has come up. Did I screw it up again? Oh. The question has come up is, can natural gas that's used for the purposes of marketing be a deductible post-production cost? And there are two cases that address that. Carl versus Hillcorp, which was the dual royalty clause that I told you about, market value at the well is sold off the lease, proceeds is sold on the lease. The gas there was used for just the same thing I was just talking about. They used it to fire compressors, and they used it in a plant. And Hillcorp was not paying a royalty on those volumes. Plaintiff said you got to pay royalties on those volumes. Carl versus Hillcorp said, no, that is a deductible post-production cost. deductible post-production costs incurred by the lessee are not just limited to dollars and cents, but it can also be limited, it can also apply to volumes of gas that are used for the purposes of marketing that gas. And therefore, in Carl versus Hillcorp, under that lease clause, it was a deductible post-production cost. Randall, different story. Randall, gross value at the point of sale. Gas, remember, was sold at the tailgate of the plant in that particular case. Gas was used for compression. Gas was used for in the processing plant. A royalty was owed on that gas. The court got into the no deduction clause, but the fact of the matter was that gas was used off the lease. They were supposed to get gross value for it at the point of sale, and there was no deductions that were allowable either under the express terms of the lease or under the no deduction clause. So therefore, a royalty was clearly owed on that gas. We'll visit a little bit about oil royalties. How much time do I have? Okay. I want to speed through this. Most common oil royalty clause is an in-kind royalty clause. The oil is to be delivered at the wells with the lessor's option into the pipelines to which the wells may be connected. That is an in-kind at the well royalty. So if you're going to be paying royalties on that in cash, which is what 99% of the people do, it is at the well, and the rules of deductibility apply. Implied covenant, very quickly. Texas has a vast body of implied covenant law in the oil and gas space. The implied duty to market basically says you're supposed to get the best price reasonably obtainable. There's no implied covenant in market value leases. That's the Izagiri versus KCS Resources case, 2001. And in most proceeds leases, I would submit to you that the implied covenant is applicable, but our Supreme Court says, well, there can be some circumstances where it is not. That's for another talk or a paper. What is the analysis? The analysis is what would a reasonably prudent operator do under the same or similar circumstances at the time the sales contract was signed. Now, where do we get into this litigation? We get into this litigation quite a bit when we have a very old contract. Contract life of, most of these back in the 50s, 60s, and even in the 70s, those contracts were life of lease. Life of lease. So you're never going to get a better deal because now the gas is committed. And if there is an implied covenant issue, the way the analysis works is, did the operator act as a reasonably prudent operator at the time they signed the contract? Not whether or not they could get out of the contract later, not whether or not there's a better deal 10 years later or 20 years later, but whether at the time that they signed that contract, did they act as a reasonably prudent operator? The contract in the Helen Jones Foundation case, I believe, was signed in the 50s. And that case had a lot of other particular issues in it, but that was the lens from which the jury must view the conduct of the operator. Very quickly, inherent affiliate sales. Just for the plaintiff's lawyers out there, I got to say this: affiliate sales are inherently suspect. That means we got to take a look at them. But here's what Helen Jones teaches us in the other cases, and I'll end with this. The analysis in an affiliate sale isn't, oh my gosh, King and Keffer are affiliates. Therefore, they can do whatever the heck they want to, and I should get the benefit of that. That's not the analysis. The analysis is, okay, they're not affiliates. What would a reasonably prudent operator achieve in an unaffiliated transaction? That's the prism that you're looking through. And the royalty owner, the fact that they are saying, well, I'm not sharing in all the benefits between the affiliate transaction, that is no evidence of a breach. These cases generally say, well, the affiliate your deduction should only be at actual cost, gathering and processing. That theory, as stated, is wrong as a matter of law. The burden of proof on the plaintiff is to say, in an unaffiliated transaction, would a reasonably prudent operator be able to obtain a contract where they got gathering and processing and treating at cost with a third party? It's out there, but good luck with that one. I don't know of any midstream company that doesn't want to make a profit on its operations. But that's the standard in Texas. Conclusion, what folks need to understand is when it concerns royalties and just the oil and gas lease itself, lessors and lessees are not partners. We ain't in love. You're not my brother. You're not my sister. You're not my neighbor. You're my business counterpart. You sold those minerals to me. I'm the lessee. And you got a right in exchange for a right for a royalty to be determined based upon the terms of the contract. And what I hear, quite frankly, all the time with affiliate sales is the argument that it just ain't fair. That is legally insufficient for the reasons I just stated. You got to show that there was a better result. I appreciate your time. I covered a lot of ground. Be happy to take any questions.
We did have one question from Zoom from Mr. Brad Moody. How do you reconcile the Texas Supreme Court's pronouncements that it will give effect to the royalty clause as written with its continued reliance on ignoring language in the royalty clause that it deems to be surplusage? Isn't the concept of surplusage only applied after the court has tried and failed to give meaning to the language in the context of the contract as a whole?
My submission to whoever asked that question is that they have given meaning to the contract. They have looked at the contract. They have said the royalties be paid based upon point of sale, proceeds at the point of sale. That by definition means there can be no deduction in the payment of those royalties from the point of sale. So the fact that the royalty, those clauses will say you cannot deduct gathering, processing, and all these other post-production costs. If my point of sale is downstream, and if all it said was proceeds at the point of sale, the things that are mentioned in that no deduction clause cannot be deducted, period. That is the part that people get confused. Where you cannot deduct post-production costs from the revenue or from the basis that based upon the valuation method at the location of valuation. You cannot do it. That's what heritage stands for. That's what Shepherd stands for. That's what all these cases stand for. So it is surplusage, and it does not ignore the lease language. Matter of fact, it enforces the lease language. And if there's anything that we could say about the no deduction clause in that context, is it is clarifying exactly what the oil and gas lease already says. Anything else?
That's it. Thank you, Mr. King.
Thank you.
Okay, right now we're going to take our lunch break. At 12 o'clock, we'll be having our student speakers. And then at 12:45, we'll have Michelle Sears speak. And we have coffee replenished. So if you need some more coffee, we have some for you. Thank you, guys. Food is right outside.
Green? Yep. All right. We're going to go ahead and get started back. This year, we're doing something a little different. We have 3 student speakers here to talk about their comments that have been published on our Energy Law Journal and through Law Review. So we just wanted to allow them the opportunity to come and speak about what they wrote and kind of highlight their accomplishments. So our first speaker is David Berta, also known as Canada, as all of us call him, because he is from Toronto, Canada. He did his undergraduate degree at the University of Toronto, and he got his master's at Niagara University. He also had a previous career in professional athletics where he played and trained professional hockey players in the Northeast. Following his athletic endeavors, David worked in the energy sector in Canada with his father for Canadian Appliance Recycling Enterprise, where he assisted in applying for and managing various government contracts across Ontario and Canada. The main focus of these initiatives being reduction of communities' carbon footprint by implementing energy efficient measure with a given region. At Texas Tech School of Law, David is pursuing his JD with an energy law concentration and is expected to graduate this May of 2026, or next May. He is going to be headed to Midland to work for Glenn Harwood at the Midland County DA's office. He is also the lead article editor of the Energy Law Journal here at Tech, the president of our Energy Law Interest Group, and he got his comment published, or the comment will be published this December in the Energy Laws Journal. So I'll turn it over to David.
Good. Can everyone hear me? Okay, let's see if this works. Oh. Really press it. Okay, perfect. No. How to work? Okay, so I just want to thank Charlotte for the brief introduction here, and I want to thank Professor Keffer and everyone for letting me do this. I know I'm probably the speaker he's most nervous for to present here today, so I'll preface with that. So I thought, what better individual to talk on potential foreign policy implications than a foreigner himself. Seeing as I'm from Canada, I can look at this from kind of a 50,000 foot view. So I published my comment on the Inflation Reduction Act and the shortcomings thereof. So the title of that is A Race Against Time, amending the Inflation Reduction Act to safeguard energy, economy, and security. So a brief history on the Inflation Reduction Act, not that I need to bore you with these details because most of you have probably worked with it in the past, is that it was signed into effect in 2022 by the Biden administration. This act provided over $370 billion in tax credits for renewable energy projects, and this extended well through the 2030s. The main goal was to lower energy costs by increasing energy availability and making it less expensive for consumers by increasing competition within the energy development sector. So, but did it do this? In short, no, not really. This truly had a negligible short-term effect, and given the big, beautiful bill signed into effect in July of this year, the potential long-term effect is likely to never be fully recognized given the rollbacks of the effective dates of the incentives. Further, let's call it what it is. The Biden administration took office in January 2021. Looking at this graphic from that point until the end of 2022, inflation was generally out of control. Even if this act did, in the future, have a positive impact on curbing inflation, it would be akin to one of us purposely breaking a plate and then wanting our praises to be sung for picking up the pieces off the floor. It just doesn't make a whole lot of sense. So just to clarify, I'm up here talking about inflation rates and the economic impact of federal legislation. But folks, I want to be clear, I'm not an economist, barely count to 10. But I'm going to be talking about the safeguards that I think should be in place when we bring out these tax incentives in the future. So talking about my article a bit, back in the summer of 2024, I noticed a discrepancy within the renewable energy sector, which prompted the direction of this comment. We had all these large-scale wind and solar projects being built, like the ones out in Nolan County, but the names of the companies undertaking these projects were none that I recognized. Looking into it further, I could see that there was such a large influx of foreign companies seeking to have a stake in our energy sector, and I couldn't help but wonder why this was the case. Looking into it further, I realized that these foreign entities were drawn to this great nation because of these incredible tax incentives we're offering. Now, my article targets the Inflation Reduction Act and the energy sector. This is an oil and gas, energy sector, CLE after all, but I truly believe it is extremely applicable to other pieces of legislature that look to stimulate economic growth in other areas as well by tax incentives. Albeit the one big beautiful bill, as I mentioned, has addressed some of the concerns I'll address in my comment itself. My article proposes two major amendments to the Inflation Reduction Act that I believe can be translated to other tax incentives passed in the future. The first of which is to strictly protect our critical infrastructure with heightened CFIUS oversight, and the second is to actually prioritize American businesses taking advantage of these tax incentives. So you're going to ask me, what are these gaps you're speaking of? These tax credits are not solely available to American businesses. All the time, international businesses are taking advantage of these incentives. And yes, we have the Committee of Foreign Investment in the United States to watch out, but they have to balance the economic interests as well. So there's pressure from the back end for expedited review of foreign entities looking to do business in the United States. Here's my major concern, though. A couple of days ago, my colleague Chase Crouch put me on to ERCOT. Okay, I look at the website, and around 40% of the load at one point during the day was being sustained by both wind and solar. Now imagine this room, and imagine 40% of this room. So maybe this section right here. This represents 40% of the supply on the grid right now. Imagine 40% of this room is no longer available. What does that do to demand? What does that do to the price of electricity? It would pretty much simulate the effects of Winter Storm Uri that you guys experienced years ago, where the spike in per kilowatt hour had devastating effects on the local community and economic impact across Texas. So what sections of the Inflation Reduction Act in specific am I referring to here? Section 13101, the extension and modification of the Renewable Energy Production Tax Credit. Section 13102, extension and modification of the Energy Investment Tax Credit. 22001, additional funding for electric loans for renewable energy. And 22002, the Rural Energy for America program. So you're asking, how am I proposing we strengthen the Act? So I want to take a two-pronged approach here, the first of which is to strengthen CFIUS oversight, as mentioned, and the second is to prioritize American ownership and American utilization of these tax incentives. One of the most critical solutions to address the challenges posed by the Inflation Reduction Act is to strengthen the oversight role of CFIUS and implement stricter limits on foreign ownership of critical energy assets. This approach would involve enhancing CFIUS's authority to scrutinize foreign investments in renewable energy projects, particularly those involving entities from countries with potential national security implications, such as China. Strengthening CFIUS regulations to explicitly prohibit investments from countries like China in the U.S. wind and solar farms would effectively mitigate national security concerns without hindering the growth of the renewable energy sector. By targeting investments from specific countries with no national security risks, the United States can protect its critical energy infrastructure while still encouraging investment from the trusted allies and partners. So on these slides here, you'll see the language that I'm proposing we utilize. I'm not going to bore you to death by reciting all of that. If you really feel that you're passionate about this, feel free to read my comment. As Charlotte mentioned, it is coming out in December for our fall of 2025 issue. I would be very grateful if you guys checked it out. So that's the first amendment I'm proposing. The second of which is that we must acknowledge America's economic dependence on foreign investment. However, if American businesses are truly meant to reap the benefit, we also need to implement some protective measures regarding these tax incentives. Putting it plainly, if only the large-scale corporate giants are supposed to be players in the energy sector, then we would not have a privatized energy sector to begin with. Interestingly, foreign businesses have emerged as significant beneficiaries of the Inflation Reduction Act in the United States. The incentives provided by the Act have stimulated substantial investments in clean energy technologies from overseas firms, according to the Wall Street Journal. This further prompts the question, who intended to benefit from the Inflation Reduction Act? The Biden administration claimed the Inflation Reduction Act's intent was to lower costs for millions of Americans while addressing the climate crisis and creating jobs. But were everyday Americans whom the act was to benefit aware that we were doing so at the expense of losing control of our own resources and our own critical infrastructure? Likely not. As suggested by the debate topics and the outcome of the recent presidential election, therefore, it is imperative to provide protection to those hardworking U.S. entities and ensure that these valuable grants and loan forgiveness programs actually prioritize American businesses. As mentioned, this is the language that I'm going to be proposing. If you really want to read it, please go check out the issue in fall of 2026. As mentioned previously, I believe it's coming out in December of this year. So, moving forward, as I mentioned, this comment was drafted back in last January and February of 2025. One big beautiful bill was signed into effect in July of 2025, and it actually addressed some of the concerns I was discussing pertaining to national security. The one big beautiful bill looked to accelerate the expiration and phasing out of these tax credits by putting dates instead of in the 2030s in 2026 as well as 2027, as well as it actually went and addressed and prohibited specific foreign entities from owning and gaining a foothold within our energy sector and within our critical infrastructure. So, with respect to these foreign entity restrictions, the Act limited foreign investment involvement in the United States, clean energy projects, making many tax credits unavailable to specified or foreign influenced entities. Specified foreign entities include Chinese military companies and entities flagged under national defense and security laws, and the definition of foreign influenced entities are those partially owned or controlled by specified foreign entities, extending restrictions to indirect ownership and influence. What I'm proposing here, folks, is more strengthened CFIUS oversight to look at the multiple layers of ownership. We all know within business that you can have an LLC on an LLC on an LLC. You all seen the movie Inception? It's like that. You're going a dream within a dream within a dream. There's layers to this, right? I want CFIUS to have the autonomy to really put the brakes on some of these foreign investments and to go and really look and make sure that we know who's running the show with respect to these potential foreign investors. So I told you earlier I'm not an economist, but I might be able to tell the future, okay? I kind of predicted the, if you will, the one big beautiful bill and how they structured their regulations with respect to foreign investment. So that being said, I want to emphasize how real this threat actually is. As many of you have sat here and now think that I'm talking in vast, drawn-out hypotheticals, and you probably think I should be wearing a tin hat and, waving a conspiracy theorist flag. The threat here is very real. Just this past summer, there were articles published about rogue communication devices found in solar arrays we were receiving from China. I see a couple nods in the audience. We've seen this, correct? So the threat is very real. We cannot lose control of our critical infrastructure. If we do, we leave ourselves vulnerable to someone hitting the switch, deleting 40% of our grid's load, and all of us sitting there being like, oh, I wonder why the megawatt or kilowatt hour price is in the thousands at this point in time. We need to be preventative about these measures. This is a silent battle we need to continue to fight. I want to thank you all for your time here today. Please feel free to read my article. It's coming out in December of this year. We have a really great group of staff editors working on editing it right now. And please, if this is of concern to you and this piques your interest, please feel free to write your congressman. That's the only way we can get things like this changed and implemented so that we can protect critical infrastructure within this country. Thank you.
All right, everyone. Our next speaker is Jonathan Gabehart. Jonathan is a little bit more local than David. He's from Big Spring. He did his undergrad here at Texas Tech. I actually got the pleasure of being on an organization with him during undergrad. So I've known Jonathan for several years, and he's a dear friend of mine. Jonathan will also graduate next May of 2026. He is the editor-in-chief of the Texas Tech Law Review. And after graduation, Jonathan will serve as a judicial law clerk for the Honorable James Wesley Hendricks of the United States District Court for the Northern District of Texas for the year of 26 to 27. When Jonathan finishes his clerkship, he will be moving to Midland to join Kelly Hart and Hallman and work in oil and gas litigation.
Good afternoon. Thank y'all so much for coming and attending. Really, we put this on because the school tells us to, but it's really not possible without people coming and attending. So students in here, everybody, thank you. I'm going to talk about a topic today of produced water, which is something that I'm sure everybody in here has had some exposure to. It's a critically growing issue that I feel like every speaker that Professor Keffer has come to the law school mentions in some regard or another. So my comment specifically was to target produced water and what's going on with it, but also to concurrently look at Texas's current water situation and the droughts that Texas has faced. And so with the title Water, Water Everywhere and Not a Drop to Drink alludes to old sailors stuck on a life raft in a sea of an ocean and dying of thirst with all this water around them that they can't drink. So that's kind of akin to what Texas is facing right now. So it's hard in a doomsday-centered society like we have that everything we hear about is the end of the world and you have to pay attention to it right now. But water scarcity is something that seriously is kind of on that level that kind of flies under the radar a lot of times. Any student of history knows that many wars have been won and lost over water. So looking at Texas specifically, water demands are outpacing supply, and that's just a statistical fact. We know that population growth is booming exponentially too. I'm sure a lot of people have seen California license plates, maybe a few too many to their liking, but it's just a reality that a ton of people are moving to Texas while supply does not increase at the same rate. And so one of my points here is talking about the drought of record. That's a statistical metric of a drought that occurred in Texas in 1950 that Texas water planners then use as a metric for if that kind of drought occurred again, what would we do for planning into the future? And so seeing that if that had happened in 2020, we would have faced an immediate need for 3.1 million acre feet of water. That's a serious concern because year by year, really the only way that water planning is done is based on projected rainfall and growth. But other than that, we can't just create water like any other kind of resource. This is a chart indicating this from the Water Development Board. And population growth is just extended, or is planned to just increase exponentially through 2070. And so this is something that we have to address now, and honestly, the sooner the better. So now flipping to the other side of the coin, produced water, this focus. Everybody in here, I'm sure, has felt a earthquake that they figured out wasn't attributed to a produced water disposal. So a lot of students in the room or people that aren't familiar with oil and gas may feel an earthquake and see on the news that it's due to oil and gas activity and think that it's attributed to fracking, and that's actually incorrect. What happens is produced water is a substance that's in the ground with hydrocarbons that are desired, and when it's drilled into, produced water is going to come up with it whether operators want it to or not. If they could, they absolutely would leave it down there, but it's a waste, a byproduct of oil and gas development that is highly saline and filled with a lot of other chemicals that make it really undesirable for really any use. I've heard people say that it shouldn't even have water in the name. That's kind of a misnomer. But the amount of produced water that's created with the advent of fracking and increased oil and gas production just increases. So my comment explored, looking in Midland and Delaware basins, the daily equivalent of 12 million barrels or 504 million gallons daily is an exponential problem that has to be addressed. So a lot of what is done is disposal reinjection. So a formation is targeted for operators to put that water and that substance back in the ground, essentially out of sight, out of mind. And it's when those fault lines are essentially lubricated with this produced water that the induced seismicity occurs. And alongside that as well, zombie wells. I'm sure people have heard of Encino Ranch and Lake Bomer, these areas of the state that abandoned wells have had, they're still tapped into those formations that maybe the operator injecting that produced water doesn't know about is still tapped into there. And now they're sending produced water in, and it's going to go via the path of least resistance and come back to the surface, leading to these lakes of produced water that highly saline, kills anything it touches, ruins pasture lands. Serious concern. So now in looking to an alternative, so what's an alternative to disposal reinjection is beneficial reuse or recycling. The industry term is beneficial reuse, so that's how I'm going to address it. But beneficial reuse is taking that water and actually doing something with it. So either applying it to sending it to a facility, cleaning it to some degree, to then be able to apply it to an agricultural context, maybe an industrial context, using data centers, whatever else. But the problem is that it's super expensive, obviously, especially compared to just disposing of it. So that's what we're seeing here, these figures that I give are pretty rough estimates. A lot of it is dependent on where it's at in the state, but with disposal reinjection at 40 cents to $2 a barrel, as opposed to beneficial reuse starting on the low end at $2.50 a barrel, operators are just going to have to do the most economic thing possible. And that's understandable, but trying to look at maybe some more of the methods out there for how can we lower that cost of beneficial reuse to make it an economic option, because this is something that Texas needs to address. So, and this is going along with all of the freshwater needs that I've been talking about. So the focal point is water midstream companies. And so they're the ones that, for the most part, operators don't actually take on the disposal or treatment of their own produced water. Like the oil and gas industry as a whole, most of it is piecemealed. Every step of the way is usually taken by a different entity. And so the operators that their goal is getting the hydrocarbons out of the ground are not going to be the ones dealing with the produced water. So it's targeting these specific water midstream companies. So my proposed solution is a franchise tax exemption that would help make beneficial reuse economically viable as soon as possible. So looking at Chapter 171 of the Texas Tax Code, which deals with franchise tax exemptions, this is kind of generally looking at business tax. It's not a tax that's levied on consumers or in any other regard. I have a slide here that is from the Texas Comptroller of Public Accounts that kind of goes over the franchise tax in general. And so why are we looking at targeting a franchise tax exemption specifically is because it's one that Texas won't feel too large of a hit in doing, but is something that historically Texas has done to incentivize these acts. So, looking at these numbers, a lot of it is kind of arbitrary for us, but kind of seeing the impact overall, we have to remember this is a limited scope, so this isn't going to be some kind of hit that Texans are going to feel from their tax dollars. And so I talked about a precedent that some of these have something that we've looked at in the past. Two of these specifically are both prospective and remedial in nature. So Texas in the past, for solar energy device installation, the legislature has granted a tax exemption for those corporations specifically in installing them. The same goes for sludge recycling, which is from corporations involved in recycling sludge, which is a byproduct of wastewater treatment. That's the remedial side that, kind of looking at produced water would be akin to. And there's also some funny other parallels with sludge recycling that have been done in the past. Like there's applications of sludge once it's recycled to be used in the soil to provide benefits of nutrient recharge. But there's a lot of fear for food chain crops. Obviously, if it's sewage water that's being used and then we're going to put it in food chain crops, does anybody want to be first in line to eat that? Like probably not. A lot of the same challenges exist for produced water. Even if we can clean it up enough to be able to readily apply it to your crops, not many farmers or ranchers, I think, are going to be wanting the first to test that out and see what happens. But it's going to kind of become a push to shove type situation. So this is mostly just for your maybe being able to look at later. It mostly mirrors the franchise tax exemption for the solar companies in looking at beneficial reuse being an offset of current uses of potable water. So most of fresh water in Texas that is used in agriculture. Even in the Permian Basin, 75% of the water usage is for agriculture. So if we can take that water, the produced water and use it to clean it up and offset other uses of potable water, that would then free up more for the rest of Texas to use. I had interviews in writing my comment with the directors of the Produced Water Consortium. There was a switchover. Professor Keffer mentioned Dr. Walker is going to come give a speech later. And in talking with him, he said, with enough time, effort, and money, produced water as it comes out of the hole could be taken to the point of drinking water, but the hurdles that you have to get over for all of the environmental questions and then actually giving it to the public is just probably insurmountable, and definitely from an economic standpoint is not doable. So trying to find offsets where we can free up other water is going to be the ideal. This is pretty much all what I was saying exactly, and especially in this area with Ogallala and other areas that are feeling the pressure. El Paso, this is something that's very on the minds of a lot of people and civic planners. Something else just to throw out there is that I would not ever try to make the claim that without these kind of tax incentives or other incentives that it would survive a market analysis normally. This is a common criticism of wind farms and these other things that have these massive tax incentives, that if we take those away, nobody's going to want to keep doing this. And I agree. But the problem is that analysis is not applicable here, because if the government starts truly regulating how much water you can use by fining you heavily or actually turning off your water, there could be rioting in the streets for real. So a funny example, talk about use of AI. AI made this for me. I think it's kind of evident. But a common, maybe a thing, you're on a deserted island or in the middle of the desert dying of thirst. Who's going to go to the water versus the gold bars? It's like water is a necessity of life. Of course you're going to go to the water. Let's see here. So now in thinking about the secondary benefits of this, so I talked about the induced seismicity and zombie wells. Those things are essentially being alleviated at the same time. So it's not killing two birds with one stone, but like 20. So it reduces the total amount of produced water that needs to be disposed of, mitigates the seismicity and zombie wells, and then also kind of helps foster this position that Texas takes normally with trying to fund research and development for something, because once produced water goes down whole, it's gone forever and it's not going to be used again. And that's the same that goes for fresh water that's used in oil and gas operations. If you have a water flooding event or a frack job that's done with fresh water, once that water goes down whole, for the most part, it's never going to be seen or used as potable water again. So overall, the aim that I'm trying to do, if I could snap my fingers and have something done, it would be trying to incentivize a secure water future for Texas. Nobody wants to live in a world where water is a question mark. That's something that I think a lot of us take for granted where we live. I definitely do. I accept when I turn on the faucet, water's going to come out of it. And that's not just something that happens magically, but a lot of planning and work goes behind that. And that's something we can all think about and play a part in. So as a final closing thought, thinking of, back on this instance again, I ended my comment with the same quote: water, not oil, is the lifeblood of Texas. If Texas wants to have a secure future in general, we have to focus on potable water and securing that for all Texans. Thank you all.
All right. Our next student speaker is Cole Palmer. Cole Palmer is originally from Roswell, New Mexico, but he came over to the great state of Texas for his undergrad here at Texas Tech, and is now here at Texas Tech School of Law. He will also graduate May of 2026. Cole serves as a comment editor for the Texas Tech Law Review, and he is also our student publication editor for the Energy Law Journal here at Tech. After graduation, Cole will be joining Bigby and Curtis as an associate attorney here in Lubbock. Today, Cole will be presenting on his comment, and his comment actually just recently got published in the Journal of Energy Law Practitioner for May of 2025, and the copies of that are actually outside. So if you really like his presentation, you can grab a copy and read his comment.
Thanks for the endorsement. All right. Can everybody hear me? Working? Yep. Okay. So as you heard, my name is Cole Palmer, and today I'm here to talk to you about wind severance. But before I do that, I just want to kind of echo what some of the other speakers have said and thank everybody for coming today. It really does mean a lot. Texas Tech Law Review and the Journey of Journal of the Energy Law Practitioner have worked really hard. Specifically, Charlotte has worked very hard on putting this all together. So we really do appreciate you being here. So today I'm going to be talking about my comment in which I argue that wind severance is possible. Specifically, I argue that wind is a property interest that is capable of ownership independent of surface ownership. And so to kind of give a little background on the issue, I think a good starting spot is the beginning of federal investment, or really the catalyst for federal investment in the wind industry. In the 1970s, due to the OPEC embargo on oil and gas, there was a shortage in the United States, and the federal government began to look into energy production alternatives. In doing this, they invested millions of dollars into wind energy and continued to incentivize and encourage the development of wind energy. Eventually, this led to the introduction of the production tax credit, or the PTC, which I'll spare you the boring tax, part of this. But suffice it to say that PTC encouraged developers to go and construct wind farms, and it encouraged them to do so quickly. And in Texas specifically, that led to kind of a boom in the industry. Wind farms started to show up really all over the state, a lot of them in South and West Texas, and pretty soon it became pretty clear that wind had value to Texas property owners. And so that's really the core of my argument, is that the value that's been given in the marketplace to wind energy is what justifies it holding its own as a property interest. And so to date, the only states that have answered the wind severance question have answered it in the negative. You have states like Colorado and Oklahoma that have legislated full bans on wind severance to the point where it's just impossible. And looking into the reasoning behind these prohibitions really fall into one of two major camps. The first one being a complexity argument. And the argument there is essentially that developing a new body of law to govern wind law would be unduly burdensome on courts and legislatures, and they also raise the fractionalization issue that's been persuasive through mineral interests. The second big drawback on the severance of wind rights is generally this fear that a severed wind right will unduly burden the surface estate. And so on the other side of that, the general concepts in favor of wind severance are property and contract law, just general principles like the freedom of contract, the idea that property should be put to its best and highest use, and the idea that transferability is necessarily inherent to fully exploiting any natural resource. What my comment adds to this is it argues that not only are those justifications for allowing a severance of wind, but the inherent value to landowners and to property owners is another justification for allowing the severance of wind rights. And the meat of my argument goes into mineral jurisprudence and applying that to severed wind rights. And I think that answers both the complexity and the surface arguments pretty well. And so to kind of get into that, in Texas, it's pretty well defined that a mineral interest consists of 5 essential attributes, being the right to develop, the right to lease, the right to royalty, the right to bonus payments, and the right to delay rentals. Largely, I feel that these rights are transferable and applicable in the wind industry. In the wind context, the right to develop will operate pretty similarly. It's going to authorize the wind owner or wind lessee to have the authority to enter on property and to do all those things that are reasonably necessary to produce wind energy. And as a part of that, kind of as an anti-complexity argument, is that will actually reduce the complexity of the wind lease document itself. Having a defined right to develop that necessarily includes many of these easements that your typical wind lease is granting, like for met towers and wind turbines, is going to reduce some of the cost and complexity to draft a wind lease. Moving into the right to lease, also termed the executive right, that's going to be the method for monetizing the interest as it is in the oil and gas industry. But another benefit that comes from utilizing mineral jurisprudence on the executive right is that Texas courts have consistently held that executive mineral owners owe a duty of utmost good faith and fair dealing to non-executive mineral owners. When applied to the wind industry, the practical effect of that is going to be to make it so that wind developers are not going to wind owners rather, would not be able to arbitrarily deny leases or otherwise obtain benefits that they do not also obtain for non-executive owners. Moving to the right to royalty, early wind leases royalty was pretty much exactly based off of oil and gas law. Landowners sought to negotiate cost-free royalties, and they structured them pretty similarly as well. Today, it's kind of grown apart from that. Most wind leases today typically include a minimum royalty provision, which essentially provides that your landowner is going to get paid the highest of generally 3 different options: the per acreage payment, a per megawatt installed payment, and then finally the general percentage of gross production, which is more in line with the mineral royalty. Now, despite this difference, I think the mineral right to royalty still applies to the wind industry in just the same context. It's still going to entitle the owner of the right to receive the compensation attached to that royalty, and it's also going to allow the transferability of the royalty interest, whether that be part or all of a royalty, whether the royalty be connected to a specific lease or in perpetuity. It'll grant that free right to alienate those rights. And then moving into some of the less applicable ones, you have the right to bonus. This isn't as applicable, especially in the modern wind lease. Early wind leases will often contemplate a bonus payment for signing the lease, but generally modern wind leases today won't contemplate any kind of consideration merely for signing the lease. Though, of course, if a wind owner were to negotiate that, the right just makes it clear that they would be entitled to that compensation. The right to delay rentals is kind of similar in that it doesn't have a true counterpart in the wind industry. Wind leases are, to my knowledge, never conditioned on production, but in theory, if a wind owner had the negotiating power to draft a lease that was conditioned on production and it otherwise contained provisions providing for payments in lieu of production, it would operate similarly and it would just entitle the wind owner to that payment. Now, one area that Texas law does leave a little to be desired in the realm of transferring jurisprudence to wind law is the nature of the interest itself. In Texas, when a lessor and a lessee enter into an oil and gas agreement, the lessor conveys to the lessee a fee simple determinable title in the minerals. That's directly to the minerals. In contrast, this doesn't seem, and this is really based on Texas ownership in place theory, meaning that they own the minerals before production. This is a little harder to equate to the wind industry because while wind and oil do both move throughout a property, wind, in addition to having that quality, is also intangible and invisible. And so it doesn't match up with the ownership in place theory quite as well. However, if you look outside of Texas, still within the realm of mineral jurisprudence, you can find an acceptable answer. And that other jurisdictions sometimes term the interest as I'm going to butcher the pronunciation, but a profit, a prendre. And the real difference there is that represents a right to go and produce the resource, and it'll be owned once it's produced, rather than directly owning the resource. And I believe that meshes with the qualities of wind, the nature of the resource, a little bit better. And another thing I like about it is it provides a clear route to kind of attacking the fractionalization issue too. Some jurisdictions, like Louisiana and Tennessee, will use a terminating interest. Essentially what that is when an interest is severed, if it's subject to a period of non-use for a prescribed period of time, generally 20 years from what I've seen, the interest will then become vested in the surface owner. So in the wind context, if that's applied, then the fractionalization concerns can be a little bit stymied because if you're either forwarding the energy policy by entering into a wind lease and going ahead and reaping the benefits of the energy lease in the community and for the owners personally, or if you're not using it, it won't continue to become fractionalized because after a specified period of time, the rights will vest in the surface owner or surface owners. Okay, and so I think those are really the arguments that kind of go against the complexity argument. It's a matter of judicial economy that we have a very well-developed body of law in the mineral context, both inside Texas and outside of Texas, that could be fairly easily adapted to regulate wind law without having to develop, as some critics say, a whole new body of law. Moving into the surface, the burdening the surface estate argument that often detracts from wind severance, Mineral jurisprudence provides some answers there as well. The first would be the accommodation doctrine, which broadly provides that a surface owner's pre-existing use cannot be precluded or substantially impaired by the lessee's use when the lessee has an alternative and the lessor does not. And now the Supreme Court of Texas has already indicated that the accommodation doctrine is applicable outside of the mineral context. In Coyote Lake Ranch versus City of Lubbock, a Texas Supreme Court case, the court applied the accommodation doctrine in a dispute between a severed groundwater estate and a surface estate. Then in Lyles versus Midway Solar, while the court ultimately passed on the issue as premature, the court indicated that the accommodation doctrine would also be the correct tool to resolve a dispute between a solar developer and a mineral owner. Next, as another kind of counter or rebuttal argument to the burden on the surface estate is that accommodation agreements, their use could probably be expanded. Traditionally, these agreements have been contemplated between solar or renewable in general and mineral developers traditionally, but they could be expanded to include surface owners, especially where the estate is severed. That could give the surface owner at least some level of control over the placement of certain facilities and could potentially contemplate surface damages as well. And that leads into surface damages, which I think is the last kind of argument that you can propose against burdening the surface estate. And what's unique about Texas is that we don't have required surface damages in the oil and gas context. But I think despite that, there's still a way to justify them in the wind context through history. Now, historically, oil and gas leases never really contemplated surface damages in the state of Texas. But wind leases currently do and typically always have, whether that be payments for crop damages, livestock, general land damage, or payments for the loss of use of land, as you see for substation and O&M building payments. There's a historical underpinning to applying surface damages in the wind context. And I think that argument, coupled with the fact that wind energy has the potential to leave a larger blueprint than mineral development, serves as some justifications to go ahead and impose a statutory surface damages in the wind context. As a final argument in favor of wind severance that I wanted to bring up is this idea of reliance in Texas on wind severances. So I took wind and solar law with Professor Wetzel here at Tech Law, and one thing that was really illustrative about that class is Professor Wetzel was able to share with us some of his personal experience and knowledge drafting wind reservations for his clients. And then this past summer, while I was clerking in Midland at Davis, Gerald & Kramer examining title, I ran across a couple wind reservations. So it just really instilled in me that this is an issue in Texas, and if Texas legislates the other way, i.e. prohibiting wind severance, that it will have real ramifications on Texans. So in conclusion, my comment really focuses on this idea that since value has been attributed to wind in the marketplace, that is an additional justification for recognizing it as a property right. And mineral jurisprudence, both in and outside of Texas, offer kind of a blueprint to developing the rights, especially when severed. Thank you.
Thank you, Cole. And be sure to grab the latest issue of Journal of the Energy Law Practitioner to read Cole's article and all the articles in that issue. And Professor Wetzel, I know, is watching from home, so I hope he enjoyed the presentation. Our next speaker is Michelle Sears. Michelle Sears is a partner at Holland & Hart in Denver, Colorado. There, she specializes in resolving complex disputes for oil and gas and natural resource clients. Her litigation work covers virtually all aspects of the energy industry, including disputes between working interest owners and royalty underpayment litigation. Moreover, she has extensive experience in defending oil and gas producers in class action lawsuits. Her work has led her to be included on Best Lawyers Ones to Watch in America for energy law, oil and gas law, and environmental litigation. Today, she'll be discussing oil and gas royalties in New Mexico. Please welcome Michelle Sears.
I just need to put I don't think my mic is on. Can you all hear me? Yes. Okay, great. Okay. Okay, great. Thank you. All right. Another round of exciting royalty law. I know you guys can't wait. Hope you don't fall asleep. I am going to give a big shout out to Jeff King because he did a lot of underground groundwork that I'm not going to have to recover. So you guys should be happy. But I think a lot of what he talked about in terms of just how we value royalties, the prices, how gas is sold, how gas is marketed, selling gas downstream versus closer to the wells, what we like to call a local market or in basin. That is going to be very relevant to what I'm going to talk about today. And again, I just want to thank you guys for inviting me to talk. This is super cool. I did not go to a law school where there was any discussion of oil and gas or minerals or anything like that. And so I think you guys have a really great program here. So like Marcus said, I do oil and gas litigation. I practice kind of all over the West. I practice in Colorado, Wyoming, New Mexico, Texas. I've done some work in Oklahoma, North Dakota. So really anywhere that there is mineral production. I'm going to talk to you guys about New Mexico royalties today, and I'm going to focus on just two main issues specifically in the class action context, because like Drew said earlier, we do not have much law in New Mexico State Court. And my husband and I had just finished a Mission Impossible marathon when I wrote this, so that's where the show me the money comes from. All right. So what are we going to talk about today? So I'm going to give you guys just a really brief overview of royalty valuation in New Mexico. Then we'll take a quick look at some considerations that are involved when you're litigating a royalty class action in the 10th Circuit. And then we're going to kind of get into what I'm going to call our royalty realities in New Mexico today. And we're focusing on two: the implied duty to market, which Jeff started to talk about at the end of his presentation. And we did not coordinate, but his presentation really worked out well for me. And then we're going to talk about this new surge in litigation that we're seeing in a number of jurisdictions, including New Mexico, on failure to pay interest on late payments, and you'll understand my air quotes in a minute. All right, so just basic overview. I'm not going to go through this in super detail, but like most states, including Texas, New Mexico recognized that royalties are creatures of contract, right? So the language of the oil and gas lease or the overriding royalty instrument, whatever instrument is giving rise to the royalty, is going to control how the royalty is valued. Unlike Texas, New Mexico sometimes follows the language. What New Mexico does, which is slightly different from Texas, is unless the lease actually says at the point of sale, it's going to be valuing the royalty at the wellhead. And so even if it just says market value, you assume in Texas that it says market value at the well. And that's because the royalty interest, right, it vests at the moment of production. So as soon as the oil and gas comes out of the ground, the owner has a royalty interest in that production. Now, in order to get to the wellhead value, we're going to use the netback method, which Jeff also mentioned. And what that does is it approximates the wellhead value by backing out those post-production costs, which I've listed here. So gathering, compression, dehydration, processing, marketing, transportation. You're going to have more types of post-production costs for gas than you are for oil. But the way the netback method works, you back those out of the price that's actually received by the producer, and that's what you value the royalty on. So key variables in New Mexico are going to be lease language, the price that's received by the producer, the cost to get the production from the well to the point of sale, whether there are any affiliate transactions involved. And similar to what Jeff said, affiliate transactions are still viewed with a kind of, we need to double check them, and there will be other considerations that come into play. And so these variables are going to vary, right, from case to case. So, went way too far. Oh no. Oh, you guys weren't supposed to see any of that. bad. Pretend you're act surprised and laugh when I show this. Okay. So what's a royalty underpayment claim? Jeff kind of mentioned this, right? So a royalty underpayment claim means that the royalty owner or the overriding royalty owner is going to claim that the lessee, which is often also the producer, has underpaid royalties either by deducting impermissible costs or by paying on an amount that doesn't reflect the true value of the production. And class actions are really common in the royalty underpayment world because the value of an individual owner's monthly royalty can vary depending on the productivity of their wells and how many wells they have on their property, right? So a royalty owner might have get $10 a month in, payment from an operator, but another royalty owner might get hundreds or tens of hundreds or thousands or tens of thousands of dollars from proceeds on production. And so the value of the royalty may not necessarily justify individual litigation in every single instance. And so plaintiffs' lawyers have recognized this, and they have brought a lot of class actions that attempt to ban these lessors together. And because of the Class Action Fairness Act, most of these are now brought in federal court. Even if the plaintiffs file in state court, the defendant will file a notice of removal to get it into federal court on the notion that federal court is going to be more beneficial to the producer, less royalty owner friendly. I don't know if that's really true. I actually don't think that's necessarily true, but I think it's kind of a, pick the best of both evils. But so a lot of the law that I'm going to be talking to you guys about today is actually federal court law, but it's under New Mexico. It's applying New Mexico law. And that's really where we're seeing a lot of the development in New Mexico when it comes to royalties. So I've listed the Rule 23, Federal Rule of Civil Procedure 23, which governs class actions here. I'm not going to go through every single one. But I think what's important to recognize is that the requirements like numerosity, typicality, adequacy, those are not going to be where the fight is. Same thing with superiority. The real fight is going to lie with commonality and predominance. And those are harder to prove in the royalty underpayment world because the leases, the marketability of the production, and also the damages are going to vary from owner to owner. And so I've listed here, these are really the three main cases from the 10th Circuit that have set the standard for commonality and predominance when it comes to royalty underpayment claims. They essentially say that the district court has to address any variations in lease language before the court will certify the class and show that common questions truly are going to predominate over individualized issues. The Harrell's LLC versus Chaparral Energy, which is often referred to as Naylor Farms, that case is important for what we're going to talk about later because what the court did there was it affirmed class certification based on a lease chart that the plaintiffs had put together showing that every single lease had the same exact language. And the court said that that was sufficient in order to show that common questions were going to predominate. And we'll see how this reliance on a lease chart gets a little bit twisted in more recent cases. All right, so let's turn to our first topic for today, the implied duty to market under New Mexico. So like Jeff was talking about, most jurisdictions, including New Mexico, recognize some sort of implied duty to market that is implied in every single oil and gas lease. And because the implied duty is exactly that, it's an implied covenant, it only applies in the absence of express lease language. And so that's where you're going to have potentially variations between class members if some of their leases negate or abrogate or modify the implied duty to market and others do not. Now, in New Mexico, this implied duty to market has been pretty limited. It has historically not been the same as Texas. It has generally been understood to all that it requires is to make diligent efforts to market the production so that the lessor can realize their royalty interest. And so essentially it just prevents inaction, right? The producer cannot sit back and do nothing. They have to actually market the production. And this limited duty was recognized by the 10th Circuit in a case called Elliott Industries versus BP American Products. which is from 2005, that case also said that including cost deductions as part of the royalty valuation under New Mexico law did not violate the implied duty to market, which again is going to come into play when we get into these recent cases. So, starting in 2016, we get a series of federal court opinions, all coming from Judge Browning, creating a pricing duty as part of the implied duty to market. And what he essentially has done has imported the highest reasonably obtainable price duty, or now literally as of 2024 and 2025, a variation on that duty into New Mexico law. This has been rejected by other judges on the federal district court in New Mexico. At least right now, it is only been applied by Judge Browning. It has not been reviewed by the 10th Circuit, but it's definitely something that we are paying close attention to in the royalty class action world, because we're also seeing these claims starting to be brought by plaintiffs in Colorado as well, and other 10th Circuit jurisdictions. So the first time we see this is in a 2016 opinion from Judge Browning in a case called Anderson Living Trust versus ConocoPhillips. I'm just going to call it Anderson Trust because we're going to go through a few different opinions from this particular case, which is where he's talked about this duty. And if you've ever read a Browning opinion, you know that they are very, very long. His opinions can go anywhere from 70 to 150 pages, so I'm going to do my best to give you just the highlights. So in Anderson Trust, the plaintiffs filed a class action complaint saying that ConocoPhillips underpaid royalties. There was a long procedural history, and what he's ruling on in this opinion in 2016 was a motion to amend the complaint. They wanted to assert a new claim that ConocoPhillips had sold their production to an affiliate who resold the production at profits that weren't shared with the royalty owners, and thereby by doing so, they violated the implied duty to market by not paying royalties on an arm's length sale. This allegation turns out to be factually inaccurate later on, but that was the allegation that they were making at the time. Now, they also said that the implied duty to market created or included a duty to seek the best prices and values obtainable. So again, going back to Texas, they're trying to import this highest reasonably obtainable price into New Mexico's implied duty to market. Now, rightly or wrongly, Browning granted the motion for leave in part, and he lets them pursue this claim that Conoco breached the implied duty by failing to sell the gas for the best possible price and paying royalty based on non-arm's length sales. And he gives us some contours of what he thinks this highest reasonably obtainable price, or HROP, if you want to make it easier for yourself, duty. He acknowledges that it's never been adopted in New Mexico. The entire opinion, if you read it, cites to Texas and Oklahoma law. And he says, though, that it's actually distinct from the implied duty to market the production and the duty to develop the property. He also says it's limited to sales price. He doesn't accept their argument that it's highest value. He says it's the highest price. And then he also says that it's the highest price obtainable under existing market conditions. So very similar to what the law is in Texas. He also says it's going to be evaluated under a reasonably prudent operator standard. So what would a prudent operator in the same situation do when marketing their production, and what prices would have actually been obtainable to that producer? And so even though he creates this new duty under New Mexico law, at this point, it's extremely fact specific, and you have to look at the existing market conditions and what prices would have actually been available to the producer when they sold the production and where they sold the production. All right. So in 2023, the parties are back in front of Judge Browning on a ruling for plaintiff's motion to certify the class. And in their briefing, they actually seek to certify a completely different claim. They go back to their value argument. They say that royalty has to be paid on the highest market value, not sales price, in the area of production, not where it was sold. And so the wells that we're looking at here are in the San Juan Basin. The majority of New Mexico's oil and gas production is not used in New Mexico and not sold in New Mexico. A lot of it is moved to downstream markets like California, Arizona, other places. And Browning rejects this argument here, which I think was correct. And he denies certification on the basis that individualized issues are going to predominate because he has to look at what the market demand was for gas at the time, what were the existing market conditions, and that's going to be a very individualized issue he's going to have to conduct basically mini trials of what was available. He also says that the plaintiffs haven't done their work to show that all the leases are subject to the implied duty to market. And so plaintiffs are very grumpy because it was denied. But they do not relent. So, all right, a year later, in 2024, the parties are back in front of Judge Browning on a motion for summary judgment. And this is the first merits ruling that we get on this issue because all the other rulings have been on pleadings, on class certification, which, while it may overlap with the merits, is not supposed to be an analysis of the merits. And in their motion, they press the same argument that Browning actually rejected at the class certification stage. They say that the implied duty to market requires payment of royalties on the highest net value that is obtainable for the gas. And in addition to that, they say that the highest reasonably obtainable price was the price that was available in the local market of the San Juan Basin where the wells are located. So I'm going to call this the in-basin price. Now, if a producer is selling gas in a local market, they don't have to pay as much, right, to transport the gas. If you're selling it further downstream, the cost of getting it to that downstream location is going to necessarily be higher. And so the in-basin price will automatically result in a higher net royalty because there are less transportation costs. And so even though his opinion in 2016 rejects this idea that the implied duty to market is based on a highest net value and thereby implicates cost deductions, he completely changes course in this opinion and grants summary judgment and holds that the highest reasonably obtainable price is determined using the gas's wellhead value. And so that's going to be identified through the netback method, so thereby subtracting costs from the price that's received. And so this combines this highest price duty with the highest wellhead value duty. And this is completely at odds with New Mexico law and prior 10th Circuit precedent that you do not have a duty to avoid cost deductions under New Mexico law. Okay, so when I read Browning's opinion, I literally had to read it like 4 times because I was like, what the heck are you saying? So I think this example might help us illustrate what we're talking about here and why the two things are not the same, which I think is key. So we're going to have 2 example wells. Let's start with number 1. And let's assume that there's 100 MMBTUs that we're selling. That's obviously an incredibly small number, but just go with me. And sales point number 1 is going to be an in-basin sales point, so in the local market. The price that we're going to get for that gas is going to be $3. So the price we're getting is $3. We're selling 100 MMBTUs. That would give us $300, right? The cost to get it to this local market is only going to be 50 cents per MMBTU. And so using the netback method, the wellhead value that we get to is going to be our $3 price less the 50 cents in transportation to get to a wellhead value of $2.50. Okay? Well, number 2, though, we're selling the same volume, but we're going to sell it downstream. Let's go to Arizona. We're going to sell it in Arizona. We're going to get a higher price in Arizona. We're going to get $3.10. But the cost of getting it to Arizona is going to be more expensive. So it's going to cost us 65 cents to get it to Arizona. And so the wellhead value that we're going to get is going to be the $3.10 minus the 65 cents for a wellhead value of $2.45. So if you look at this, the highest price that you're getting results in a lower wellhead value because the cost to get it there is higher. Well, why does this even matter, right? Unlike the highest reasonably obtainable price duty that you have in Texas, and which even Browning explained initially as based on existing market conditions, so fact-specific, accounting for actual market realities at the time that the gas was sold, the highest wellhead value duty is completely divorced from the realities of gas marketing. And especially in New Mexico, where the majority of the natural gas production from New Mexico is sold and used outside of New Mexico. Additionally, the highest wellhead value duty is completely divorced from a reasonably prudent operator standard. It is completely unlikely, and I have talked to many experts and had many experts write reports for me in similar cases in Colorado, and talked to business folks and all that, is completely unlikely that other producers selling similar large volumes of gas would limit their sales to in-basin sales points to one sales point when they can get a higher value downstream. Okay, so this past March, the parties are back in front of Judge Browning, and plaintiffs have moved now for reconsideration of his opinion on class certification. And this is all in light of the ruling on their motion for summary judgment when he said that the highest reasonably obtainable price is the wellhead local price. So to get around his ruling where he said that individualized issues were going to predominate because the price that was reasonably obtainable was going to require an analysis of lots of different issues and would not be able to be answered in common answers, the plaintiffs say that the highest reasonable obtainable price, so the highest price that Conoco could have possibly gotten for this gas, is not the higher downstream prices that they actually got, but the average price that they got for all the gas that they sold in New Mexico, so in the local market. And even though Conoco sold gas at a lot of different points, he talks about Arizona and California specifically in the opinion, the plaintiffs say the court should just assume that the price of Conoco's sales at a single market location was the highest price they could have possibly gotten. They also narrow their class definition and say that we're going to limit this to only royalty owners who have interest in leases that do not modify or negate the implied duty to market. And Browning accepts their argument. He accepts their proposed fact that the San Juan Basin price was the highest price that they could have gotten, and allows the claim to proceed on a class-wide basis. And this is problematic. I would argue this is highly problematic, but it's arguably problematic for a few reasons. So number one, not all class members are going to have an interest in the gas that was actually sold in the basin, right? There were people who had an interest in gas that was sold in Arizona, that was sold in California and other downstream markets. And if you would have to really evaluate the royalty that was paid to every single owner, because some owners might have actually benefited, right, from higher prices downstream. And so you're going to have tension between owners who didn't benefit from higher prices and owners who did. In addition, ConocoPhillips, right, they're a big company. And they were engaged in a very large drilling program in New Mexico. If they had chosen to sell all of their gas in the basin, you are assuming that they still would have proceeded with the same development and drilling program that they did actually do when they were getting higher profits downstream. And so owners who had a significant, maybe, one owner had 20 wells drilled on their property. They're a huge royalty owner. Not clear that that owner would have had the same number of wells and therefore would have gotten the same royalty amount if Conoco had sold its gas in the basin for a lower price. Additionally, because the price that Conoco actually received for a significant portion of the gas is going to be impacted by transportation costs, Browning essentially allows the plaintiffs to challenge Conoco's costs, which is not permitted in the 10th Circuit without explicitly saying that's what they're doing. So this goes in direct contravention to the 10th Circuit's ruling in Elliott. It also assumes that the local price that they're pointing to, which is based on an index price, was actually available if Conoco had sold all the gas. So if Conoco had flooded the market and sold all of their production in the local market, supply and demand suggests that that price is not going to be the same as what it actually was. And so essentially what the plaintiffs do and what Browning does is want you to assume that supply and demand doesn't exist in this fantasy world, and the highest price you could have gotten is in the local market. So I would also say that his ruling is inconsistent with 10th Circuit precedent, and even Browning's prior rulings with respect to class certification. He allows them to proceed with their new class definition, even though they have not identified the leases going forward. They say that they can do it later. And he basically says, okay, as long as they can potentially show that they can find these leases later, I'm going to certify this class. And that is inconsistent with Roderick, Chieftain, Naylor Farms, which suggests that you have to evaluate the leases and identify the leases and show that they all either they all negate the implied duty market or the implied duty market applies to all of them. Now, Conoco did file a 23F petition. That was denied. The litigation is ongoing, and they're scheduled to go to trial in December. So before I tell you that this is the law in New Mexico, this has actually been rejected by Judge Herrera, Judge Browning's colleague on the New Mexico Federal District Court. He first rejected it in 2015, and then he rejected it again on a motion for reconsideration that was filed after Browning's initial 2016 opinion. Now, there has been no further analysis by other judges on the federal court of Browning's rulings. The 10th Circuit hasn't evaluated it. And so this is really the only case law that we have that says, no, this doesn't exist under New Mexico law. So now that I've thoroughly confused you all, what the heck does the implied duty to market actually require in New Mexico? And I think it's actually pretty unclear right now, right? We know at the very least that the New Mexico implied duty to market, it definitely requires a producer to act as a reasonably prudent operator and use reasonable diligence to market the production. So they can't sit back and do nothing. Is there a highest reasonably obtainable price or highest wellhead value duty? Unclear, but if you're in front of Judge Browning today, yes. There's a real divergence between Judge Browning and other New Mexico federal court judges and state court precedent. And we're also seeing, a relaxation of the Rule 23 certification standards. And so it remains to be seen whether other judges in federal district courts within the 10th Circuit will do the same thing. All right, so moving on to our next topic. I'm going to talk about claims for interest on late payments. And our story actually starts outside of New Mexico in Oklahoma, where an Oklahoma federal court in a case called Klein versus Sunoco certified a claim for failure to automatically pay interest on proceeds paid outside of the time periods prescribed in the Oklahoma Production Revenue Standards Act, which governs payment of proceeds and the timing of proceeds. And not only did they certify the class, but they awarded a huge damage award, $150 million, $75 million in compensatory damages, $75 million in punitive damages, and plaintiffs' attorneys are psyched. They are super excited. They are filing these in tons of jurisdictions. I have 3 active litigations in Wyoming. I also am doing some stuff in Mexico, but I'm not going to talk about that. So This Klein versus Sunoco is currently on appeal in the 10th Circuit. The 10th Circuit has heard argument in November of last year. They have not issued an opinion. I will tell you that the plaintiff's attorneys are feeling very confident. I don't know if that should be how they're feeling because it's been so long since the argument was held and we still don't have an opinion, but we'll see. All right, so there are many jurisdictions, including New Mexico, that have statutes just like the Oklahoma Production Revenue Standards Act. In New Mexico, it's the New Mexico Proceeds Payment Act, and it governs the timing of payment and provides for payment of interest when those payments are made outside of those time periods under certain circumstances. So like I said, we're seeing these cases pop up. There are 2 federal court, what I would call test cases, that are currently pending in New Mexico Federal District Court. They were both originally filed in state court and then were removed to federal court. And the 2 cases are Culp Minerals versus Apache and Snyder Ranches versus Oxy USA. And if you read the complaint, I mean, obviously they have specific things related to their named plaintiffs, but it's almost identical claims. And so they are alleging a breach of the duty to pay interest on late payments, a breach of the duty to investigate the right to interest. They claim that the defendants have engaged in fraud by misrepresenting on the check stubs whether or not interest was paid, if it was paid, how it was calculated. They're seeking an accounting and disgorgement of the alleged benefit retained by the company when it failed to pay interest. And they're also seeking injunctive relief, so a prospective order that the defendants have to pay interest going forward. All right. So before we get into those cases and the issues we're seeing there, I think it's important to note that before these 2 cases were filed, it had previously been understood that, at least in federal court, a claim under the New Mexico Proceeds Payment Act was a derivative remedy. So there had to be some other claim, or, an underpayment claim or a breach of the implied duty to market, some other claim. And then you could also add a claim for interest on the unpaid royalty that you were seeking from the royalty underpayment claim. It seems that the judges who are presiding over Culp and Snyder Ranches are going to allow these claims to go forward without any underlying royalty payment claim. And so that is a development under the law here. So what are the plaintiffs alleging, right? They say their position, and this is from the complaint actually these allegations are identical in both complaints, but I think I pulled this from the Culp one. They say that the New Mexico Proceeds Payment Act gives owners a absolute uniform right to statutory interest on any payment that is made outside of the time periods prescribed in the act, no excuses whatsoever. So let's see if they're right. All right, so the act, Section 3 of the act is what talks about who should be paid oil and gas proceeds and when they should be paid. And it says oil and gas proceeds that are derived from the sale of production. And that's important because sometimes you can have prior period adjustments, right? So a subsequent payment that's an adjustment to original payment. Sometimes that is a result of additional proceeds of production. Sometimes it's actually just a correction to the payment, so there was no additional proceeds that are being paid. Shall be paid to persons who are legally entitled to such payment. Now, legally entitled, that means we're looking at not just royalty owners, right? We're talking about royalty owners, overriding royalty owners, and working interest owners. So if you are jib netting, you could potentially face liability if you were withholding payment because the working interest owner was not paying their jibs. And so that's going to create much bigger potential liability. And then timing, it requires that proceeds are paid not later than 6 months after the first day of the month following the date of first sale, and thereafter not later than 45 days after the end of the calendar month within which payment is received by the payor. So the payor, maybe the payor is the operator, they have to actually get paid by the oil and gas processor before this timing starts. And also these timing provisions can be negated or modified if there is an alternate arrangement in a contract. Now, a valid contract here is not just a lease. It can be a lease. There are a lot of leases that often provide for payment annually or quarterly. But it could also, because we're talking about anybody who's legally entitled, including working interest owners, it could be a joint operating agreement. There's also, I'm not going to read this whole thing. If you want to go look at the Act, you can find it online. But the Act also requires the operator to ensure that they have all the information that they need to pay the owner, right? They have the address. They understand what the proper division of interest is. And they also have proof of marketable title. Now, there are two provisions in the New Mexico Act, which this is different than the Oklahoma Act. There are two provisions in the Act that provide for interest on payments that are made outside of the time provisions in Section 3. And the first is Section 4, which focuses on suspended funds. So typically an oil and gas company is going to have two different pay codes, two main pay codes in their system, right? An owner is either going to be in pay, so they're getting paid every month. The company has everything they need to pay the owner, have their address, proof of marketable title, they know what division of interest is, they're paying that owner regularly. Or the owner is going to be in suspense, which means the company is holding the funds back on their books for one reason or another, and they're just accumulating funds, which they will then pay out once they can get the owner out of suspense. And there are a lot of different reasons that a company would hold funds in suspense. For example, let's assume my grandfather has an interest in operator X's wells. He dies and leaves me his interest. The company might put those funds that are attributable to his interest in suspense until they get a final probate order from a court that says I actually own the interest. Or maybe there's a dispute, right, between me and my siblings about what the proper allocation of that interest is. I say everybody should get equal amounts. My brother says, no, I should get more because I'm older. And so they'll put the funds into suspense until that dispute is resolved. Or maybe the operator just simply can't find the owner, right? They sent out a check, the check gets returned. They sent a second check, that check got returned. And so they put the funds into suspense until they can find the owner. And the Act says that persons who are entitled to payment from suspended funds, so funds that are released from suspense, shall be entitled to interest on those suspended funds, and they're going to be calculated at the Dallas federal discount rate plus 1.5%. So that's not a substantial interest rate. All right. This is where the money is. This section, this is where the money is. This is what the plaintiffs are after. Section 5 says that if a payor does not make payment within the time periods provided in Section 3, and the payor has all the information they need to pay the owner, right? So they have the address, they have marketable title, they have all that, then they will pay 18% on the unpaid funds per year. And so think about a class action, right? You've got thousands of owners, thousands of late payments, and the plaintiffs want to apply an 18% interest rate to every single one. Significant liability. Section 5, however, this is again very different from the Oklahoma statute, provides 4 instances where payment is excused. I'm not going to go through each one of these, but it's generally if there's like a proof of marketable title issue, or there might be multiple people claiming the interest, or if the amount is pretty low, right? So it's under $100 a month, or if the owner fails or refuses to execute a division or transfer order. Those are documents that are pretty common in the oil and gas industry. The company will send them out to owners, and it essentially just has the owner confirm what their interest is in certain wells and also their address. You might also ask for tax ID information, right? Because you need that to pay owners. So we've looked at the statute. And now going back to their allegations, do their allegations ring true? The allegations that they're raising in the current pending cases, Culp and Snyder Ranches. So just remember, they want to say that any payment outside of the time periods prescribed in Section 3 is a late payment, and interest is due on every single one, whether it be at the Section 4 interest rate or the Section 5 interest rate. And I would argue no. They fundamentally or potentially purposely, likely purposely, misunderstand this statute. Because there are 7 total prerequisites to liability under the New Mexico Act that you have to go through before interest can attach to any particular payment. So under Section 3, you're going to have 4, right? Are the proceeds derived from production? When did the payor receive payment for the production? When did the payor tender payment to the payee? And then is there a contract that has a different arrangement for timing? And then under Sections 4 and 5, you've got 3 prerequisites. So is it a Section 4 violation such that the lower interest rate applies? Or is it a Section 5 violation? And if it is a Section 5 violation, does it fall into one of those 4 exceptions? So, we've looked at the statute, and I think there's really unknown of how the court's going to rule on these issues, but we do have a few issues that are popping up and that the courts have ruled on as of today. And the first one, I think a great place to start, is standing. So you all have taken con law, right? You know that under Article 3 of the Constitution, the plaintiff has to establish standing to bring each of its claims. So the plaintiff has to show injury in fact that's traceable to conduct by the defendant that's going to be redressed by a favorable decision. But how does standing apply when you have a class action allegation, a violation under 2 different sections of a statute, Sections 4 and 5, if the named plaintiff has only experienced a violation under 1 section? The plaintiffs in Culp and Snyder Ranches, they want to say that it doesn't matter. We do not care about the difference because violations of both sections result in the same injury, a failure to pay interest. But you have to remember that Sections 4 and 5 involve different conduct, right? Is it suspended funds or funds that were just paid outside of the time frame? They also involve different prerequisites to liability. They also involve different remedies, right? The different interest rates. Another consideration, are the statutory provisions separable? So could an operator violate one section and not violate the other? And then also remember that these claims are being brought as class actions. And in the 10th Circuit, there is very well-established precedent that named plaintiffs cannot rely on the injuries of putative class members to establish their own standing. They have to establish standing because the class is not certified. They cannot rely on those class members until there is a certification order. So what are the courts actually saying? And we have an order from both cases that come out very differently. So in March of this past year, Judge Garcia in the Snyder Ranches litigation denied Oxy's motion to partially dismiss the complaint, which, among other things, challenged the plaintiff's standing to bring claims on behalf of putative class members whose payments were held in suspense or escheated. That just means they were sent to unclaimed property funds. Am I out of time? Oh, God. Okay. Sorry, guys. So he came out and he said, no, this is a class certification issue. The plaintiff only has to establish their own standing, and then you are going to evaluate it under class certification. He says this is a majority view. He does not cite any 10th Circuit precedent in his opinion. In Culp, literally the next day, Judge Gonzalez comes out with a completely different opinion on a motion for partial summary judgment, and he says, no, the named plaintiff has to establish standing for each claim. It cannot rely on the named plaintiffs. I think a reason for the district split could be the procedural posture, and there is a pending motion for summary judgment in the Snyder Ranches case on standing, so we'll see. Okay, and then last thing, and then I'm done. Class certification. So class certification is still unknown in these cases, right? They are pending. They're still in discovery. There has not been any motion for class certification filed in either Culp or Snyder Ranches yet. But we do have 2 opinions from, you guessed it, Judge Browning. And I think that contrary to what I think about his rulings on the implied duty market, I think this is actually a space that he got right. He says there is no way that you can have common issues predominate because he's going to have to conduct a mini trial on every single payment. You're going to have to figure out that liability attaches for every single payment to determine if it's interest-bearing or not. This is my last slide. Okay. So what does this all mean? We will definitely see more putative class actions under these types of statutes in other jurisdictions. And depending on the outcome of Culp and Snyder Ranches, we will likely see more in New Mexico. We still don't know. There's a district split, right, as to whether the named plaintiff must show injury in fact for each statutory violation. I would say if you are litigating one of these, you should definitely raise standing just to make the argument, because those are district court opinions. Again, there are different procedural postures. And so I think remains to be seen what the 10th Circuit would do if they were reviewing Judge Garcia's opinion. And then whether courts will certify these claims is still unknown. There's good law from Judge Browning, but we just don't really know how they're going to come out. So obviously no time for questions, but if you want to chat, I'm more than happy to. I'm going to stick around for a little bit. My flight is at 5. But I'm more than happy to answer emails, calls. Yeah, and super excited to be here. Thanks for having me. Thank you. Oh, wait, your microphone. Come on. Okay.
Thank you, Ms. Sears. Our next speaker is William Osborne. William Osborne was born in Austin, graduated from the University of Texas Law School, and is now partner at Osborne and Bennett in Austin. Today he is active before both Railroad Commission and the Texas General Land Office. His work requires him to assist in managing a large Western land portfolio, including projects relating to wind power, oil and gas, and pipelines and short line railroading. Today, Mr. Osborne will be discussing forced pooling in Texas. Please welcome William Osborne.
Hey, can y'all hear me? So I'm set for 45 minutes, but I'm only going to talk for 30. The last 15, I'll be outside if there's any questions, okay? First, let's talk a bit about the Railroad Commission. And I've got some slides, and can somebody bring up the first one? And whoever's going to do this, what do I do? Right here. All right, well, we'll just try this. Yeah, stay here. So I'm too old for this technology. So I've spent a career practicing before the Railroad Commission. It's a misnomer, of course. The agency started its existence to regulate railroads in Texas in the 1890s. Regulation of oil and gas came in 1917 because oil was being transported in pipelines. Pipelines were common carriers, and the Railroad Commission regulated common carriers. So that's how I got the jurisdiction. The practice before the agency by law firms then is just the same as it is now, restricted to about a half a dozen firms, highly incestuous. We marry each other and we bury each other. There are literally marriages between firms, of couples. And for that reason, it's kind of an antique practice. We're very respectful of each other. And over the years, there has developed a course of dealing. So y'all are used to rules and precedent, but there's this whole body of other precedent, which is just the way things are done. And in the 1950s, the chairman of the Railroad Commission, Ernest O. Thompson, was asked, well, what are these rules of practice? And he responded, well, sonny boy, the rules of practice at the Railroad Commission are about like snakes in Ireland, which is to say there are none, right? It's just a course of practice written down. And so that same course of practice extends to the Mineral Interest Pooling Act and forced pooling. Forced pooling in Texas is not common for single tracts. It has become much more common in the last 15 to 20 years for cities and projects where an entire city is of interest for development by an oil and gas operator. So the slide you're looking at now is from a website that our firm built for a client, Sinclair Oil and Gas, the green dinosaur, for the city of Big Spring. Okay. And if you want to look at this website, it's bigspringwells.com. And if you go there, you'll see all these tabs. And one of them is offer letter. Okay. So the offer letter for forced pooling in Texas is a complicated looking thing. And it's complicated because it deals with all of the prior precedents over the past 40 years that have shaped administration of the law. So every time there's a case that says, no, don't do it this way, do it that way, the body of law firms that practices before the agency changes their offer letter, right, to reflect that. And so what to you as an outsider might look like a very contorted offer letter, to us, it's just a reflection of history. And you damn well better follow the form. The examiners won't give you much respect if you don't. In this particular case, and let me see if I can work this little control thing here. Okay, so in the city of Big Spring, you see the units outlined in green. This was a kind of a donut hole that had never been drilled because of the complexity of the situation, about 8,000 city lots. Big Spring is not at all unique in this respect. The entire city of Midland has been dealt with in this same way by a different operator and a different law firm, one of the tribe that I'm in, a competitor. The operator is Arrington. Fort Worth, city of Fort Worth, has been dealt with in this way by XTO and other developers. And the way it happens is that, and here on this slide, we're showing the units by the surrounding operators were very easy because those were like units of 2 or 3 big ranchers. Inside the city limits of Big Spring, we had 8,000 city lot owners. And some of them do not respond very favorably when a fellow walks up to their front door wearing a tie and knocks. He's offering an oil and gas lease, right? He's offering to give him money. That's not what they think. Instead, what they think is he is with immigration. He's with the Child Support Division of the Attorney General's office. He is with the tax collector to whom I have not paid my property taxes for more than 20 years. Or he's with somebody else bad, but if he's wearing a tie, it's not good. They don't answer the door, right? So try as hard as it could, Sinclair could not obtain oil and gas leases from a substantial number of city lot owners. So what's the problem that causes? Oh, let me stop here and show you this. Anytime you try to develop in a city, you're going to get something like this. You get sent this photo. Your drilling in the city caused our streets to collapse. This happened yesterday. Write me a check. Just get this. You'd be surprised how often you get something like this. Okay. So let's talk about this field, Sprayberry Trend. You see here a hearing exhibit, and it is showing correlative intervals. The Sprayberry Trend field is designated by the commission here as about, it's more than 2,000 feet thick. In the lower right, you're going to see traces of other wells that have been drilled since then, or after this. A lot more wells have been drilled south of the red line. The first time that I ever saw a 15,000-foot well permitted in the state was Thanksgiving weekend of 2018, and it was just like one of these jaw-dropping things. A well just south of this red line by SM Energy, and of course now we're seeing 20,000-foot long laterals and more. What I want to say here is that in Texas, the Forced Pooling Act only applies to a specific field, okay? And so you've got this field covered by orders that are now in place. But as you may know, now operators are drilling even deeper and finding production in other horizons. So all the work that's been done in the city of Midland, city of Big Spring, Fort Worth, everywhere else, it's all going to have to be done all over again because of the way the commission regulates this. This is an illustration just of the, it's a hearing exhibit showing the correlative intervals that are allowed to be targeted. Now, another issue here is you can see the Sprayberry and the Wolfcamp. All right. So the commission designated intervals, more than 2,000 feet. We get a forced pooling order. Does the forced pooling order apply only to the first well or to deeper wells in the same field? So we've gotten the commission to say that it applies to all of these depths. And we, as the collective tribe that practices before the commission, and we do this by precedence. One of the more interesting precedents that's been established this way in the last, since COVID, it used to be that before any of us filed an application at the commission, we would tell our oil company clients, you need to have 80% leased. Long one of these unwritten rules like Commissioner Thompson had. And by the way, a slight war story here on Commissioner Thompson, because we're at the base of the Panhandle. He was mayor of Amarillo before he became a revered railroad commissioner. He served in that capacity from the middle 30s to the middle 60s. And I was on staff in the early 80s and heard this story out in the cafeteria. Cafeteria was divided into smoking and non, and we all had to sit in the smoking section because the technical examiners were World War II vets and they smoked. And so the ceiling tiles in that section were brown, not white. So I'm sitting there one day with George Singletary, been there. He would get his 50-year pin there. He died on the job, which is what he wanted. And he told me this story on Commissioner Thompson. He said every day Western Union Telegram would deliver a telegram to the Railroad Commission. So telegrams were very expensive. It was like their equivalent of texting, right? But a word cost 50 cents. Doesn't sound like much to you, but in the 1940s and 50s, 50 cents meant more. So this telegram came every morning to the commission, addressed to General Thompson from Amarillo, and it had a number. It might be like 172. It cost 50 cents. That was counted as one word. So Commissioner and Chairman Thompson, General Thompson, they called him, owned the Herring Hotel in Amarillo. And the telegram that arrived every morning was from staff down in the basement. He thought, or he just figured, that the front desk was cheating him on the room revenue. And so that was a towel count. That was how many towels had been laundered last night in the laundry. One towel was issued per room, right? Anyway, complete digression. Back to our subject. So in Big Spring, we worked on these wells, and then you'll see in red, the red was phase 2. I've been working on this for Sinclair, like going on 10 years now. We're still of an application over there now. We keep expanding. Half of the red is a state park, the Big Spring State Park, and about a fourth of it is a golf course, a city golf course. So our biggest royalty owners are the Parks and Wildlife Department and the city of Big Spring, and you can be damn sure the Railroad Commission signs what we place in front of them to make this happen. Now, let's talk about a different situation. We've got these big cities, okay, they're a natural, but there is a series of ghost towns across South Texas. They were platted by railroads in about 1900, boom towns promoting sales of 10-acre lots to people who lived in Chicago in the north. Come down here, it never freezes, it always rains, cantaloupes as big as a basketball. Okay. So what you're looking at here is a plat from another hearing I did, and this was submitted as an exhibit in a Sinclair hearing, but it was from a hearing I did for another client. And so what you're looking at here is the town, actually it's not a town, it's a ghost town called Big Wells, Texas. And big wells didn't mean big oil wells. It meant big water wells, artesian wells. So in this case, ghost town gets platted, sold to all these people in Chicago and the Midwest that never show up, defaulted on their taxes, all of it. So you've got a massive number of lots with nobody to whom application can be made for an oil and gas lease. So the company wants to lease them and tries to lease them and can't. And so this is a close in of a result. You see that arc, that blue arc, that's a railroad track. Guess what? The railroad's also gone. And it's Union Pacific Railroad. If any of you have ever dealt with Union Pacific, you know they've got a real ugly oil and gas lease form. And they tried to impose it here. And we just said, no, we will force pull you. And we did. So that's the reason for that arc. And those lots that you see are ghost town lots that have been abandoned. And the wellbore trace, as you can see, only includes a part, what's enclosed in green. So here we're using the allocation well permitting process to form a unit under the forced pooling statute, which in theory can only be 160 acres, and pool it with some other acreage next to it. So this is a slide showing the Barnett Shale. This is from the Railroad Commission website. So you can see all of these red dots. Just about none of this could have happened without use of the forced pooling statute. You may be aware, for instance, that Chesapeake paid $10,000 an acre bonus for the mineral rights under the Dallas-Fort Worth DFW airport that all of us use, right? With a promise never to drill there, but to drill underneath it from adjacent acreage. So huge boom that has happened there and is still going on. And the Mineral Interest Pooling Act has been used to make this possible. So this is an exhibit. This is a hearing that I handled for somebody in one of those cases. So a French company called Total Energies, which does business as TEP in that area, last year wanted to form a forced pooling unit. And we were contacted by the owner of a guy that owned a lot of acreage because he had a Ford Motor dealership, right? And all this ground, and he didn't think that they were giving him a fair shake. And so we went to hearing and they decided they would give him a fair shake. But what I want to show you is, this is a screen from a database called drillinginfo.com. You'll see up on the left corner, the search screen for it. This is something you pay for. It's indispensable in our work. And here it's showing a label that I've asked it to show for a hearing exhibit about a well, its history, because we have to prove productivity. Okay, now let's come to a different subject, personal one, and I think it's why I really got asked to speak here. The history of the Railroad Commission and the General Land Office is very complicated, and at times you would think that they would be fully aligned, but actually they're not. Sometimes they're complete loggerheads. My father he's now a retired attorney, but he started his career with the Attorney General's office and was assigned to the General Land Office exclusively for 5 years, late 50s and early 60s. Has incredible stories from there, including the exhumation of a dead body that they needed to check out. But because of that, I got real interested in the General Land Office, and I practiced before that agency. It's another small tribe that does that. And the Railroad Commission and the General Land Offices are across the street from each other, Congress, but they're very different agencies. When I go to the Railroad Commission, I want justice. When I go to the Land Office, I want a deal, right? And the Land Office employees, a great many of them spend their entire careers there, like 40 plus years. I spoke at a retirement party for one of them earlier this year and counted 10 people in the audience who had been there for more than 40 years. And so you better not mess with these people, right? Because you're going to be doing business with them. So here's where it gets personal. In about 2010, I noticed that a lot of state riverbeds were being left out, drilled on both sides. This is a screenshot from the Land Office GIS database showing a particular lease, which is set to term out in a couple of weeks. So I'm the lessee. My oil company is named Ammonite because it's kind of fossil that collected as a boy at our ranch. And so I've had this riverbed tract under lease, and you can see wells coming up to it from both sides. In this case, the operators have declined to pool voluntarily and stranded the riverbed. So starting about 2010, I was working on this project and then started taking leases in the sealed bid cell and accumulated more than 50 of them and started filing forced pooling cases at the Railroad Commission saying that the operators are seeking to pool portions of the river directly opposite each of these wells into a pooled unit. So we have a contested case hearing. In the earlier years, the commission had approved them, but in 2015, there was a change in commissioners. And the new administration didn't like this and began to deny these. And I got denials in cases against DOG, Chesapeake, and Apache. So we appealed, and we took one to the Texas Supreme Court. So there's an opinion that you'll find from 2024 called Ammonite versus EOG, where the Supreme Court found that the statute was not designed to be used like this and was not applicable. So sustaining the commission's denial of the applications and suggesting, well, it could have been handled differently before the commission. But the real problem is the commission doesn't like these. So, you know, as a veteran employee of the legal department of the agency, I know well enough not to tilt at windmills. And so we're now looking at this situation. This is a screenshot from drillinginfo.com. This is the Pecos River that you're looking at. And I told the software to illustrate all the wells in this territory. So it's identifying them by their API numbers. It's like a street address for a well. Texas is state code 42. 301 county code for Ward County. 389 is county code for Reeves. And you can see what's happening here. So all of these wells are coming up to either side of the river. And some of them leave it out, others include it. So, you know, it just seemed like a wrong looking for a correction. And so I systematically set out and started leasing the gaps. So here's how it looks on satellite. See, this says media, and it shows south end and north end of a state riverbed lease that I hold, 116710. So I had a fight with the XTO about this, and the fight lasted 10 years. I'm very patient. My wife uses a different word. And now this riverbed is included in the media unit. They have another unit called Mi Noche, my day and my night. We are their nightmare, right? We're included in both of them now. And so the state's included. This is an extract of a Railroad Commission map from the 1880s showing the Frio River. And the vertical line you see on the left is the McMullen County line. So the Land Office has all kinds of maps like this. This is how it looks, that same riverbed piece. If you look at the vertical up and down line to the left, let me go back here. You see that vertical up and down line kind of towards the left? Now we're going to jump you forward 150 years. Boom. You see the same vertical line towards the left. Those wells that you see, those are all EOG wells in Ron Oil and Gas. That's the case we took to the Supreme Court. where we sought force pooling, saying that EOG had stranded the river, and my company filed 16 applications and went to hearing on them at the Railroad Commission, and then sent a letter to EOG proposing another 35 wells, jointly paying its full share. So this is how it looks now. Okay. So the question becomes what to do about it, right? We lose the Supreme Court case on force pooling. So I don't know what to do. I'm thinking there's got to be a remedy for this. So it's 2025. I just sit down and think, okay. And I write an inquiry to artificial intelligence. And I use the Gemini search engine. There's different search engines you can use. I use Gemini. And I described the situation, and I said, this seems wrong. What is the remedy? Right? Just it thinks for 20 seconds. That's just all the show, by the way. And it tells me that I need to assert a doctrine that the Supreme Court of Texas set forth in 1888. I didn't even know this word, for pressure. Very rare thing. I took Texas land titles class at UT Law in the 80s because Daddy made me, and I had the same professor he did. This word didn't come up. It's quite rare because people don't normally try to treat the state this way. Okay? So there's this. And here's the 1888 case that artificial intelligence told me about. Famous rancher Charles Goodnight, the Texas Panhandle. And you can see the Supreme Court did not think very kindly of his approach toward colonization of the West. In particular, his fencing out public lands. And you'll see their reference to navigable streams. Okay? So, you see this? This is a clause that is in petitions that we filed in the last 3 weeks in Reeves County Court and in Travis County Court against different operators. And we're fixing to file some more asserting liability. So that's the end of my presentation. And I told you I would talk for not all of my time. I've got, though, a couple more minutes, and we'll say this generally. The force pooling law and statutes in Texas are completely unlike what you see in New Mexico, Louisiana, and Oklahoma. In this state, it's very hard to do. You know, it's not looked upon with favor except for these city plays, and that is not going to change. The problem is that our statute was written in 1965, before horizontal drilling, so it doesn't work very well nowadays. And what happens is you see the tribe of the firms that practice before the agency trying to make it work in these city town lot cases in particular, and having to struggle to come up with ways. The most recent case I've seen that surprised me was by one of our fellow members of the tribe. They got only 45% sign up. They went ahead and the commission approved it, which begs the question, just how much do you need? Because within my practicing lifetime, it's gone from 80% to 45%. How low is it going to go? And it's almost like an administrative workaround, if you will, of a way to approach the problem of acreage getting left out in the rush of development or the jigsaw puzzle assembly of various interests. And it's complicated, but it's fun. So I'm going to stop here, and I'm now 15 minutes early, and I'll be in the back for any questions. Thanks.
Hey, William, would you hang up there for a second and let me ask you a couple, since
Yeah.
we've got some time?
Yeah.
So two questions. One is, obviously you were focusing on the companies that have not wanted to play ball with you on force pooling of the riverbed leases that you have, but are you able to share any success stories with companies that have complied and that you can kind of report what the consequences or the benefits have flowed from those results? And then the second question is, to the extent that this continues to be an issue with companies that don't want to participate in a force pooling application like that, do you have thoughts or suggestions about how the legislature might take some affirmative action on how to bring about a different result?
So, as to the first question, if you look at the petition, it relates some history about this whole project, which I started it in 2010. I was sitting next to Flip Whitworth, bless his departed soul, at a state land board meeting in 2010, and they were approving a unit called the Atascosa River Gas Unit. And I looked at the plat and I turned to Flip. I was sitting next to him because we were buddies. I said, Flip, I see it's called that, but the river's not in it. Why is it called that? Well, it's just beside that. Are you going to put the river in? Nobody cares. Oh, okay, fine. So in the petition, you'll see that we relate that we've had success in putting more than 100 wells into units, and that most operators, when it is pointed out to them, resolve to address the situation. And the few that don't have reasons of their own, and the land office is not very happy with them. So we'll just see what happens. In terms of there's some very stubborn management, of course, in oil companies. In terms of the legislature, Drew, I would say, we tried in not this recent session, but the one before it, to get the rule changed for a client. Right now, the force pooling statute in Texas says that you can't form units larger than 160 acres for oil. Now, we're able to do some magic, right? And I got 640 acre units approved in Big Spring, but it's complicated magic. And so we suggested that the legislature change that to allow 640 acre units for oil. And of course, we hit a buzz wall of resistance. We worked with the Texas mineral owners and got buy-in. If we would agree to have the statute say there would be 2 lateral wells per 640. And it was presented privately to Tom Craddock, who looked at me and said, I was elected to this body in 1969 on a premise that I would always oppose force pooling, and I'll be goddamned if it's going to happen on my watch. Right? Yes, sir. What are you going to do? So it's not going to happen on his watch. All right. I'll be in the back for more questions.
Excuse me, everybody. We're going to go ahead and get started a few minutes early. Our next speaker is Jackie McLean. She'll be presenting remotely. Ms. McLean graduated from the University of New Mexico School of Law and is the founder and managing partner of Hardy McLean LLC in Santa Fe, New Mexico. Her practice is focused on representing energy companies, oil and gas operators, and investor-owned utilities. Her work includes representing oil and gas operators in compulsory pooling actions. Moreover, she regularly represents energy companies and oil and gas operators in both regulatory proceedings and appeals. Ms. McLean has prevailed in appellate proceedings before the United States Supreme Court, 10th Circuit Court of Appeals, and the New Mexico Supreme Court and Court of Appeals. Today, Ms. McLean will be discussing force pooling in New Mexico. Please welcome Jacqueline McLean.
Thank you. Can you hear me okay?
Yes, we can.
Okay, perfect. I feel a little bit like the Wizard of Oz over here, just behind the curtain. Before I start sharing my screen, sorry I couldn't be there in person today. The Oil Conservation Division and Commission has been really crazy recently, scheduling a lot of last minute hearings, just whenever they feel like it. So fortunately, I couldn't be there, but hopefully you learn a little something from my presentation. And I guess if there's questions, just please let someone there know or put them in the chat, and I can answer them that way. Let me share my PowerPoint. All right. Hopefully everyone can see this okay. So I am going to be talking about forced pooling in New Mexico, or compulsory pooling. And I wanted to start with just an overview of the New Mexico regulatory agencies that are at play, because everyone might not know them. First, we have the Oil Conservation Commission. They promulgate rules. They hear de novo appeals of the division decisions. They have jurisdiction over other matters like acid gas injection wells. They mostly, I would say their two main functions are rulemaking and then hearing the de novo appeals of division level decisions. Who is on the commission? The OCD director, the Oil Conservation Division director, a designee from the state land office, and a designee from the Energy, Minerals, and Natural Resources Department. And the Energy, Minerals, and Natural Resources Department, a lot of people call that MNERD, and that is what OCD sits under. That's the agency that it is within. Then we have the Oil Conservation Division. And that is where, that's like the bread and butter of compulsory pooling. All of the cases for compulsory pooling go before the Oil Conservation Division. And the division is responsible for regulating oil and gas development. It's where people do all of their well permitting, filing APDs, filing applications for non-standard spacing units and non-standard locations of wells. They are also the enforcement mechanism of MNERD, and they issue notices of violations to operators for failure to comply with the rules. So I would say, people who are doing compulsory pooling in New Mexico, the Oil Conservation Division, or the OCD, as everyone calls it, that's who you are going to be interfacing with the most. Then separate from MNERD is the state land office. And they regulate oil and gas development on state oil and gas leases. So they're responsible for managing approximately 9 million acres of surface estate and 13 million acres of mineral estate in New Mexico. They basically, are responsible for the surface, and all the leasing goes through the state land office. They have their own enforcement arm, I guess you would say, which is like just whenever they want to enforce something, they do. I'm not going to really talk about the state land office much today, but a useful resource if you want to jot this down, on their website, they have a section under the oil and gas, drop down menu. And they have all of their forms, and they also have a brand new handbook, oil and gas handbook, and that goes through all of their regulations. informs and kind of explains how each one should be used. All right, moving on to the Oil Conservation Division and Commission, since we're talking about pooling today. There are, I would say, 4 really important rules that drive a lot of what we do as in terms of applications for force pooling. The horizontal well rule, 19.15.16 NMAC. Then there's a rule regarding standard spacing units, non-standard spacing units, and non-standard well locations. And those all impact what type of application you're going to be filing with the OCD for your compulsory pooling. I would say like 99.5% of all the applications we're doing nowadays are for horizontal wells. I think I've done 2 vertical wells in the past 5 years. So those are, very rare. And so everyone is really just concerned with the horizontal well rule and the corresponding, subparts of that. So in New Mexico, standard spacing for an oil well is 330 feet or more from the outer boundary of the horizontal spacing unit. And the first take point and last take point can be no closer than 100 feet from the outer boundary. For gas wells, it's 660 and 330. I was listening to the prior speaker, and he was saying how it seems very small the spacing units in Texas can be compared to New Mexico. And more we're seeing people making these huge multi-well horizontal spacing units that don't comply with setback requirements under the non-standard spacing rule. And you are allowed to do that. We are doing, 3-mile long full section or non-standard spacing units, and you are allowed to do that as long as you can show that's necessary to prevent waste or protect correlative rights, and those just allow you to pretty much you just have control of that acreage, and you can do whatever you want with it as long as you do comply with the setback requirements from the outer boundaries of that non-standard spacing unit. And the necessary to prevent waste or protect correlative rights, what we're seeing there is facility consolidation. Instead of having multiple spacing units, multiple communitization agreements, you can have one spacing unit that has one facility, and New Mexico really likes to see that. They like to see a reduction in surface use, so that has been very helpful. Non-standard well locations or unorthodox well locations, those are any spacing units that the first take point, last take point surface location. Oh, is there a question? That I just heard someone. Anything where the first take point, last take point, surface hole location, or bottom hole location is closer than allowed by the setback rules. So closer than that 330 or 100 feet from the outer boundary of the spacing unit. Okay, now the compulsory pooling process. I'll probably come back and talk a little bit more in detail about non-standard spacing units and also what we call proximity track spacing units. But first, let's just do an overview of the compulsory pooling process. Now, the statute the Oil and Gas Act and its implementing regulations provides authority for the division to compulsory pool 2 or more separately owned tracts of land where they're owners of royalty interest or undivided interest in oil and gas minerals, where you can't get voluntary joinder within the proposed spacing unit. So let's say you're an oil and gas operator and you want to create, just a 320 acre spacing unit. You send your well proposal letters out. If you see this bottom figure here, it's kind of like a flow chart of what happens. The first thing you do is just send well proposal letters out to interest owners that in the well proposal letter, you do have to have certain things. You have to have a description of the lands that are going to be within the spacing unit. You need to have the at least first and last take points identified. People generally specify the footages from the section lines of the intended well location. And you generally also see the surface hole and bottom hole location. The surface hole location, that does not have to be specific yet, but a bottom hole location or a last take point does have to be the same in the well proposal letter and the application, and then when you go to hearing. Any deviation from that, you'd have to send out a new well proposal letter. So that's really the most important thing. And the first take point and last take point must be within that proposed spacing unit. You also need to include in the well proposal letter the overhead and supervision charges that you are going to be charging, as well as an AFE, an affidavit of expenditure attached to that for each well that you've included in the well proposal letter. The division places a really heavy emphasis on ensuring that notice is correct at the time of the hearing. So sending out the well proposal letters to the actual interest owners in your proposed spacing unit is extremely important, and you will not get your compulsory pooling application approved if you have not done notice correctly. They are so focused on this that they actually just sent out new, I wouldn't say guidance, it's new requirements last week for notice specifically. And all of the OCD notices can be found on their website under, and I'm trying to get the website for you guys. It's on the MNerd website, and then there's a drop down list for oil and gas, and then it says division notices. So everything for the last 8 years, I think, is uploaded there. And there are lots of really important notices and clarifying memorandums that you can find on their website. If you have questions about some of these particular pieces of the process, a lot of them have been clarified over the years. So that's a good piece of information to have. Who do you provide notice to? Notice is important, but who do you provide notice to? Notice needs to be provided to each owner of a mineral estate of any portion of the lands the applicant proposes to be pooled or unitized, whose interest is evidenced by a written conveyance document, either of record or known to the applicant at the time the applicant filed the application, and whose interest has not been voluntarily committed to the area proposed to be pooled or unitized. So basically, interest owners and any interests who have not been voluntarily committed. Something that keeps coming up for debate is who is known to the applicant at the time the applicant filed the application. That's where a lot of arguments are made. And what we tell people and what the division has been telling people is basically anyone on title, that's run at the time of filing of the application. And then also a lot of times, these interests change hands all the time. So if you know that before you're going to get a pooling order, there's like a deal in the works for someone, or the person that's in title has told you like, oh, we're, assigning this interest to so-and-so, it's best to notice them as well, because a lot of times that will just create more questions for the OCD. And so it's best to overnotice, although people don't like to do that. That's the easiest way to make sure you're at the hearing and you don't have problems. So you have sent out well proposal letters 30 days before you want to file the application. This is important, this 30 days, and knowing when, the application deadlines are is very important, because the OCD only hears new compulsory pooling applications once a month. It's like either the first or third or second Thursday. They keep changing it on us all the time of the month. And that's the only chance you're going to get until the next month rolls around. So let's say right now the deadline is passed for the November 13th docket. But let's say you're an operator who wants to get on the December 4th docket. At this point, you should have already sent out your well proposal letters by October 4th. And then you need to file the application by November 4th, which is 30 days before the hearing date of December 4th. And the OCD publishes all of their hearing dates. We already have them published for 2026. They do change them from time to time, but this is a pretty good, you can tell and calculate all the dates from what's already been published out there. So if you want to be on the December 4th docket, you'll need to file your application by November 4th, which means you should have sent out all your well proposal letters by October 4th, because it's 30 days before the filing deadline, and then the application must be filed 30 days before the hearing date. Then once you file the application and you get it back with the case number and everything, the division rules have specific notice requirements, like I said before, and the applicant must give notice to each interest owner at least 20 days prior to the application's scheduled hearing date. So right now we're working on notices for this upcoming November 13th docket. All notices for all the applications we filed must go out to working interest owners by October 24th, which is next Friday. And if we don't get them out by then our case is going to get kicked to the December docket. So knowing all of these and meeting these deadlines is extremely important. And the OCD does review in detail all of the notice and all of the exhibits that are submitted, which I'll talk about in a little bit. But there's an entire packet of information that you submit that is just about the notice that's sent about this hearing. So the notice has to be sent out at least 20 days prior to the scheduled hearing date and must include a copy of the application, the hearing's date, time, and place, and how protests may be made. And that's pursuant to Rule 19.15.4.12b NMAC. And then you might also have to do a newspaper publication or notice publication in the county paper. We typically always do a public hearing notice because there are so many interest owners that we have wrong addresses for or are deceased or whatever it may be. The only time we don't do a notice publication is if there's like one person and it's like ConocoPhillips and we know that they're going to actually get our letter. Other than that, we always do a notice publication, and the publication is required to be completed and published in the paper at least 10 business days before the hearing. And so you have to publish it. Let's say you're pooling in Eddy County, you would publish it in the Eddy County, Carlsbad, Current Argus. And that is also an affidavit of publication is also submitted to the division to show that you have done that. And if you can't show that the application that you sent to the interest owner actually was delivered by certified mail, you can point to the publication to satisfy that notice requirement. So then after you send out all the notice, you have to get your clients to submit. And this is also, just to clarify, this is all for just a standard compulsory pooling case. This is, just what's required of every standard compulsory pooling case. This isn't a contested hearing. This isn't anything crazy. But after you've gotten all the notice out, then you and your client work on the exhibits that are going to be submitted. And exhibits, we typically submit exhibits from the landman and a geologist. And exhibits for uncontested hearings typically include a map that shows the spacing unit and percentage of ownership of each tract in the unit, the names of the formation to be pooled, so like Bone Spring or Wolf Camp, the pool and pool code, C102s for the wells, the name of all the interest owners that are going to be pooled, as well as the percentage of interest that each owns, and a statement that the applicant has conducted a diligent search of public records. And that just, again, goes to, that you have sent notice out to who you believe to be an interest owner at the time of the application. Then you have to show the location and depths of the proposed wells. Geologists typically show the formation and why a lay down or stand up orientation is preferred. You have to show that written evidence of your attempts to gain voluntary agreement, including copies of the well proposal letter and AFEs that you sent out. And then that's all packaged together in one packet and submitted a week before the hearing. And then at the hearing, there may be questions about the evidence that you've submitted. So that's just a general overview of, filing the application and all the deadlines, and then what you do when you get to the hearing. There are two types of compulsory pooling hearings, contested or uncontested. Uncontested hearings, these are the majority of compulsory pooling cases, and these are presented by affidavit with the witness available for questions by the hearing examiner. These are very easy. As long as you submit everything that they want you to submit, there's really no issue, and these are approved 1 to 3 months after the hearing, just depending on what is going on at the division. Contested cases, we are seeing a huge rise in these as people fight for, control of operatorship in the Permian, because it's just, so profitable now. I'm sure you've seen the recent lease sales and all of the records that are being hit here in New Mexico. But contested cases are held on special hearing dates, and they're typically presented in person at the division. The hearing, there's status conferences, there's a pre-hearing order setting deadlines for exhibits and pre-hearing statements and objections, and filing. You have to submit pre-filed testimony with the exhibits for these. So they're a lot more involved than just the regular uncontested hearing. Sometimes we will see someone just simply contest an operator's development plan, but the majority of contested hearings are a result of competing application for either the same exact acreage or overlapping acreage filed by operators. And these, what's really important to have in mind, and I'm going to spend a little bit of time going over this, when you are at a contested hearing, the commission or the division is charged with evaluating several factors to determine which operator wins in these competing pooling applications. These factors are a comparison of geologic evidence presented by each party as it relates to the proposed well location and the potential of each proposed project to efficiently recover the oil and gas reserves underlying the property. There's a comparison of the risk associated with the parties' respective proposal for the exploration and development of the property. There's a review of the negotiations between the competing parties prior to the applications to pool to determine if there was a good faith effort or good faith negotiations. That is like the least important of the factors, but people really want to get into it back and forth about who made this offer and that, and that can get a little messy. There's a comparison of the ability of each party to prudently operate the property and thereby prevent waste. A comparison in the difference of the well cost estimates and operational costs. There's an evaluation of the mineral interest ownership held by each party. And that's at the time the application was heard. So that is oftentimes, people are trying to get people to join on to their unit before the hearing, and the ownership interest can wildly deviate between the time you file the application and the time you actually go to hearing. And the mineral interest ownership is largely seen as the most important factor. And then finally, there's a comparison of the ability of the applicants to timely locate well sites and to operate on the surface. There's a lot of division and commission decisions that analyze these factors and kind of define what do we mean when we compare geological evidence? What do we mean ability to prudently operate and prevent waste? And some important, to hit the highlights of this, because I'm just seeing I only have 15 minutes and I feel like I could just talk forever about the exciting topic of compulsory pooling in New Mexico. But basically, the division has said that, and this is, if you want to pull this order, let me give it to you. I'll talk slowly. This is probably the most important one that you should have in your filings. It's order number R-22205. And then there's another one, order number R-21800. And these orders say that in the absence of any other compelling factors, working interest control should be the controlling factor in awarding operations. And the commission has defined working interest control as not simply working interest ownership, but also interests that support a particular operator or interest under a JOA or joint operating agreement. So that's why leading up to these hearings, there can be a lot of activity getting, interest owners to sign your JOA. And the division has also reiterated in these orders that its first task is to determine which development plan will most efficiently develop the subject acreage, prevent waste, and protect correlative rights. And if there are no significant differences between the development plans, the division must look to other factors, and in particular, working interest control. So in terms of the, the other factors, comparison of geologic evidence, that's basically, let's say you have two competing applications covering the same acreage and targeting the same formation, right? Like you're both going to try and drill Bone Spring wells in the same 320 acres. And one company is proposing wells from north to south, while the other is proposing wells from south to north. Well, then you're going to have to put on evidence and show why geologically it's better to drill from north to south than south to north. So that's, how that factor comes into play. Ability to prudently operate and prevent waste. A good example of that one is, a company proposing 3-mile laterals versus 2-mile laterals. And they are always going to want to go with, even if someone proposes 3-mile laterals, if the other party's 2-mile, if you can show that 2-mile can get the same, results with the least amount of drilling, then you can win on that one. Also, if you have similar development plans, if you can show that your development plan, which might have fewer wells or different spacing between the wells, if you can show that those, will lead to a better result, and you have, analogous results from nearby spacing units to prove that, then that's how you win that factor. Working interest control, if it is really close in interest, like, 37 and 42 or whatever, that is not really going to make a big difference. The division has said something like a gap between the parties in working interest control of around 7 to 12% is not a very significant difference, but a clear difference and a meaningful difference is something like 62 and 37% working interest. So that will kind of push things more in your favor if you have 62 versus 37 or 74 versus 24. But it needs to be really over like 15% difference in working interest control to make a big difference with the working interest ownership. And then costs, basically you just have to have someone that can go through all of your cost estimates, show why they are, believable, what they should be in real life. And there's very rarely do we see huge fights about costs because most are pretty well aligned. And then the surface factor, or that ability to locate timely locate well sites and operate on the surface. That really comes into play when you're an operator that has nearby surface facilities or gathering lines or takeaway already set up in that or nearby the proposed spacing unit. If you can show that you have, extensive surface facilities, and then the competing operator does not have similar facilities, that can help push things in your favor as well. And here is where we see a lot of, the much bigger or more long-standing operators in New Mexico winning that factor simply because they have existing facilities and they're spacing, they are controlling acreage all around each other. So that makes things a little bit easier for them. That is really the basics. I'm happy to take questions or talk more in depth about anything that you guys might want.
Thank you so much. You might not be able to hear it, but let's all give her a hand.
All right. Our last speaker for today is Mike Bassett, unapologetically passionate and transparent. Mike has never stopped believing in the power of his team, truth, and doing the next good thing. He is a civil litigation attorney who has practiced law for nearly 4 decades. In 2002, Mike founded the Bassett Firm, a Dallas-based boutique law firm specializing in defending catastrophic injury cases. Mike has tried nearly 200 cases to verdict and is a highly sought-after national speaker, consultant, and mediator. Mike is also the co-host and co-creator of the podcasts Legal Grounds, Conservations on Life, Leadership, and Law, whose guests have included everyone from archbishops to military leaders and New York Times best-selling authors. In his time as an attorney, Mike has embraced the hard path of grace and believes in second chances as much as he believes in honesty to his clients. Mike is also the author of The Man in the Ditch, a redemption for today, story for today. Please help me in welcoming Mike.
Is this me? Thank you. All right. Can you hear me back there? Show of hands, law students, practicing attorneys, about half and half. Okay. You know, they usually say they save the best for last. I'm an officer of the court. I'm not going to lie to you. I'm the last. But I'm the only thing that stands between you and the end of the program. And if you're a lawyer, I'm the thing that gets you the hour worth of credit. Before I start, I want to thank Professor Keffer and everybody here at the university, and the folks from the law reviews have been very, very kind. They emailed me every day asking me if I needed a ride or wanted to go to dinner. So I really appreciate that. Thank you all very, very much. Every time I come to a seminar and I listen, I realize how many smart lawyers there are in this state. I mean, just some really, really smart people. I'm not one of them, and I'm going to tell you a story today. I'm not going to show you any graphs. I'm not going to talk about surface rights. I'm not going to talk about anything that has to do with oil and gas law. But I am going to talk about something important: ethics. Stand over here. Maybe I'll try this one. How about this? Got it. Thank you. But I am going to talk with you about something that I think is very important, especially for you law students. It can take you years and years and years to build a reputation, and it can be lost in an instant. And I want you to remember that. Because if you think the internet is fast, lawyer gossip is faster. And here's how it will go. You will get a case with a lawyer you've never heard of before, and they've never heard of you. And they will email their friends and they'll text their friends and say, what do you know about this new lawyer, Mary Smith? And you'll be amazed at what people will tell other people. So hopefully with my talk today, what people will say is, that is a lawyer of integrity, and that is somebody that you can trust. What no one ever thinks to tell you is how loud an FBI windbreaker can be. You see, in the movies, a team of clean-cut agents will walk into the room, ask people to step away from their desk, move away from their computers, as a series of whispers sort of goes through the room, and the inevitable, hey, as people wonder what is going on and everybody looks around in shock. Dramatic music usually starts something with a lot of strings that amps up as the pressure builds. Now, in real life, the agents do come into the room and they do fan out. They do ask people to step away from their desks, bankers' boxes at the ready, with a practice efficiency while they gather evidence. But what the movies get wrong is the murmurs of confusion. Because you see, when most people are confronted with a badge, let alone an FBI badge, their default reaction is shock. And once the agents begin to gather what they've come for, a sort of silence, rooted very much in fear, settles over the room. And that's when I would first begin to notice it. The unmistakable sound of polyester on polyester. Instead of some dramatic music score, the music to my downfall would be a symphony of windbreakers, stuck somewhere between an endless loop of the swish of a basketball net and nails on a chalkboard. It is January of 2002. the director of claims for one of my law firm's largest clients has just been found out to have been embezzling money to the tune of over $1 million. For the sake of our story today, we're going to call this guy Sam. And his scheme was really simple because usually the best ones are. You see, what Sam would do is he would hire you young lawyers and you would do work for him. And then he would send you checks drawn on the bank accounts of the trucking companies you represented, except they would not be for real cases. The cases would be made up. And then you would take those checks and you would run them through your firm trust account. And then you would keep 25% of the money and you would send Sam back 75% of the money. Or he would send the checks to you and you would cash them and give him the money. I know because I was one of those lawyers. Sam's scheme was simple. Like any skilled con man, here's what Sam knew. The best way to circumvent the system and to beat the system was to get people inside the system to play along. Many of the lawyers that he sent these checks to ran them through their firm's trust accounts and sent him back money. For years, I thought Sam held the keys to the kingdom, but what I would come to learn was that he only really knew how to pick the locks. Today, I'm going to be really transparent with you, and I don't want you to think for a minute that I'm asking for forgiveness or excuses or making excuses for the things that I did, because I own the mistakes that I made. The title of this speech always has been and will be The Man in the Ditch. But unlike the traveler and the Good Samaritan, I dug the ditch that I was in. I read somewhere on the internet, so I know it's true. The average adult makes about 35,000 conscious decisions a day. So, taking into account sleep, doing the math, that's about 200 problems we solve every hour, 2,000 decisions we make every hour. Which dog is going to get the extra treat? Which coffee mug am I going to use? Which socks am I going to wear today? Now, unless you're foolish enough to use your partner's favorite coffee mug or wear their favorite fuzzy socks, your decisions really are not going to affect those around you. But for us practicing lawyers and you soon to be lawyers, you are entering a profession where all of your decisions have tremendous consequences, not only for you, but for your clients. At its core, whether you are an oil and gas attorney, whether you are fighting over water rights, whether you are fighting over mineral rights, whether you're like me and you defend companies in catastrophic injury cases, at its core, what we as lawyers do is have clients come to us and we help them navigate problems they cannot. And we get the privilege of doing that. We get the privilege of doing that for one reason. The clients that come to us trust the integrity and the honesty of the legal system. Today, I am going to share with you what a fall from grace looks like and feels like in real time. And more importantly, I'm going to let you in on the flawed lines of logic that got me into that dumpster fire in the first place, in hopes that you can recognize them long before you start rationalizing a way to cheapen this shared institution called the practice of law. Before you fall victim to the kind of isolation that will justify self-preservation and self-interest above the needs of any larger community which you belong. So that you can begin to see the world through a lens of forgiveness long before you're stuck memorizing a Federal Bureau of Prisons inmate number. And hopefully before you learn just how loud an FBI windbreaker can be. I'm going to take you back, way back, although I thought this was way back until I heard one of the speakers talk about 1910. So I'm only going to take you back to 1994. I've been in practice 7 years. I get hired by a big insurance company to represent a trucking company. And that's the first time I meet Sam and work with him. It's a small case. But on the defense side of the bar, when you do a small case well, you usually get bigger cases. And I like the work that I was doing for Sam. He was one of those clients that was very hands-on. And so every time there was a major deposition or mediation, Sam wanted to be there in person, which means that I got to know him a great deal because he and I spent a lot of time together. I got to know Sam's family. He got to know my young family. He broke bread at my house in Waxahachie, Texas. He sent tickets to sporting events to my wife and I so we could take our 2 young sons. And perhaps most cruelly of all, as a fellow Catholic, he always insisted that we go to Mass together. Sam had gone from being a client to being a friend. In 1996, myself and another lawyer left the firm we were at and started our own firm, and Sam's business followed, and it was a bunch of it. I used to joke that I wanted to set out my own shingle, but because of Sam's business, I got the whole damn roof. Sam was one of those clients that you will dream about as a lawyer and that we lawyers dream about. He knew the trucking industry front and back. He was just as comfortable talking to a truck driver at a Whataburger in the middle of nowhere, Texas, as he was shaking hands with an executive in the C-suite. If a case needed to be defended vigorously and money needed to be spent, he let me do it. And best of all, he paid his bills early. So Sam and I had become so close that in January of 2001, I walked into my office and there was this huge cardboard box. It was really big. And inside it was Green Bay Packers football memorabilia, signed game day footballs, signed team jerseys, signed team prints, stuff he knew my young sons would love, and they did. So I picked up the phone and I called Sam and said, "Man, thank you so much. This is really kind." He said, "Man, I'm happy to do it." Then he kind of was talking to me like someone walks in the room, he kind of whispers and goes, did you get what I sent you? I said, "No." So I start going through the box and I start going through the wrapping paper and the trash. I think I missed something. And then he whispers, "There's an envelope in there for you." So now I've got to get everything out of the box. And sure enough, at the bottom of the box, wedged in between the flap and the side, is an envelope. Holy smokes, I think. My boy Sam has come through. Super Bowl tickets. It was the last positive thought that I would have for many, many years. Instead of Super Bowl tickets, guess what that envelope contained? 3 checks totaling $10,165. Checks for motor carriers whose names I knew that we represented. But I didn't recognize any of the case names. So I told Sam, there's a mistake, man. Here's the deal. These checks are made payable to me. No one makes checks made payable to me. I never see checks. Second, I don't know any of these cases. I know all the cases we have for you. And these are none of your cases. He said real casually, No, Mike, that was my intent. I'm sending you these checks. Here's what I want you to do. I want you to take those checks and run them through your firm's trust account. You can keep $2,500, send me the rest. I said, "We're not doing that, Sam." It's okay. All right. If you don't want to do that, the checks are made payable to you, right? I'm like, "Yes." He goes, "Then you cash the checks and give me the money." And I thought, no, Sam, we're not doing that either. And this is the moments that the rationalizations began. I thought to myself, there's no way Sam is doing this just because he's got to be in a bad bind if he is stooping to something like this. So I'm sort of confused and I'm really worried. I thought, well, you know what? We're close enough. I said, Sam, do you need me to lend you $10,165? I mean, that's how close I thought we were. And then his voice changed. And because it's mixed company, I will not tell you what he said, but here's the G-rated version, the shorter version. He said, here's what you're going to do. You're going to take those checks and you're going to cash them and you're going to give me the money. And if you don't, I will pull every bit of business I have from your law firm and everybody that I've ever referred to and everybody I know in the trucking industry. I will tell them that you have lost your edge and that you are no longer a competent attorney. Doing the quick math, his business was worth about $500,000 a year to our fledgling little firm. Suddenly now, it's not a friendship on the line. It's my job on the line. It's the jobs of everybody that I work with on the line. It's my identity as a lawyer. So at this point, I'm at a crossroads in my career and in my life. What do I do? Do I do what's right? Do I tell Sam, you can go to hell, hang up the phone, and pick up his boss and say, by the way, your director of claims is shaking people down? Or do I cash the checks, give him the money, and keep my mouth shut? At this point, the rationalizations have kicked into overdrive. I will spare you the stream of consciousness. But, a la David Letterman, top 4 reasons for cashing the checks, here they were. Rationalization number 4. I had an entire office full of people that were counting on me to bring in business. I had a family to feed. This is what I needed to do. Rationalization number 3. I had heard of lawyers doing stuff shadier than this, and they were still practicing, so this couldn't be that bad. Rationalization number 2, we could make it look like some sort of accounting error. And my number 1 rationalization, I wasn't keeping any of the money, so surely that made me one of the good guys. Now, I told you that this logic was flawed, but that is what was going through my mind as I stood there in my office. If mental gymnastics were an Olympic event, I would have nailed the landing, gotten a gold medal, and gotten 10 out of 10. So I cashed the checks. I gave him the money. From that point on, my life and my career would never be the same. Sam and I never spoke about that transaction again. He continued to send me business. I continued to try cases for him, and he continued to refer folks to our firm to hire us. As the months went by, with a mixture of naivety and hubris, I thought maybe this whole thing would blow over and nothing would ever come about. Now, hopefully, none of you that are going to be lawyers or the practicing lawyers in this room will never, ever be confronted with such a blatantly illegal proposition again. But I can guarantee you this, every one of you will be confronted with a situation where you will be able to rationalize doing the wrong thing. Not because you're bad, not because you're flawed, but because you're overwhelmed and you're scared. In my panic, I told myself I was already guilty by association. Everybody in the trucking industry knew how close Sam and I were. I mean, we were really good buddies. But that fear of being ostracized had a darker, more insidious side, and here's how my logic went. Are you ready? Sam was somebody that everybody knew in the transportation industry. And if somebody as reputable as Sam was doing this, was I going to stake my career as being some sort of goody two-shoes lawyer who could not do the hard things when push came to shove? Again, I'm not saying that the logic made sense, but that was going through my mind. I had known since I was a since I was a sophomore at Coronado High School in El Paso, Texas, that I had wanted to be a lawyer since the 10th grade. After I got out of law school, I was a briefing attorney at the Texas Supreme Court.
I tried cases against and with some of the best lawyers in the state of Texas. For the first 13 years of my career, I idolized being a lawyer. I was the first lawyer in my family. I idolized being a lawyer, and I idolized the law. And by the time I hung up that phone with Sam, I had made a mockery of every single bit of it. A lot of you in this room may have noticed that our profession as of late may not be everybody's first choice to the prom. And while you may have varying degrees as to the legitimacy of the public's frustration with lawyers in the legal system, I am going to submit to you that that does not excuse any of us from practicing within inside the bounds of the law, and it gives none of us a free pass to denigrate the judicial branch. In the year after my phone call with Sam, every time I spoke with clients who were nervous, I would tell them things like, listen, trust the process. The law will get there eventually. And I would have a pit in my stomach, not because what I was saying was a lie, but because I was afraid if what I was telling them was really, really true. If this was imposter syndrome, I was over here, and here's why. You see, I was telling my clients and giving them advice to do things that I was too cowardly to do. On top of the fact that the only reason I was having to have these conversations with my clients was because I was pushing back against the stereotype and the narrative of lawyers and the legal profession that read like a checklist of my sins. You ready? Greedy? Check. Self-centered? Check. Disingenuous? Check. I learned the hard way, friends, that not only is justice blind, but she is patient. And she only suffers fools for so long. There was not a lot of traffic when I left my office that Wednesday on the way from Dallas to Waxahachie to tell my wife I had ruined our lives. The drive still took me about 45 minutes, and what little spiritual faith I had at that time is really the only thing that kept me from driving my pickup truck into a bridge abutment at 75 miles an hour. Even after 23 years, some conversations are still too raw and painful to share, and that conversation with my wife in my house that day is one of them. Suffice it to say, it was not my best day. Now, my wife, who's not a lawyer, had the wherewithal to say, you need to hire a lawyer. So I called Martin Lenore, a criminal defense lawyer that I'd referred folks to for years in Dallas. He said, come up and see me. So we drove back into Dallas that day, and I remember sitting in Martin's office in these blue upholstered chairs, telling him, I am beaten, I am broken, I am done, it's self-inflicted, I am never practicing law again. He never interrupted me, but he never agreed with me. Before we were about to leave, he slid a card across the table and said, this is a card for Dr. Martin Einsbrook. He's a psychiatrist. You need to go see him. So my wife and I, still shell-shocked, drove over to see Dr. Einsbrook that day, and he would end up treating me for at least another 2 years for the crippling anxiety and depression that would follow. On the way out, Martin said, listen, by the way, you're going to need to hire another lawyer for the state bar grievances we all know are about to happen. So I hired Jim Burnham, went up there to see him the next day. In the course of less than 48 hours, less than 2 trips around the sun, you with me? I walked away from a law firm that I had helped found. I met with and hired 2 incredibly smart and incredibly expensive lawyers. And I was taking prescription medication for anxiety and depression. That was not my plan for 2002 on New Year's Day. That weekend, now it's Saturday, I sat on the couch and I told my wife again I was never going to practice law. What's the point, I said. The state bar is going to punch my ticket What's the point? I said, I'm going to federal prison. And she let me have my pity party. And this conversation I can share with you. She let me have my party, and then she looked at me and said, here's the deal. You were meant to practice law, and that is what you were going to do, is practice law. There was no hesitation in her voice. There was no question in her eyes. There was no doubt in her tone. Within 2 days, she had put together a business plan and a budget. And then we met with our banker, Jeff Frazier, and through the first miracle, capital M of miracles, I got a line of credit. Now all I needed were clients and a place to practice. To the surprise of absolutely no one, nearly every one of my clients dropped me like a bad habit. But 2 clients stuck with me. 2 clients had faith in me. So now I've got a line of credit and I got clients. I just need, a place to practice. This is pre-COVID. Remote work? What the hell are you talking about, remote work? You need an office. A lawyer by the name of Jim Stanton reaches out to me and says, we need to talk. Remember what I told you about lawyer gossip? Oh, yes. The news of my fall went around fast. I'd known Jim for years, but sort of like if you're a third year, you've known someone since your first year of law school, they may have been in one of your sections, you may have been in a class with them, but you really didn't know them that well. That was Jim. He and I had been on the same side of cases. So he says, let's meet. So on a cold January morning in January of 2002, he and I met at the Starbucks on Mockingbird and Central. I got there early. I was sitting outside at one of those green metal tables. Jim walks in pulls up, gets out the door, car closes the door, looks at me and goes, God, you look like shit. We hadn't even had coffee. But over the course of the coffee, we visited, and I don't remember a lot about what we visited about, but I do remember this. Jim said, listen, if you want to, you can use my law firm as a place to get your feet on the ground. So the next week, the movers from my old firm brought over all my files and all my furniture. And sitting around Jim's conference table were me and 3 other people from my old law firm. The old law firm that I had left like 11 days before. One of them was Stacy Cassidy, a 1-year associate who decided to join me in the wilderness, who would stay with me for the next 13 years. To say that those 4 people around that conference room saved my life is not hyperbole. That community saved my life. Yet, even as I sat around this conference table with visible, tangible signs of proof that these people believed in me, I still had thoughts running through my head. Here was the tape that was running through my head. Do you people not understand I am radioactive? Do you people not understand I'm probably going to federal prison? Do you people not understand I don't deserve a bit of your generosity? It's not until years later I would learn about the psychological concept of projecting. And that's why young Mike couldn't understand while these people were around me. You see, my drive for self-preservation, the thing that got me into this mess in the first place, meant that I didn't understand or did not trust the concept of community. Probably a little bit of both, if I'm being honest with you. If you do this job long enough, and when you are licensed, long enough will be about 48 hours, you are going to piss somebody off, you're going to let somebody down, and you're going to make a mistake. You with me? First 48 hours. When you do so, please do not isolate yourself. Do not turn inward on yourself. In this profession, which is adversarial by nature, it is so easy to succumb to this mindset that it all rests on your shoulders. That is a lie Do not buy into it. Here's something else that I don't know if anybody will ever tell you in law school. That self-isolation you pull is both a breeding ground for piss-poor decisions and a catalyst for shame. Because in turning inward on yourself and not opening up to your community, that is not going to make you a better lawyer. That's not going to make you a better partner. That's not going to make you a better parent. And it is not going to make you a better member of the community in which you live and in which you move. Again, I hope your time in the ditch is never, ever, ever as severe as mine was. But at some point in your career, an opportunity is going to present itself where a lie will give you the illusion of control and maybe give you the way you think you can keep your place in your community. I had 5 close friends I could have called the minute I opened up that envelope and saw those checks. And you know what? I didn't trust enough to call any of them. Is it scary? Is it scary to go to a boss and say, I missed a deadline as a young lawyer? Yeah, it is. Is it scary to have to call a client and say, remember that motion we filed that I told you I thought was going to be the silver bullet? Guess what? It was a blank. Those are not comfortable conversations to have. But as somebody who's had their own law firm for 23 years, I can tell you this. 99.9% of the problems that you run into as a lawyer can be fixed, solved, handled by remembering 3 phrases, and they're all 3 words. And I would encourage you to write them down. The first one, I screwed up. The second one, and this is so freeing, I don't know. I don't know. And the third one, and the most important, I need help. I need help. Because no one may know you are drowning because you put on this great facade. And if nobody knows, nobody can help you. The reason I believe most of the lawyers in this room do what we do is because we have been blessed with the ability to have tools to help folks solve problems when they come to us. And I bet the reason a lot of you are going to law school is you want to help people in some way. And that is noble. But remember this, my friends, whether you're a practicing lawyer or a law student, you are going to run into a problem for which you have no tools in your toolbox. And that's okay. So when, in your practice, you think about, should I do this or not? Is it right or not? Stop. Hit stop. Turn to somebody you trust. Connect with your community. So the criminal charges are still looming in the distance, as are the grievances. 2 of them, count them, 2 filed by Sam's employer and my old law firm. I think the best way to describe those months is like getting up every morning and putting on a really heavy wool coat that is sopping wet and 2 sizes too small that sort of binds your every movement. One minute I would convince myself this is all going to work out. This is going to be fine. The next minute my heart would be pounding in my chest and I thought I'm going to federal prison for the rest of my life. I worked a ton because work was therapy and it stopped me from ruminating. At this point, my family's forgiven me. The people I work with have forgiven me. The clients that are with me have forgiven me. But what the criminal justice system and the state bar had in mind, well, that remained to be seen. So every single time my phone rang during those months, my heart would stop. Just like when you're blowing through a school zone doing 95 miles an hour and there's a DPS trooper sitting on the side of the road. That's what my heart did every single time my phone rang. When the fear and anxiety got too much, I self-medicated with alcohol on top of the prescription medication I was taking. I'm not proud of it, but it's the truth. That August, I reached a plea deal with the federal government. The courtroom, as I remember, was probably 9 times bigger than this room. The judge's bench maybe was up there where that stop share button is. That's the way it seemed to me. I remember they're standing there in front of the judge, and he asked me, "Have you repaid the money to Sam's employer?" I said, "Yes, Your Honor, I have." He said, "Do you have anything to say for yourself?" My lawyers told me he was going to ask this question, and like any good lawyer, I had rehearsed my answer 100 times. I stood there and I told him, and I don't remember a word I said. What I do remember, though, is the feeling of pure and utter shame standing there in front of a federal judge while my wife, family, and friends sat behind me in the gallery. The judge told me that he'd read the letters of support that my family, friends, and colleagues had written. And then he shuffled the papers on the bench. Remember that he's that high. And it seems like he shuffles them for 3 months. It's probably 3 seconds. And then he leans over and looks at me, and I can remember this like it was yesterday. I can remember what he said with the tone of compassion and sternness. He said, "Mr. Bassett, you have made a grave mistake, and you will pay for it. But do not let that mistake define you or your future." I'm going to tell you that is advice that I struggled with for at least 20 years. Then came the state bar grievance hearing. Again, I don't remember a lot about it. The room seemed to be about from here to those chairs to me. The air conditioning wasn't working, and everybody was just pissed off that was in the room. There was no parish priest behind me. There was no letter from my friends and family, and there was no doubt at this state bar grievance hearing that I had broken the law. The only question on the table was I going to report to the Federal Bureau of Prisons halfway house for my 90-day sentence in January of 2003? Was I going to report as a lawyer or as an ex-lawyer? That really was the decision. Late 2002, Jim Burnham called me and said, "Mike, the grievance committee has reached its decision." As a law student, I think the best way to describe that is, you know that feeling you get when someone says the grades have been posted? Multiply that by 1,000. If you're a trial lawyer, it is that feeling when you're walking the hallway and you hear, bailiff comes out and says, "We have a verdict." That's what my stomach did. Jim told me, "Mike, they gave you a public reprimand. You're going to get to keep your law license." I thought, okay, maybe this nightmare is about to be over. Aside from the overnight permission slips and the travel permits required by the halfway house, on paper, I thought my time in the ditch was done. But I'm going to tell you, folks, I struggled for years with the damage that my decisions made to the people around me. Some seasons were like a blossoming. Man, everything I touched turned to gold. Some seasons were like a crucible where everything I touched turned to whatever. But more often than not, here's what's interesting. More often than not, the path towards forgiveness for me was not made more difficult by hostility. It was made more difficult by accountability. And here's something else I'm going to submit to each one of you, both law students and lawyers. I think that this is the way we should be practicing law. Because without accountability, the law either becomes lip service to the public or vengeance in disguise. Without that accountability for ourselves and for others. Before my really bad decisions in early 2001, I used to think that if you worked hard and took care of your business, you could inoculate yourself from life punches to the face. So when old me, Mike 1.0, would read about the lawyer that got the DWI, got disbarred, or was being sued, I would silently think, well, if they'd have taken care of their business, that wouldn't have happened to us. That's their fault. You know, frankly, that's really a mean and little lens through which to view the world, especially if you're a lawyer and you're trained in nuances. It took me being the man in the ditch to learn something, and that is that everybody in this room, no matter how much money you got in the bank, no matter where you went to school, no matter the car you drive, no matter where you work, is one left turn from being in the ditch. And here's why. You know why? Because of the inescapable human capacity to make really stupid decisions. So now when I read about the lawyer that is going to federal prison, now when I read about the lawyer who is being sued, now when I hear the gossip about the lawyer who's going through a horrible divorce, my thought is, man, I've been there. That could just as easily be me tomorrow. I have tried to replace judgment with forgiveness. And I think it's really a lighter way to live. This is Edmund Burke. He is an Irish philosopher. And I love this quote from him. Justice is not what a lawyer tells me I may do. It's what humanity and reason tell me I ought to do. I am not going to impress you and lead you to believe I know a lot about Edmund Burke or Irish philosophers in general. But what I do love is Burke's acknowledgement that we have to balance the letter of the law with the spirit of the law. And I'm going to encourage you and I'm going to implore you that when you become lawyers, or if you're lawyers in your practice, that we need to operate with both reason and humanity, that the two cannot be mutually exclusive, because if they were, I would not be standing here. Hey, Edmund, go away. All right. That is my cell phone number. And no, it really is my cell phone number. It's not a burner. If, God forbid, you ever find yourself in a situation like I did, maybe not so bad, hell, maybe worse, call me. I'll talk to you. And if you don't want to talk to me, please talk to somebody in your community. Please do not turn inward. That is my Federal Bureau of Prisons inmate number. It will follow me for the rest of my life. It does not define me, but it will be with me forever. I am giving you that top number so you have someone to call that will not judge you. I'm giving you the top number so that you do not end up with the bottom number. When soon-to-be lawyers in your practice, and when practicing lawyers, you run across somebody that is in the ditch, my hope is that you will not pass by them, but stop and help them out, because it could just as easily be you. My hope is that you will hear about my story and hear about my struggles and hear about what I went through and think, you know what? Maybe tomorrow, maybe Monday, I can be a better, more effective law student and lawyer. And who knows? Maybe even a better version of yourself. My name is Mike Bassett. I'm a trial lawyer from Dallas, Texas. Thank you for letting me share my story with you. This is still hot.
Okay, that concludes our symposium. So I just want to thank you all again for coming today and supporting the Texas Tech Law Review and the Journal of the Energy Law Practitioner. It really means a lot to us. Here is your Texas CLA course number and QR code. We also have some sheets printed out outside that has this information on it that you can grab on your way out. If y'all need any certificates for New Mexico, please feel free to reach out to myself or Marcus. Our emails are right here as well. And yeah, thank you all again for coming.